Well, good morning, everyone, and thank you for joining us. It's pretty early here in California, but I'm very excited to see all of you. The University of the Pacific Law Review, in conjunction with the Capital Center for Law and Policy and the Mcgeorge School of Law Public Policy programs are all proud to present California Dreaming, Regulating the Gig Economy. Today's symposium explores one of the most exciting and fast-moving areas of law in our world today, the rise of the platform economy, which has disrupted the traditional arrangement between the worker and service agent by offering an alternative to stable employment as an independent contractor. But at what cost and to whom? We're thrilled to spend the day exploring this timely and important topic, and we are clearly not alone in that excitement as we have over 200 registrants for today's symposium. And we are also excited to be sharing the exciting scholarship from our esteemed presenters today in the first issue of our next volume of the University of the Pacific Law Review. But before we get started, I would like to thank some of the people behind the scenes who made today's virtual symposium possible. First of all, I'd like to thank Professor Moots for spearheading and curating this wonderful group of scholars and practitioners to share their knowledge and experience with us today. I also need to thank the amazing Cassandra Fernandez for her amazing work organizing today's event, and Ashley Gollage for helping us get the word out there. I would also like to thank Aaron Muhlenberg, Director of the Capital Center for Law and Policy, and my fellow members of the Board of Directors for the University of the Pacific Law Review. And of course, I also want to thank all of you for taking time out of your busy day to be with us today. And with that, it's my pleasure to introduce to you the Dean of the Mcgeorge School of Law, Michael Schwartz.
Good morning, everybody. I'm Michael Hunter Schwartz. I'm the Dean of Mcgeorge. We would like to acknowledge that we work on indigenous land. We'd like to acknowledge and pay our respects to the Nishinon Indian tribe and all the American Indian and indigenous peoples and communities who have been or have become a part of these lands and territories in California, and more specifically here in California. On behalf of my faculty colleagues and the rest of the Mcgeorge community, it is my great honor to host today's symposium on regulating the gig economy. I think I will start by chiming in on thanking Cassandra Fernandez and Ashley Gollage and certainly Jay Moots, who's not only a faculty colleague, but is like a model of what it's like to be a wonderful former dean who engages deeply in the work of the faculty. And so he's both a role model for me and a really great colleague. And I'm so grateful to all the work he did in putting together this incredible, high quality, great depth of speakers today. And we're so lucky that we get to have this quality of speakers for this symposium. I also want to sort of make it a point to highlight that this is also sponsored, in addition to being sponsored by our Law Review, by our Capital Center and our public policy programs. Mcgeorge is very proud to be the home of the third ranked in the nation government law program. Incredibly innovative, and certainly kudos to Professor Muhlenberg for her leadership of that center, and one of only 2 law schools in the country to have a public policy and public administration program integrated in the law school. And so thanks also to my faculty colleague and the chair of our public policy, public administration program, Jeffrey Michael. Mcgeorge is in a great place to be dealing with these kinds of issues. We are in the state capital of the 6th largest economy in the world. And so what a better place to take on these kinds of issues than Mcgeorge. And so I just wanted to thank all of you for being here. We are really excited about our speakers and today's experience, and we're incredibly excited about the upcoming law review issue. And I hope you have as good experience as I think all of us are anticipating, and wish you a great day.
Thank you, Dean Schwartz, for all your support of everything we do here at Mcgeorge, and Matt, who on behalf of the Law Review has organized this. I'm going to get us rolling. I thought first I would describe briefly how we're going to conduct the symposium today. We've got a great array of speakers with a wealth of knowledge. They will each talk for about 25 to 30 minutes, and then we will have 10 to 15 minutes for discussion. This is designed for a broad audience, so some of you may know most of what some of our speakers are going to talk about, but we don't think anyone knows everything that all of our speakers are going to talk about. So we want to try to be inclusive with the audience and provide a setting for some of the more detailed discussions. So everyone from law students to government workers to lawyers practicing in this area are in our audience of more than 200 registrants. As a result, unfortunately, we can't have a live give and take, but if you use the Q&A boxes, we're going to make sure that your comments and questions get filtered to the speaker, and then the speaker will be able to respond. I'm sure you all suffer from Zoom fatigue, like all of us. We have built in a number of short breaks and one lunch break, and we intend to strictly follow so that everyone can get up, stretch, walk around, and come back refreshed for the next speaker. And I would like to emphasize that this will be memorialized in the issue of the University of the Pacific Law Review, as Matt mentioned. And we hope to get that out relatively quickly because, of course, things change quickly in this area. I would like to start by thanking my fellow panelists who have agreed to participate today. It's a very dynamic area of law. It's hard to pin down. But everything is rooted in the so-called development of the gig economy. And that was driven by the implications of someone being an employee rather than an independent contractor. So just to set the baseline, we're going to start with a short video from Susan Provenzano that just explains what the importance is in distinguishing an employee from an independent contractor. Susan Provenzano is professor of practice at the Northwestern Pritzker School of Law. She practiced in the areas of employment law and anti-discrimination law, and now she teaches those courses at Northwestern. She had a conflict today, but she agreed to permit us to play a short video that she has prepared for her students in employment law regarding employee classification. So we're going to start today's proceedings with this short video to set the stage. And Chris, you can go ahead and roll that video.
This unit is about the two legal classifications that apply to workers, employee and independent contractor. As you'll see, these classifications are not straightforward, but they involve high legal stakes. To understand worker classification and why it's important, we'll first explore the incentives that firms and workers have for preferring one status over the other. These incentives often conflict, and each side has a lot riding on getting it right. Let's talk first about firms' incentives for classifying workers. Employees are awfully expensive. They need benefits, space, equipment, regular pay, all of which come with significant costs. Why on earth would any firm, large or small, want to shell out for that? One word sums it up: control. Think about it. If you own an online grocery delivery service, you may want your customer service workers to be employees. That way you can maintain total quality control over their interactions. You can also reap the efficiency benefits of the training you've invested in them, given the greater continuity of employment relationships. Your motives for classifying software programmers as employees may be different. You want them to be loyal and not compete against you while employed, and you want to own the essence of your online presence. So, to maintain a competitive edge and protect your intellectual property, you may also want the programmers to be employees. For your best performers in any job, you're more likely to recruit and retain talent if you employ rather than contract. And having a workforce of mostly employees can improve morale. A very different rationale applies to your delivery service workers. Depending on customer demand, some may make only a few deliveries per day. You wouldn't want the salary, benefits, and overhead expenses of employing them full-time. And you definitely wouldn't want to be held liable if they injure another driver on the way home from a delivery. So, some or all of your delivery workers may be independent contractors. In general, independent contractors come with fewer legal responsibilities, and they offer firms greater flexibility in staffing, since their work is often project-based or time-limited. Now let's think about it from the worker's viewpoint. Many of you have worked as both employees and independent contractors. In some settings, you may have preferred an employment relationship with a steady salary and benefits. If you were seeking continuity, employment probably appealed to you too. Even at-will relationships are costly and risky for employers to terminate given the scope of employees' legal rights. Unlike independent contractors, employees are protected by federal and state labor and employment laws. Finally, you may have preferred employee status to avoid spending on equipment and overhead and the hassles of contractor tax compliance. In other situations, you may have wanted to work as a contractor to maintain control over your work and the intellectual property you generate. Being a contractor might have afforded you the freedom and flexibility to work as you saw fit, generating multiple sources of income without having to commit to a single firm. As an independent contractor, you might also have had more negotiating leverage with the ability to command higher rates and reap profits. Let's end with the stakes. You should know that legal regulators have the final say on a worker's legal status. But the law is not always easy to predict. Different regulators use different tests for different situations, and getting the prediction wrong can have dire consequences. For one, both firms and workers must answer to the IRS for tax liability. If a worker is wrongly classified as an independent contractor, but looks more like an employee, the firm that issued 1099s instead of withholding taxes will face fines and back taxes. The worker who went along with it will be penalized too. Misclassifying workers under wage and hour laws is a big problem too. The Fair Labor Standards Act, FLSA, requires employers to pay minimum wage and overtime. A firm that wrongly calls its workers independent contractors and fails to observe these requirements will not only owe these wages, but will also pay penalties, especially if the firm was trying to dodge those obligations. Misclassification can also result in unexpected discrimination liability. Good businesses work actively to promote diversity and inclusion and to prevent discrimination across the workforce. But firms that are less vigilant, believing their workers to be contractors, will find themselves on the wrong end of an anti-discrimination action. Employees, but not independent contractors, are also protected from retaliation against unionizing activity by the National Labor Relations Act, NLRA, and they are entitled to receive the firm's employee benefits. So misclassification can mean liability for unfair labor practices and having to pay back benefits as well. Liability to third parties for worker-caused injuries is another big risk. Finally, misclassification can thwart firm and worker expectations about loyalty and intellectual property rights. Generally, employees must sign over intellectual property rights and refrain from competition. Independent contractors do not. On the flip side, the risks for firms are often incentives for workers. So just as firms must classify with caution and foresight, workers must plan and be savvy from the outset about what they want from their relationship and how it is likely to be viewed by regulators. As we move into the legal tests for worker classification, keep these important points in mind. 1. Worker classification carries legal uncertainty and risk. 2. The risks span many areas of the law. And 3. Given the stakes involved, foresight and planning are essential for both firms and workers.
Well, that was to get us started. That's the basics on worker classification. And I'd like to take a minute to thank Chris Gimroth, who is the master of all things technical here at Mcgeorge, for loading that up and getting us off to a good start. Because Professor Provenzano couldn't be here, there's no Q&A opportunity. And again, that set the background. So I will be the first speaker and will get us kicked off this morning. I'm Jay Moots. I formerly served as Dean at the Mcgeorge School of Law for 5 years. before joining the faculty as professor of law. I teach employment law and have co-edited an employment law casebook called Learning Employment Law. My law review articles in the employment law area have focused on the emergence and development of employment practices liability insurance and the special employment issues that arise surrounding the use of legal cannabis in California and other states. The topic of my talk is the legal backdrop for what we are discussing today, and that is, of course, the gig economy. I will bring up my slideshow. And is that being shared? I am screen sharing, so we are ready to go. My role is to provide a quick overview of the complex legal history of classifying gig workers in California. The legal fight is ongoing, but this presentation is designed to bring everyone up to date to provide a basis for the later presentations. There is no resolution as of this moment, and the battle continues in the courts as we speak. Today's symposium is oriented mostly towards moving forward, but of course you have to know how we've gotten to where we are. So today I'm going to talk about 6 topics. First, the labor market disruption that's occurring and is leading to some of these issues arising. The traditional common law multi-factor test of who is an employee and who is an independent contractor. The Dynamex case, which introduced the so-called ABC test in making a determination of who is an employee. Then the legislative initiatives of AB 5 and later AB 2257. Finally, Proposition 22. And now the current status is the constitutional challenges that are now pending against both Proposition 22 and AB 5. So this is the outline of what I'll be talking about, and I'll begin with the labor market disruption. Labor economies around the world are being disrupted by a disaggregated mode of production that's organized through numerous short-term contracts rather than stable employment relationships. The emerging model includes the so-called platform economy, in which a company creates an app to connect those seeking services with workers willing to provide those services. The relationship between the worker and the person paying for the service is fleeting and potentially a singular event. The relationship between the worker and the platform is arguably just to facilitate these singular gigs. Thus, an Uber driver will accept connections through the Uber app for an individual driving gig without becoming an employee of either Uber or the person who is using the ride service. For now, we're going to focus on the transitions and issues related to these platforms. First, in the Communist Manifesto, Marx talks about capitalism being like the sorcerer's apprentice. It is so efficient that it can spin out of control of those who seek to corral it and keep it developing according to their plans. It pays, I think, to begin by thinking how today's issues are rapidly going to change. Robotics and artificial intelligence are going to present new challenges very soon. Driverless vehicles will soon be delivering food and transporting customers around. But for now, we're going to focus on the transitions and issues related to platforms. Workers seek flexibility and freedom. This is the mantra of those talking about the innovations of the platform technology. Purely anecdotally, my experience has been that rideshare companies initially involve drivers who love this flexibility and freedom. And they viewed the income as a bonus, an extra, something that they could choose to pick up if they had the opportunity. Usually in addition to a, quote, real job, or perhaps graduate studies, something along those lines. Indeed, some people from the Sacramento area would drive down to San Francisco on the weekend in order to drive for ride-sharing companies, sometimes sleeping in their cars while there, and being able to pick up quite a bit of money. We're also experiencing the Great Resignation, which I think is related to the flexibility and freedom argument about workers. After COVID, workers became very accustomed to off-site work. Think about Professor Provenzano's presentation, where one of the benefits of having workers be your employee is control. Well, of course, that was teased out a little bit in the COVID situation because there was no longer direct physical control in the sense of workers. As Tizadal Nile, a professor at Harvard Business School, says, we have changed, work has changed, the way we think about time and space has changed. So just pause for a moment, those of you who are lawyers, and ask yourselves, what would happen if we had Uber law? And of course, we have steps along that way. Imagine a legal practice organized solely through complex networks rather than law firms. In a professional setting, this might be considered intriguing, or some might consider it horrifying. The point is, as we quickly change, these platform economies themselves are going to be surpassed by other forms of organization, and the regulators will need to keep up with these developments. Let me just checking the chat room. So what is the problem? I think those who would say in this disruptive moment, it's not just about increasing sophistication of our capitalist system, matching needs with suppliers, but instead is having vulnerable workers provide the source of an increasing concentration of wealth among the few. Workers are ever more vulnerable as politicians carve away the social safety net, and the ability to secure the benefits of traditional employment fade away. Again, just anecdotally, my father worked for one company for his entire career, had a defined benefit pension, right? We all know this is becoming almost impossible to achieve in the modern economy. A 2014 study by the Harvard Business School concluded that the growing disparity of wealth between the very wealthy and the lower and middle classes is simply not sustainable. But it is still increasing. In 2019, the top 10% of households held 70% of the country's wealth, and the bottom 50% of households held 2%. Now, this is wealth, not income, but it's important. So I bring this up because the labor market disruption, it seems to me, extends far beyond just platforms and how they operate. This is just one symptom of a much broader issue that regulators need to address, and that is the ability for workers to be somewhat secure in the jobs they have, and also somewhat secure in the ability to accumulate some measure of wealth on their own right. Well, that was all very general and background material. I'd like now to talk about the legal issues particular to the platform economy, but to keep in mind these broader questions that lurk somewhat in the background. So where does our story start? As Professor Provenzano indicated, it starts with the notion of control being the key factor in determining whether someone is an employee. The California case, Borrello, emphasized that the so-called control test is a situation where the key factor is control, but it really is a multi-factor test. This is borrowed from the law of agency, which really is no longer realistic. We don't have a situation where someone is pinned to an employer for life under the master-servant rules. So think about the emergence of at-will employment, which we just take for granted as a background fact. That was a development in response to the industrialization of the economy. Employment used to be for a year because of the agricultural cycles. At-will developed as the means to address the need for employers and employees to be more flexible in an industrialized economy. The same thing, I think, has happened with the multi-factor control test. It just isn't appropriate to many of the work arrangements that are now developed by platform companies. Think about the other factors besides just control. What skill is required? Who provides the tools that are used? Is the duration ongoing or is it isolated? Is the work part of the hiring entity's regular business? Is the worker able to outsource the work to someone else? How do they file the tax documents related to this relationship? All of these factors are weighed in what becomes difficult to predict. As Professor Provenzano indicated, there's a risk in some situations if you're trying to achieve an independent contractor status, that a court might balance these factors in a way that tips the scale towards employee status. There is an exception, a very prominent exception that is important for the California situation, and that is the Fair Labor Standards Act does not use the multi-factor control test, but rather uses the economic realities test. Now, there's some doctrinal reasons why the Fair Labor Standards Act was treated differently in federal law, but the economic realities test really has provided an alternative test that gives inspiration to other approaches. These other approaches include, for example, an entrepreneurial test, whether the person who is working has the opportunity for gain or loss. The economic realities test is probably a more accurate approach in the modern economy. So think of a Seventh Circuit case, a famous case, Lauritsen, where migrant workers were harvesting cucumbers. Were they controlled in the exercise of their work? No. All they were told was, please go out into the fields and harvest these cucumbers. However, the economic reality of this situation was these workers depend on the defendant's land, crops, agricultural expertise, equipment, marketing skills. So in the area of fair labor standards, the economic reality was they really should be deemed to be protected by the law and considered employees. The famous Grubhub case, which is still proceeding, dealt with a company who pretty effectively lawyered out of the employee designation. How did they do this? Grubhub set up its platform in a manner that required virtually nothing from their drivers. They exercised no control, really. The driver could take runs or not. The driver could be on call or not. As a matter of fact, many people who were proved to be Grubhub drivers never drove a single job. This was established to make sure that they would not be considered employees. As the court summarized, Grubhub could not make any of their drivers work or count on them to work. So it would seem strange to consider this to be a situation where they were employees of a firm for whom they never did any work at all. This would never trigger employment status under the Borrello control test, right? There simply is not control. The relationship is totally in the discretion of the driver. But the freedom and flexibility issues are real. And drivers might say, I don't want any of the obligations and benefits of employment because I can, through this completely free approach to association, make money when and if I want to, and I'm under no obligation to do so. This was the setting when the Supreme Court intervened and developed a new test for determining employee status. And that's the infamous Dynamex case, where the Supreme Court of California introduced the ABC test for litigation under wage orders in California. So this is analogous to an economic realities test under the Fair Labor Standards Act, where we're going to interpret the language of the statute more broadly when it regards hours and overtime, minimum wage and overtime. The ABC test was borrowed from unemployment compensation cases in other jurisdictions. Social policy requires that something like unemployment compensation be read very broadly. We're trying to protect people from the ultimate economic shock, and that is losing their source of income. So for a remedial statute like an unemployment compensation scheme, the courts want to ensure that everyone is included to the extent possible. So Dynamex applied the ABC test from these other settings to wage orders under California law. What did this mean? The ABC test presumes that the worker is an employee unless three factors are met. So we've completely flipped the situation. Rather than saying you are an employee only if I exercise control under a multi-factor test, the ABC test says you are an employee unless these three factors are true, in which case then you are no longer an employee. This is a more liberal test than the economic realities test. The public interest in workers receiving benefits and in having the hiring entity bear the full cost of the workers is certainly paramount. The first element that one would have to prove to eliminate the employee status is that the worker is free from control over the work. This is both by means of contract and in fact. So in other words, the hiring entity can't simply say on a piece of paper, you are free from our control. It has to in fact be the case that the worker is free from control by the hiring entity. Again, the Grubhub case is an exemplar. It really sought to relinquish any form of control over the drivers in order to satisfy the multi-factor test under Borrello. Well, this is just now the first element that you have to prove is you are an employee unless you're free from control. The old test is now just one of three that are to be considered. You also must work outside the usual course of the hiring entity's business. Or to phrase it affirmatively, you're going to be regarded as an employee if your work is within the usual course of business. This raises the question, what is a platform company's business? What is Uber's business? Is it connecting people who are interested in a transaction? Or is it, more importantly, providing a service to their customers? The determination is pretty clearly by the courts that the usual course of business is going to be tough to prevail upon. Drivers perform services for Uber in the usual course of Uber's business, according to People versus Uber in 2020. So although the platform companies such as Uber were arguing that we just match people, that's our business, the courts tended to view the ride provisions to customers as the actual course of business for Uber. Now, I will pause and say this was much easier under the Dynamex case itself. In that case, Dynamex had employees driving trucks and making deliveries. They then wanted to shed those obligations and create independent contractors. So these same workers doing the same job suddenly were deemed independent contractors who were making deliveries. That obviously doesn't look too good. Uber is a different situation because from the beginning, like Grubhub, they attempted to structure themselves as merely being a platform and not being engaged in a particular business of providing those transportation services to customers. Finally, the third test, you have to customarily be engaged in an independent business. So again, we're presuming employee, but if you can show that the worker is free from control, is doing work outside the usual course of your business, and is customarily engaged in an independent business, then that person will be deemed to be an independent contractor, but otherwise the presumption holds. So what do we mean by customarily engaged in an independent business? Well, we may have a driver who's driving for Uber and Lyft and Grubhub and DoorDash, and we would say that's their independent business. They just choose sometimes to use the Uber platform. Think about an easy example in the application of the ABC test in a way that would have worked under the control test as well. You own a factory and the toilet backs up in one of the bathrooms. You call a plumbing company and someone comes out and fixes the problem. Clearly, you're not controlling their work. You're hiring them to accomplish a task. They're using their best efforts to do so. Under the control test, they would not be an employee. This is work that's outside the usual course of business for the factory, right? Maintaining operating restrooms is important, but it's not really their usual course of business. And finally, the plumbing company is engaged in an independent business. They are providing these services to a number of people on terms that they set. So that would be an easy example where we presume that they are an employee, but in fact, because they're free from control over the work, that work is outside the course of business of the hiring entity, and they are engaged in an independent business, they would not be deemed to be an employee. And that would be the same result under the control test. AB 5, what happens with AB 5? AB 5 was enacted by the Assembly on September 18th, 2019, just as the session closed. And the bill was signed by Governor Newsom to be effective on January 1st, 2020. Essentially, the ABC test is applied under AB 5 to the unemployment compensation scheme and all the employee benefits under the labor code. Without exemptions, this would have transformed hundreds of different business models that have nothing to do with the new platform economy. Thus, over 100 occupations were exempted in AB 5. And it was quite a last minute shuffle. I was teaching employment law in the evening that September, and a few of my students had to be on the floor for the close of session. And my employment law class was getting live updates as to who's being exempted, who's not. It must have been quite a thrilling ride for those in the assembly. So what's an example of an occupation that was exempted from AB 5? Cosmetologist. Cosmetologists were exempted, but most of the exemptions had very specific requirements. So the cosmetologist had to set his or her own rates, be paid directly, process their own payments, set their own hours, sole discretion over who they accept as clients, own their own book of business, issue 1099 to the business owner for use of the space. In other words, it really was a control test question. You are exempted if you really do not have any control over the, if the hiring entity has no control over your business model. So AB 5 was a bit like the Affordable Care Act in that it was put together in a way that was going to lead the occupations who are not exempted to be a bit upset. So there was a storm of protest after this enactment. First, platform companies alleged that this was an attack on their business model and would potentially destroy them. Okay, I'm sure you enjoyed being serenaded by my dogs, but I tried to put them out. So let me continue. The storm of protest is, this is going to destroy platform businesses because under the ABC test, if it's read that their business is providing ride services, for instance, that's the core of their business and all their drivers will be employees. And in fact, there was a suggestion that perhaps that was the whole purpose of AB 5, is to coerce these platform companies into having employees. But there are other established occupations that felt like they got caught in a crossfire. For example, freelance writers. They said, it just doesn't work for us to be employees of publications. The whole nature of freelance writing is it's built on gigs. Ironically, gig musicians were also threatened, where they might be employees, let's say, of a music festival, if there are musicians playing. So there was complexity as these other occupations tried to sort out the effect of AB 5. Initial efforts to stay the law were unsuccessful. What do we do? And that is what a good legislature should always do. There was AB 2257 was enacted on September 4th, 2020, and was effective immediately in order to correct the situation created by AB 5 by exempting millions more employees. That's where things stood until, as I say, the Empire strikes back with Proposition 22. AB 22.5 was not going to exempt the platform companies. The legislature was not going to include that as an exemption. And so the platforms dealing with app-based drivers promoted a proposition to negate AB 5. The name of the proposition was to protect the app-based drivers and services act. The name makes clear that only a subset of gig workers are covered by Prop 22. The strategy was to sweeten the pot with some benefits, a healthcare subsidy, minimum earnings, accident insurance, and so forth. but to overturn AB 5, creating an employment relationship. We have the democratic mythology that the people of California rose up and overturned an oppressive law, but of course the political reality is a bit different. This was obviously a calculated effort to try to secure relief from AB 5 by certain companies. The platform companies spent about $205 million in support of Proposition 22, while the labor groups spent only $19 million. The result was not surprising. It was a resounding victory by driving platforms. President Trump was on the ballot, so turnout was high, about 80%, and the proposition was enacted 59% in favor, 41% against. What does Prop 22 do? It reinstates a control style test rather than the ABC test, but only for these network companies, the app-based driver companies. So for instance, the network can't mandate dates, times, hours, require that you take any specific riders, can't restrict working for others in your off time. What's missing though are things like setting the pricing for the services. So what we have now between AB 2257 and Prop 22 is fragmented law addressing the fissured workplace. So just as the workplace is now fissured through these attenuated non-employment relationships, the law itself is fractured between treating parties differently. The CEO of Thumbtack said a few companies writing their own law is a bad look, and it forestalls a comprehensive solution that takes everyone, including workers, into account. And the challenge for us today is to figure out, is there such a possibility of a unified comprehensive solution that takes all interest into account? The last dance is constitutional challenges. After AB 5 was enacted, it was challenged for being unconstitutional. First, several cases involve First Amendment challenges that AB 5 infringed on their First Amendment rights. Those cases were pretty readily dealt with quickly. Presently, there is a lawsuit arguing that there's an irrational targeting of driver apps. Uber and Postmates is now Uber Eats, and several drivers alleged that there was an irrational animus against the app driver platforms that constituted a violation of equal protection of the laws. The plaintiff's motion for a preliminary injunction was denied, and the defendant's motion to dismiss was granted, and both are currently on appeal before the Ninth Circuit. The plaintiffs claim that the irrationality of AB 5 was compounded by the irrationality of AB 2257 to exempt millions of workers who were similarly situated to app drivers. As they argue in their opening brief, quote, AB 2257 magnified the irrational line drawing in AB 5, nullifying the ABC test for millions more workers by creating new classes of exemptions and broadening the categories of exemptions contained in AB 5. The complaint details how these exempted service providers' work is factually identical in all relevant respects to the work performed by app-based drivers, including that, quote, the service providers who use TaskRabbit and WAG have the same patterns of use as the drivers and couriers who use Uber and Postmates. In fact, WAG's business model is so similar, it is often referred to as Uber for dogs. The suit also alleges unconstitutional impairment of the right to contract and an unconstitutional bill of attainder by imposing punishment without due process, but these seem rather weak claims. It will be interesting to see if the rational basis challenge will work. Prop 22 is democratic action, but it still must comply with the Constitution. Opponents immediately challenged the law on a number of grounds. First, that it attempted to insulate itself from legislative overrule. More important, that it interfered with the plenary authority to establish a workers' compensation system. Because Prop 22 may be amended only by legislative action that is sustained by the voters, the legislature is impaired in being able to directly establish and maintain a workers' compensation system, and that plenary authority is granted by the Constitution. The bar on collective bargaining was also deemed to be outside the stated purpose of the proposition. As the trial court concluded in finding that Prop 22 was unconstitutional, quote, a prohibition on legislation authorizing collective bargaining by app-based drivers does not promote the right to work as an independent contractor, nor does it protect work flexibility, nor does it provide minimum workplace safety and pay standards for those workers. It appears only to protect the economic interests of the network companies in having a divided, ununionized workforce, which is not a stated goal of the legislation. I don't hear anyone warming up to sing, so I think it's fair to say this saga will continue for some time. Those who control the gig economy and the new labor platforms insist that this is a new era of freedom for workers to sell their labor to multiple purchasers, rather than being constrained through an exclusive employment relationship. Indeed, many workers celebrate their freedom of choice. Of course, this choice is often between working a number of gigs or finding a fully satisfactory job in the traditional employment economy. When that traditional economy stalls and unemployment rises, at least some gig workers discover that their freedom to choose has quickly become a necessary strategy to survive. They then find themselves working outside the protections of employment law, including minimum wage and basic benefits, in a struggle to make ends meet. I have described the California experience of seeking to regulate this freedom in a manner that preserves the dignity of workers without erasing the benefits of freedom altogether. Regulatory balancing is a vitally important goal. We cannot simply assume that the free market will properly align the interest of workers, hiring entities, and society. As Janis Joplin hauntingly reminds us, all too often, freedom is just another word for nothing left to lose. And with that, I will conclude and check my time. And we have a little bit of time. Matt, do we have
We do have a few questions that came in. First of all, sort of like, foundationally, kind of taking a step back, could you maybe define and distinguish gig economy, platform economy?
Yeah, I would think gig is much broader. The platform economy would be defined in my terms as someone who provides a service for people to connect. A gig, I mean, the phrase gig comes from, I think of a musician. If you get a gig to play in a bar, there's no platform, there's no matching of anyone. You just are doing a one-shot gig and are presumably not an employee. The platform economy is really a sophisticated version of, finding workers waiting outside a Home Depot or something, right? There's a meeting place location, just this is handled technologically. And the question is that meeting, do the people who establish that meeting space, are they the employers of the workers who find hiring entities through that meeting space? So I would think that the the gig economy would extend beyond establishing platforms. And it's interesting and important to note that Prop 22 was really about app-based drivers. There are all sorts of other platforms that are not included in that, including the so-called Uber for Dogs website.
Right, makes sense. We have a question from one of our staff writers in Law Review. She says that the issue with the current employment classifications is that it does not account for when an employee is clocked in at multiple employers, and gig economy drivers are often online with multiple apps at the same time. So should each ride-sharing company pay them individually for that time, meaning the driver makes two separate individual wages? Perhaps there can be some sort of legislation that allows these rideshare companies to pay its pro rata share of wages and pay its pro rata share of taxes.
Yeah, that hits the exact issue that's at stake in the legal classification. If you are riding around and searching for work through various platforms as a driver, it's hard to conclude that you're an employee of any one of them at that particular point. How do we address this? Now, oftentimes the platforms will not want you multiply listed when you're available for their riders, but I think we know that probably is not always followed. So what I would say is that is a really difficult issue if you want to pin someone with employment obligations. If you've got a driver like in Grubhub who has no obligation to even be available for your customers, right? They switch on or off. So these are some of the complications of who do we call the employer and how do we treat it? And dividing the obligations, as the person suggested, is a completely new innovation to try to think through how to deal with this new form.
Thank you, Erica, for that question. And we also have another question here. Do you have any thoughts you care to share about the effects about broadening the effect of the ABC test, first through Dynamex and then through the subsequent legislation, and the concept of dual employment, sort of similar. As an example, the employment status of security service providers or cleaning service providers to the recipient of those services?
Yeah, joint employment is one way we could think of this, but that generally is the case where the employer, the putative employer, has hired an independent contractor business, but the workers for the independent contractor are also controlled or subject to. So that still remains an issue, and that's an important part of employment law, regardless of the platform economy. But the platform economy lawyers are very smart. I mean, the Grubhub lawyers designed it perfectly under the control test, and it will be interesting to see how it pans out under that. Litigation is still ongoing. How it pans out under the ABC test, because the all critical issue is, how do you define the platform in that respect? What is their usual course of business? That's the question that has to be resolved. And I just want to emphasize the last litigation I raised, that's all constitutional challenges to the laws. It doesn't solve anything, right? We're just saying this particular approach is unconstitutional. So what I'm anxious to hear from our presenters today is what's in the offing for the future? How do we deal with all these difficult issues?
And I want to quickly get a couple more questions in before we break. We had a question about, I believe you said workers are spending less time working for employers. Could you speak a little bit more about that and how we know that?
Well, I think my colleague Jeff Michael will pick up that.
Great.
That he's a labor economist, and we're going to talk about it's difficult to find good data on this, but my colleague Jeff Michael is an expert economist and labor economist, and I think he's going to try to characterize exactly what's going on in the real world with this.
And with all those exemptions that you were talking about, how do you think those either relate to or may have been informed by other exemptions in employment definitions previously?
Well, I'll give, and then we probably should give people their break.
Right.
But I mentioned that I was teaching employment law while this was going on. And I later heard from one of my students who said, hairdressers and cosmetologists have these exemptions. What about an esthetologist or esthetician? And I'm not sure if the member knew what an esthetician was, but okay, that's, it was kind of a shuffle. So 2257 really tried to step back and say, okay, let's really try to think about the classification. And my own opinion is probably the app-based driver platform economies became the prototype of what we wanted to call an employment relationship. And then the question was, is that like this or is this different? Right, would be sort of one way to think about it. And that's why the constitutional challenge is interesting, because they're arguing those lines were irrationally drawn. There's no rational basis to uphold that line.
Excellent. Well, thank you very much for that, Professor Moots. And yeah, like you said, I think it's time for us to take our break. So yeah, we will come together at the top of the hour.
Yes, thank you.
Thank you. See you all soon.
Okay, why don't we come back from our brief break? We have well over 100 people live with us, and as I said, more than 200 people will be filtering through. So we will try to get to your questions and leave time for your questions. Ms. Gonzalez, are you ready?
Sure am.
Okay, great. Good to see you. I'm going to just go ahead and get started. It's 9 o'clock. We're back from break. We're going to now have the keynote address by former Assemblywoman Lorena Gonzalez. Ms. Gonzalez was elected in May 2013 as a Democratic representative, promising to fight for California's working and middle classes. The Atlantic magazine labeled her the California Democrat setting the national agenda for her practical, progressive legislation aimed at alleviating real issues in people's lives. Ms. Gonzalez led the fight for the adoption of AB 5 and has sponsored a variety of bills that focus on the needs of workers in the modern economy. She recently resigned from the Assembly and will be leading the California Labor Federation beginning in July. We are honored to have Ms. Gonzalez deliver the keynote address.
Thank you. And I'm starting my timer so I don't get too far off so I can open up to questions if necessary. But I want to start by saying I want people to remember I'm not a professor. I am, I guess, by trade an attorney, but I entered the labor movement, then became a legislator and back into the labor movement. So I'm plain spoken and not academic. So when I kind of give what we're going to give is kind of how we got to AB 5 and where we see it going from here, it's a little bit more plain spoken than some of my heroes can speak about it. People like Vina Duvall and others who speak on a much higher level than I do about how we got here and where we're going. But as far as, you know, and I think I'm probably preaching to the choir as far as how we got here. Many of us know, you know, the history in the last 100 years of work, quite frankly. But I want to frame it in a way, or how I saw it and why I thought that AB 5 was so important. So for me, it's about unequal work, right? When we think about all the gains that we've made and where that has led us. So of course, the New Deal was transformational as far as work. It provided kind of the safety net of work, what, you know, ensured that people had minimum standards, if you will, especially with the NLRA. More or less. I recognize that's complex as well. But it was this idea that there should be some minimum standards for work. We should have, you know, a minimum wage, of course. We should have Social Security. We should have these safeguards. But even upon its passage, you know, we recognized the Fair Labor Standards Act in particular, that we didn't recognize all workers as equal. We left out, of course, of that workers who were holding jobs that were once slave jobs, quite frankly, workers in the field and workers in our homes, domestic and farm workers. So that was an acceptance at the time because of, you know, people's ideas about race and who did that work. And in a large part, that hasn't changed, right? So as we see workers' rights grow and throughout the 1950s and 60s, kind of a post-war, injecting things like healthcare into work, obviously with Obamacare, standardizing it, ensuring that people had hopefully more and more of a minimum wage, that there was workers' compensation, unemployment insurance, all of these rights tied to work. And then, of course, those things that we've been working on the last few years to really ensure some things that people need, things like paid time off, paid sick leave. So we've been working on that for a while. We've been trying to increase the benefits at work, both through legislative action and through union organizing and collective bargaining. That's been good. And in places like California, we've actually started tearing down the idea of unequal protection, right? We've had since the 1970s the right for farm workers to earn a minimum wage and to organize. We've protected domestic workers, not enough, but we've provided some protections for domestic workers. We now have overtime for farm workers. So at the same time, we've tried to to dispel this idea of workers, employees having these different standards. Now, at the same time that was being done, we see corporations really getting around all these gains in the workplace by labeling people independent contractors. And if we look at who originally, and when I looked at AB5 and thought about AB5 originally, of course, it was timely in the sense of the gig economy. We thought about, the Uber and Lyft right when I got elected in 2013 is kind of when that was taking off. We knew they were misclassifying workers under the Borello standard. This was an issue. But for me, and the ruling really in Dynamex was so much broader than the gig economy, because we had known misclassification was happening in a variety of work as a way to get by and not have to pay overtime and not have to pay a living wage and not have to pay, provide health care and the benefits, workers' compensation in particular, the benefits that workers needed. And we saw this, especially when I was in organized labor, in industries that, again, were primarily dealing with immigrants, people of color, women of color in particular. So we saw it in the janitorial industry. We saw it in construction. We saw it when we were dealing with nail salon workers. We saw it when you're dealing with workers who didn't have the power to claim misclassification, and the laws were so complex that employers could get by with a lot of it. The Borello test in particular had always been, obviously being a weighted test, it's not a clear line. Perhaps it's misclassification, perhaps it's not. You'd actually have to sue to in some ways to gain your rights. I guess some could be done through EDD, but for the most part, in the labor commissioner, but for the most part, if you didn't have some interaction with the union or you didn't have an attorney, you weren't going to get very far on those claims. So when the Dynamex case, or Dynamics, but we got so used to calling Dynamex, I'll use Dynamex. The Dynamics case happened. We were thrilled. I mean, just as somebody coming, an attorney, somebody coming out of labor in the legislature, I remember reading it and thinking, oh my God, this is incredible. A unanimous Supreme Court decision that says the way I've always characterized it is enough is enough. Like, this doesn't make sense, not only for workers, but for the employers as well. There's not certainty with Borello. It's unclear. It's just being skirted by so many folks that, at least for wage and hour, we're going to look at it this way. Now, knowing the Supreme Court justices and the way that they've ruled, we looked at that and thought, okay, so we're going to have to litigate this piece by piece by piece, right? We think that they'll end up using the ABC test, which was the foundation for AB5 in workers' comp. We think that they'll use it in UI. We think that they'll use it in all these other protections, but that's not what this case was about. This was a wage and hour case. And so we wanted it to be expanded to the entire universe of the labor code. And of course, businesses lost, and excuse me again for my language, but lost their shit, right? They're like, wait, there's all of these situations where this shouldn't apply. And if this applied to us, it wouldn't make sense. And some of them were valid. If you actually read the reasoning in Dynamex, we understood what the justices were getting at, right? They were talking about the power of individual workers, the power of individual workers to assert their own rights and ensuring that they were able to have some kind of negotiating power. So we read through Dynamex, we read through the labor code, we read through, countless wage orders, and we said, how do we use this moment in time for AB5 where employers wanted certainty and they wanted some relief on things that the Supreme Court wasn't talking about, and ensure that it was really broadly put into code and could be enforced. So, we started with the kind of concept of what is the barrier to entry in a job? And that's what's talked about in Dynamex. What is the barrier to entry in becoming a doctor, for example, or a lawyer, right? You've got education, you've got state certification, you've got a higher income that's given to you. You have a limited pool of people who can do that job, all things that they talked about in Dynamex, and all things that had been previously looked at in our wage orders. And so we started picking away and saying, these are the things we're not really worried about, you know. Now we had to be careful because of course there were interests, and I'll take doctors as an example. Of course, in healthcare, it could spread far beyond doctors with that thing. And there were interests that represented employees, and we didn't want to give permission, if you will, for every entity to just simply, if they fit those classifications, right? A high educational standard, a high standard as far as a state license, a limited number of people going to the field. We didn't want to create an exemption that was so large that it really prevented kind of the gains that have been made in certain workplaces. As the daughter of a nurse, I saw firsthand growing up with my mom, who over 40 years in a career went from a pink collar working class career to a true upper middle class job. And that was done because, of course, the power of the union and bargaining and the role nurses play. And so we were able to transform an industry that could be set back if we just simply applied kind of the standard. And so we were really careful in exemptions. I know a lot of people have suggested we somehow gave away to the highest bidder, but that was absolutely not true. And we said no to a lot of things, and we put things in that nobody talked to us about. So we really tried to work through that in order to hit the sweet spot. We didn't hit the sweet spot, I'll be honest. And we knew that when the time had come. It was interesting because as it went through the assembly, it was still tough. By the time it got to the Senate, we knew that we had the votes to pass this, but that it wasn't perfect. We had been asking, for example, musicians in the music industry and the union to work out something on musicians. It was really complex. And they came to us in about August and said, forget it. We don't even want to be in because what was offered up, we don't like. Everybody told us that. Well, as soon as it passed, I'll tell you, we had a thing coming. So we knew we were going to have to do follow-up legislation to clean some things up. And we did that. But of course, what we saw post AB5 was the gig companies. And let me take it back. There was one other thing that was really important in AB5 that we put in there. And it was a direct result of us meeting with Uber and Lyft and all these groups who wanted an exemption, who, we got nowhere with conversations on because it made no sense. I mean, there was nothing in the Dynamex decision that really would provide us a rationale for giving an exemption to rideshare drivers or to gig workers. In fact, it was just the opposite. And so in those discussions, the very last discussion we had with Uber was with Tony West, quite frankly. And he came into my office and, I've become very, and I apologize for this, but very skeptical of anyone who starts with, I was in the Obama administration, because that became the key word for like a Democrat that was going to screw us. And it's unfortunate, and what a terrible legacy with what's come out of what was a great president, I thought. But it is something we heard time and time again through the gig industry. I came out of the Obama administration. Of course, I'm for civil rights. I'm for labor rights. Well, that just wasn't true. I mean, they did come out of the Obama administration, but the rest wasn't true. So Tony West came into my office and he said, point blank, fine, do what you want. We're going to continue to practice our business model, and people can sue, y'all can sue. We have arbitration, we have, we'll settle. That's what we've been doing, and we'll last another 10 years till we're on to something else. And as a legislator, I was so enraged with this idea of a multi-billion-dollar company coming in and saying, yeah, fine, we're just never going to abide by this law. And so a group of us sat around and talked about how could we get enforcement, because that has always been a problem with misclassification. And so we put into the bill the ability for injunctive relief that could be sought by the Attorney General or big city attorneys or DAs. And that was taken, of course, out of the Consumer Protection Code. And so soon as we put that into the bill, it was like right before it came up for its last vote, then finally the gig companies came on board against the bill, and they threatened, of course, what they ended up doing, and that was an initiative. But we knew that without the enforcement aspect, we were basically just continuing down a line of creating laws for workers that were unenforceable. So of course we battled it out with Prop 22. We didn't really battle it out. It was a battle by the gig companies who overwhelmed with money, and not a lot of opposition to it beyond a little opposition in organized labor. There was complexities there, but not what we normally do in a big fight. And of course, $200 million later, they got an exception. It's now, of course, in the courts. It's been ruled unconstitutional. I think actually that'll help. But what we're seeing now moving forward is exactly what we warned about. If we allow for gig companies, who, by the way, there is no rationale given the type of work being done to exempt them from basic labor protections, then what we're going to see is other companies and other entities trying to also get out from under not just AB5 and Dynamex, but also Borello. And so we just saw earlier this year a petition filed for initiative that would basically be the Uber of healthcare. We've seen this in every industry just about. We're the Uber of stocking shelves. We're the Uber of grocery stores. We keep seeing it coming up. But this was incredibly scary in a sense because of the type of work and the type of union density and the wages that we can demand and should demand in healthcare. And so we're starting to see that was pulled back. We don't know why it was pulled back. It's not being circulated at this time, but we anticipate that these types of things will continue to come forward. But it's a scary prospect because what we've seen is the gig companies start to lay the ground for unequal work. That started with, of course, gig workers, by and far, people of color, immigrants, people who don't have the same sort of agency in order to fight this. However, it's going to continue to spread and can upend all of the work that we've been doing for employees. So at the same time as we're fighting and continue to fight in the state legislature and beyond for paid family leave and extending rights for workers, and coming out of a pandemic where we saw how important those rights were, we're seeing industries say, hey, but it's okay. They want flexibility. We can be independent contractors by right, basically, that we could be independent contractors codified in law, and there's nothing that can be done against it. It's one of the failures of California's initiative system, that you can't have real discussion. Now, what does that mean? If that actually happens, and I'm confident that the labor movement is not going to allow that to happen, but what does that mean? Well, it means, and we saw it during the pandemic, a large group of individuals who continue to, who don't have the safety nets baked into the process that we've all agreed to, right? We had all the independent contractors who did not have income during the pandemic and did not have unemployment insurance. So what happens? Well, we saw Uber and Lyft really advocating and lobbying the federal government for the PUA. The PUA is just a taxpayer gift to people who did not pay into a system like UI, where at least employers paid in to these workers. Now, as somebody who believes in safety nets and wants nobody to go hungry or starve, I supported that. But those companies never paid their fair share. And in fact, that was taken from just taxpayer money. And then as we saw the PUA program spread, and this is really important, it's so underreported in California. We heard a lot about unemployment fraud, unemployment insurance fraud, fraud through EDD. What we don't hear is almost, I think it was over 90% of that fraud was through the PUA system. And the reason for that is because it was an individual could claim that they qualified for PUA, which was independent contractor relief, basically small business relief, without any verification from an employer. In the UI system, of course, the employer pays in for an individual worker. There's a built-in response. So all that fraud that we hear about, that was because of the PUA system and the fact that there's no checks and balances, no employer ever paid in, and that's just taxpayer money going straight out to people who self-claim that they deserve it, that they qualify for it. Those are just some of the small things we saw through the pandemic that could really affect if we get rid of the system we currently have. I'm not suggesting that the system we have is perfect. I've always been an advocate for example, single payer healthcare. I think the fact that we depend on our job for healthcare has created a lot of problems. However, those basic protections that we baked into the employee-employer relationship, that safety net that started, well, workers' comp started right before in the early 1900s, but most of which came out of the New Deal in the Franklin Roosevelt days, are really important. They're important because it's a social contract that allows for employers to take care of people who are willing to work, and ensure that they have a safety net when they can't work. So those are kind of how we got there, where I kind of see it going if we don't continue to fight to maintain AB5. And I think that is my 20 minutes. I'd be happy to take additional questions about AB5 or the process or the future.
Thank you very much. And I'll let Matt supervise the questions that are coming in. I'll take the prerogative as chair, if I might, and ask you a question. Is there a solution in your mind to these issues, or is it going to require multiple solutions and multiple differentiations?
There are multiple solutions, if you will. There's the aspect of, and I hate to say this, there's a requirement that we play defense. There's a requirement that we defend where we've gotten so far. If the fact that we could even pass AB5 was a gift given to us in my perspective, from the California State Supreme Court. It was a rational decision that took into effect the history of what was happening and how hard it was for workers and employers to determine who was an employee and independent contractor. We are going to get a fight. Employers don't want, to pay benefits. It's in their interest, of course, to undermine, especially employment that is set as it's not seen as long-term. If you look at the filings of Uber and Lyft and rideshare, Uber in particular, it wasn't seen as we're going to do rideshare forever, right? It was a means to an end. So they don't care if they run through workers and really, they're disposable in their business model, quite frankly. And so that's really dangerous. So we have to continue to fight. But we also need federal labor law reform. And so I've been heartened by things that have come out of the Biden administration. I've never seen, in my lifetime at least, such a quick response to things, to overturning things that were done by Trump's NLRB, by establishing some things in the Department of Labor that are helpful. I don't want to give up hope that we'll get the PRO Act, but maybe we can get pieces of it still. That is still important, because when we look at the extent by which we can make change in California, in a pro-union, pro-worker state like California, it's still limited by what the federal government can and should be doing. And I like what we've seen so far. I think that we have to demand more.
Thank you. One of the questions coming in here in the Q&A box, what possible middle ground would you consider for worker classifications for ride-sharing companies in regards to their drivers that placates the company and protects the worker?
I don't think that as a labor leader, my job is to placate the company. It's to protect the worker. So I don't understand why we would give a middle ground to something that when utilized correctly, when people are treated as employees, when they have that safety net of employee status, when they have the right to organize, when they actually do organize, that benefits not only the worker, it benefits the company and society as a whole. Coming out of the pandemic, we saw, when you look at delivery companies and how well they did, who did the best? UPS. A company with a union. So I reject the idea that I'm looking for middle ground. And quite frankly, I think that's been the problem with Democrats and with worker advocates for too long. It is an acceptance that we're looking for middle ground. Why would we look for middle ground when we've already been pushed so far to the right, so far into a corporate structure that puts corporate interests above workers? There is no need to help create more billionaires in stock owners of Uber and Lyft. There's no need to create more billionaires and venture capitalists. What we need is to create a strong middle class. So I'm not looking for a middle ground. I'm looking for protecting workers, for ensuring that workers have a voice on the job, to ensuring that there isn't unequal work, that we don't look at two workers and say, you deserve these things and you deserve these things. All workers, anyone who works 40, 50, 60 hours a week, and when we're talking about rideshare, we're talking about 60 to 80 hours a week. They deserve the right to a good middle-class life, no matter what type of job they do. Sorry, I'll get worked up if I start talking more on it.
Yeah, I think you need to take a position.
Well, I got to be honest, and I left the legislature, and I can say it now. I think when coming from labor into the legislature, this fact that in particular Democrats I'll be as I don't like to be partisan, but most Republicans are lost when it comes to worker protections. But the Democratic Party, Democratic elected officials who say they're there to protect workers, to protect unions, to push it, have continued to be drugged to the right. They've continued to become neoliberals to ensure that our corporations are adopting the language of corporate America. And so who is left to stand up for workers? Who is left to be the true advocate for workers? In my mind, it's unions. Hopefully it stays that way, and to continue to push. But we cannot, if we start to say, where's that middle ground? The middle ground will continue to shift to the right. And to the right, I mean to be more conservative, more pro-corporate, less pro-worker. And that will increase income inequality. It'll increase all the problems that we're seeing in society, whether it's crime, whether it's homelessness, whether it's failing schools. All of that is tied into the fact that we have increasing income inequality. So I refuse to adopt the language that unfortunately so many of my colleagues in the legislature and in Democratic politics in general have adopted, this middle ground. I'm going to, acquiesce to the corporation and not stand up for workers. It's just not what I'm here for.
I apparently did a bad job in my talk because someone asked about distinguishing AB 5 from AB 2257. And I wonder if you could just recap a little bit. AB 2257 was an effort to sort of plug the holes in AB 5. If you could just describe that dynamic, and do we need a further law at this point for more fine-tuned exemptions?
I haven't seen an exemption that's still necessary, to be honest, and we had a lot of proposals come our way when we did this. So AB 2257 technically replaced AB 5, but what it did is it continued to add clarification to AB 5. For example, I spoke about musicians. I will say that it had to be one of the hardest kind of sweet spots to try to get to, right? Musicians, original gig workers, if you will. So when is a musician truly just, a garage band or somebody that's just doing this for fun, playing at a restaurant once a month? That is not an employee. However, if you're the musician who's playing the piano at the dueling piano bar 3 times a week, just because you're a musician doesn't mean you're not an employee. What about musicians who play in symphonies and orchestras? Musicians who clearly could never pass the Borello test, right? And so trying to come up with getting some, God forbid, middle ground, but some acquisition between or some agreement between the music union, independent musicians, and the industry was really hard. So that's in 2257. It's highly technical. It's for just the music industry. We started looking at like referral agencies and other situations where people really were working as small businesses, right? An individual still can be a small business, and they were using some sort of platform or referral to get that job. So we baked that into 2257, but maintained, and it's tough. People will complain now, this is confusing, it's hard to meet. Well, it should be hard to meet. That's the whole point. All of these tests should be hard to meet, because if you're truly a small business, you have a contractor's license, or you're a small business and have some sort of license, you are paying your taxes, you're established yourself, you have a website, or you're out there, you're not just being used, being told you're a small business, but being controlled by a larger business, then you should be able to operate. But under what are those circumstances? And then we had some I've learned so much about every type of industry, but in the events industry in particular, we had some strange things come in, and I'll give one we've spent far too much time on, or not too much time for them, I'm sure, but I'm a face painter. Let's say I'm a face painter at kids' parties, and I get booked for a large party with 50 kids, and I know I can't face paint all these kids myself, and I want to work with my friend Sheila here, who's also a face painter and has her own business, but the event tracker only wants to do one check. Like, can we have an agreement where two independent contractors are working together and nobody is the boss? Those were the kinds of things we were trying to fix in 2257. I'm hopeful. I haven't seen a specific incident where we should be continue to change. Those proposals keep coming in. I'll say mobile tools was a big one for the last 2 years. So there's companies that the individual does mobile tools. Well, we start working down and working through what's the difference between a franchisee and that's truly operating their own business and somebody who is an employee of a larger corporation, and realize there's a lawsuit going on and they really wanted the exemption to get out of the lawsuit. So a lot of that has happened. There might be things that come up that still need to be clarified, but I think it's a case by case basis. I don't think there's broad changes that need to happen.
Great. Matt?
Okay, another question from the group. Will there be active investigations to find misclassification of employment, or is this complaint-based enforcement? Or is this complaint-based enforcement? This question is coming from somebody who was in the Santa Clara County Labor Standards. And these investigation roles are new and not much investigative and more education. Is there?
Yeah, I mean, we've got that. Luckily, we have a labor commissioner who, I worked with previously on misclassification issues. She's very committed to it. And I think she's actually already done a lot of work on this and continues to do work. We have different unions who are pursuing investigations. In particular, the Carpenters Union has been very good on going out and seeking this, but we'll never catch it all that way, right? There's always got to be more robust investigation, if you will. EDD is set to audit people, and we're starting to see some of those audits, but we all have seen kind of the failures of EDD and the fact that they're understaffed, underappreciated, undertrained to necessarily do this work. I think one of the things that we really have to look at is a more robust funding of the Labor Commissioner's Office and EDD so that there can be investigations, so that there can be audits that allow us to see when misclassification is happening. And there's also an information gap. I can't tell you the number of times workers will reach out to me on Twitter or call my office or on Facebook and say, I think I'm being misclassified. What do I do? Well, here you can go to, the Labor Commissioner's page. Now, is she handling one individual versus kind of the bigger, she's got a scale. And so we've got to figure that piece out as well. And I think that that's a funding issue.
And what do you see as the difference between single-payer healthcare and single-payer disability or retirement? If these issues are taken off the table as considerations for this issue, does it simplify the classification?
Quite frankly, I'm not there on single-payer retirement. I mean, in a lot of ways, we have mobile benefits. This is funny because I hadn't heard this prospect before. I have heard, we should have mobile benefits, and we have that. We have that with Social Security. We have it with Medicare. And the problem is these companies aren't looking to pay into or to help fund these type of benefit, right? So, for example, when Uber and Lyft tried to cut a deal in California and they said, we're going to put money into a fund, they suggested putting 3% of a workers that topped out at 3%. Like, I think Lyft agreed and Uber didn't agree, if I remember correctly, from what I heard from the negotiations, right? So we're going to put 3% into a fund and the worker gets to decide where to put it. Well, 3% doesn't even pay the employer side of Social Security. It doesn't pay the employer side of Medicare or Social Security and Medicare, which would be 7.5%. It doesn't pay for sick days. It doesn't pay for healthcare. It doesn't pay for retirement security in any way. So the reality is those benefits would cost about 30%, if not more, for an employer. And our wages are so low in California to suggest, I'm not sure how this is paid for. And that's what it comes down to. I mean, if we could restructure everything perhaps that would be a way to go. We could become a socialist society, because that's what it sounds like where somebody's asking me. But that's not, we're nowhere near that. We can't even get single parent to healthcare. So the thought that we could get all of these other things paid for right now is just a pipe dream.
And I was particularly interested in when you were talking about exemptions, that there were some that you had to come up with where there was nobody to speak to you about, no experts, no lobbyists. What did you use for rudders, there for your decisions? What were some of the more interesting decisions you had to make?
That's a good question. I'd have to go back and look at all our notes, but I'll tell you, there was always a process we used. We spent a long time and a lot of effort contacting EDD about previous basically audits, like in their findings in the previous 10 years, how many numbers of workers did they find were misclassified? They usually found it from either a workers' comp claim, when a worker found out they didn't have workers' comp, or through unemployment insurance, or through an audit. So we would use their numbers to find out if there was actual misclassification already going on under the Borello. When you saw massive misclassification, we were like, all right, there's a problem here. We continued to just try to apply tests, and usually it would be one person would come to us, and we had a group of people working on this. We'd talk about it. One of my biggest failures, quite frankly, is one that did get in there. And to this day, I was I think one of 2 votes against this exemption in the entire legislature. Even I was forced to carry it the first year, asked people not to vote for it. They did. And that's newspaper deliverers. It is, to me, the biggest atrocity that legislators did, because if you are in any way being intellectually honest, if you look at, first of all, Borello, newspaper carriers, anytime they actually sue, win under Borello for misclassification. I mean, I had yet to see any case that was lost. It was either settled or won by a newspaper carrier. They are employees. They're by and far women of color, actually immigrants, individuals who are in a very exploitive, low-paid profession. There's no barrier to entry. This is an ongoing aspect, and yet we exempted them because the editorials, people couldn't take the heat in the editorials in the newspaper. Every single newspaper editorialized against me. I didn't care. I continued to oppose it. Big shout out to Assemblymember Mark Stone, the only person who's like, this is just not honest. They're not making minimum wage. It's just everything you can imagine. So that was a failure. Every time I looked at that and people said, well, politically, this is what we need to do. Politically, because the newspapers, this is what we need to do. And to this day, I think it's, we sold out a group of workers, and that's too bad. I hope they sue, because they could still win under Borello.
And we have a question from one of our panelists, Professor Poster. Did you get a sense that AB 5 had a good impact for workers while it was in place? If so, how did you see that?
Well, AB 5 is still in place. I think that one of the common misconceptions, it was, I guess 2257 replaced it, but that's AB 5. All the prospects, AB 5 didn't go away. Prop 22 simply reversed or exempted Uber and Lyft and DoorDash, basically TNC and DNCs, out of AB 5. And yes, it does. I am watching, I'll give you a perfect example. There were stagehands at a theater in Vista, which is North San Diego County. I actually grew up watching this theater. Very nice, beautiful productions. And these stagehands were treated as independent contractors from the city, actually, who funded the rec center. They're now employees. They just filed for union recognition with IATSE, and they're being treated like employees. If you know anything about stagehands, it's a dangerous profession, to be quite honest, and it's a skilled profession, and they should have been treated like employees. But now they're not only employees, but they're gonna have a union. They're gonna have a union contract. That's a net positive in my mind. That's a small little group, but even right after it passed, I remember talking to an individual who did IT work, and their company had been hired by UC San Diego. They all were reclassified as employees right after AB 5. In fact, in December, right after it had passed. Well, not only were they classified as employees, but then obviously they got all the rights and benefits as being employees. So he pulled me aside and thanked me. A lot of workers who don't want to speak up against their employer, obviously doesn't like AB5, have contacted us. So I know it's made a big deal, but it can make a bigger deal. It will provide clarity when we find cases of misclassification. We can get an injunction from a city attorney or from a DA or from the AG to stop misclassification. One of the biggest problems previously is it was up to attorneys, right? They do big class action suits, and I love our consumer attorneys, but unfortunately, they would so often settle those suits without demanding a reclassification of those workers, where and so the misclassification continues. That's what happened with Uber and Lyft for years before this bill, and so it continues to happen. But what we allowed for is for it to be able to be stopped, an actual injunction to the practice happening, and I think that's important.
And another follow-up from another one of our professors. Once Prop 22 passed and is tied up in courts, how is it being tied up in courts affecting gig workers now?
Well, technically it's not. I mean, it's they're allowed to continue. They were continuing anyway prior to AB 20 or Prop 22. But it is tied up in the courts in that it was ruled unconstitutional. I have having read the opinion, I think it'll actually stick. I think they made a mistake. They ran an initiative, not a constitutional amendment. They dealt with workers' compensation, which is wholly in the hands of the legislature in our Constitution, and they didn't have severability. So I think they're in a bad spot. I also think that, like everything that these gig companies have done, and I think this is really important, they're making these exceptions because they're running out the clock, right? It used to be that Uber was looking for a time when they could get to driverless vehicles. That's what they'd look for, right? They're expanding, they're constantly changing, they're expanding what they're into. And so for them to continue to allow a legal process to run its course is, I guess, a rational business behavior. But, I'm hopeful that it will be overturned and those workers will be made whole. At the end of the day, one of the big problems, and I'll say this over and over again, in our entire legal structure and in California law, as pro-labor as we are, pro-worker as we are, is workers are seldom made whole. Even if we get things to stop, even if we get things to change, even if we have lawsuits, workers bear the burden of that. And so what I would like to see is even if when it's all said and done, they run a constitutional amendment, fine, go do that. But in that gap time, let those workers be made whole. That's what's, I think, most important and so often lost.
Okay, and our last, go ahead.
We have one more. Go ahead, Matt.
Yeah, just one more. Would you please speak to the impacts of AB 1003 on deterring misclassifications? I believe that's the wage theft law.
So I'm gonna apologize. I had a lot of wage theft bills, and I do remember this was wage theft, putting people in prison for wage theft, maybe? Or was this?
Making the intentional theft of wages, including gratuities, more than $950.
Okay.
Yeah, punishable as grand theft.
Mm-hmm. Yes. So what we're hopeful for is obviously when we were pursuing rights for workers, or we're pursuing the ability to make workers whole. A lot of things were happening that. And we saw DoorDash in particular taking tips from workers and using those tips as their supplemental or as their base pay, which of course we knew if they're an employee would be illegal. And we looked at all the types of wage theft, right? And we said, how do we stop this from happening, not only now, but in the future? And I thought back to my conversation with Tony West, quite frankly, and attorneys in corporations who are willing to tell the CEOs and the higher ups, look, yeah, this might be legally questionable, but nothing's going to happen to you if you do it. And that has been the law. So we said, how do we create a law that will actually be a deterrent to wage theft? So you have an attorney who's going to look at this and say, yeah, but if you get like and I could name a number of city attorneys or DAs in the state who have actually looked at this and worked with me on this in order to go after the stealing of wages. And if you get one of those attorneys and you're operating that business, you could go to jail. I think that that adds a much bigger protection. And we also wanted to codify that tips would count for independent contractors as wage theft. That wasn't clear in code. And there are a lot of people who said, well, people could already go to jail for wage theft. But when we talked to DAs, they said it would be so much easier if this was clear. It'll provide the confidence to go after individuals who knew the law and decided that it was worth it anyway. So I think it'll help. We may never see, because it may just be a deterrent factor. It's rare that you can actually create a crime that does serve a deterrent purpose, but we were talking about really affecting large corporations and corporations who have attorneys who now have the responsibility to tell them, yeah, you can do this, and financially, the worst you'll have to do is pay a little fine at the end, but you may go to jail for it. And I think that changes the game.
Great, thank you very much for your presentation. You served as a great keynote speaker. We are going to go off camera until 9:50, where we'll continue. And trust us, we will resolve all these problems by the end of the day, so we'll be set. Everyone will be back at 9:50. Thank you. Okay, it is 9:50. We are back from our break. The first session was introductory, and we just had the keynote address. This is the start of session 2, which will talk about the economic and policy features of the gig economy. I begin by introducing Professor Jeffrey Michael. He's Director of the Public Policy Programs and a Professor of Public Policy at the Mcgeorge School of Law, the first ABA accredited law school to grant MPP and MPA degrees. He is widely sought after for his economic analyses of major public policy issues impacting California, and is an expert in regional economic development and forecasting. I will turn the floor over to Professor Michael.
Thank you, Jay. Let me share screen here, so I'll be sharing some data. So I think that should be the screen that I'm looking for. So the economics of the gig economy. Let's. It's a little bit intimidating to be sitting in between all these lawyers and Professor Lorena Gonzalez, or not professor, but former Assembly member Lorena Gonzalez. I'm going to be trying to step back and create a little bit bigger picture here. Not going to wade too much into the employment classification issue, but try to set important context for that discussion, as well as talk about some other areas. So first thing I'm going to talk about is data and how you measure the gig economy, how you define the gig economy. You may find this section a little unsatisfying because it's actually quite hard. I can't quite dig into the data the way I might normally when looking at an industry study. Second part, I'm going to dig in a little bit closer to transportation services, because this is where the biggest transformation has occurred. But a little bit different perspective as sort of an economist. Some of what's I see missing from the discussion today here is the consumer perspective and some issues of third-party effects and the real value that's been generated. A lot of discussion about how that value is distributed between employers and workers. But maybe not need some more context on what's actually happened in the economy, which requires a bit of a consumer perspective. And then briefly just mention some other ways to pursue these issues in terms of public policy, some of which have been alluded to already. So economic data. First is a definition of what do we mean by a gig worker. So in economics, the definition has come to mean electronically mediated employment is what we're talking about. So electronically mediated employment are short jobs or tasks that people are finding through websites or mobile apps that connect them directly with consumers and facilitate payment for the task. So that's how the Bureau of Labor Statistics defines it. And that's what electronic mediated employment means. Now, data on that is a little bit hard to find because our traditional ways of collecting economic statistics aren't really set up to differentiate between gig employment and other types of employment. In fact, our economic statistics have always had a bit of a blind spot when it comes to all sorts of 1099 employment. We don't have the kind of data to work with or as timely as we do in a lot of traditional employment. But then within those types of employment arrangements, it can be difficult to distinguish electronically mediated or gig work from other types of 1099 work. We also exclude some small earners, and the data is slow to arrive, and pandemic has even slowed the data down even more. So we only have this data through 2018 right now. Bureau of Labor Statistics is often a go-to for data like this, but we don't really have any data from them since 2017 when they added a contingent worker supplement to their current population survey that they do monthly. Hopefully we'll see more of this in the future. So this had us turning to looking for other sources of data, and the data I'm going to show you today, which I found most interesting, is actually published by Chase Bank. And Chase Bank, their data, they're able to differentiate between electronically mediated payments and non-payments. What they've done at a very high level, so this is, we can't dig into it in a granular way that we could with traditional government data, but they've got the largest consumer bank in the US. So they've got 40 million households that have accounts with Chase Bank. So we have a really large sample. And they've been studying who's making deposits to those accounts, who's receiving deposits from companies that we would call gig companies compared to deposits from other sources of income, whether traditional employers or other sources. And then they've benchmarked their data to this BLS 2017 survey, and it shows that the sample is pretty representative. It is a large sample. It does show similar trends in population doing gig work that we see from other sources, but it's a little bit skewed towards younger workers in Western states where Chase has a bigger market share. But they've got some graphics I think are pretty interesting and important in setting the context. So I'm just going to show a few of those. And as I show these, something to look at in these graphs is to understand they've differentiated what they call the online platform economy into 4 buckets. And the first 2 are work, which is the topic of our discussion here today. And that's been subdivided into transportation work, the Uber and the Lyft, as well as food delivery and other types of delivery services that are electronically mediated, as well as non-transportation work, Rover, Care, Upwork, other sorts of platforms that are engaged in non-transportation work. The data also shows other types of online platform work that is not labor, but is sort of selling things on eBay or Etsy, as well as leasing things that you own, such as Airbnb or Turo as a way for individuals to lease privately owned cars. So, so let's just take a look at what they have. So first of all, this data, initial data looks at the period of 2012 to 2018, where we really see Uber and Lyft taking off and this electronically mediated employment. This shows the share of the households that are engaged in gig work. They're receiving income from gig economies. And so this orange line here shows transportation work. And you see it's near 0 in 2012 and 2013, experiences steady growth to where it's about 1% of populations is receiving transportation related gig work deposits in their account in any given month. So so it grows from about 0 to 1%. That's a pretty significant growth. Somewhere around 2015, they became more common than lawyers, if you need to benchmark that. So it's continued to grow since then. Non-transportation gig work has grown, but has been relatively small and has not exceeded 0.1% of households. So it's really the transportation sector where this has taken off. Other sectors such as selling and leasing have grown, but not seen the kind of explosive growth that we've seen in transportation. so the Chase Bank data shows us when are people getting deposits, how active are they on these platforms? And what they find is that most gig workers, and they have about 120 different companies and platforms they defined as gig workers, so they're analyzing the deposits from, is that most of them are only engaged in this type of work for a few months per year. There's a high level of turnover, which I think has come up in the past. When they're active, it's an important part of their earnings. So in an active month, this can represent about 50% of a household's earnings when they are engaged and really working on the platform. But for the median household that engages in this kind of work, it's about 10% of their annual earnings. So you see amongst the transportation workers is that the majority of them were only engaged for 1 to 3 months, 3 months or less over the previous year, and relatively smaller samples that were engaged all year long on the platforms. Looking at a little bit more recent data that even includes the pandemic, we're looking at growth, continued growth in the transportation sector. So if we sort of fast forward to 2019, we see that we've grown from 1% of households receiving transportation gig employment income in a given month to about 1.4, trending up to about 1.5 when the pandemic hits. And now we've seen it recover back up to about the 1.5% level. Now there's been some shift from transportation of individuals towards delivery type services within that. But in general, the transportation services gig employment is back up to about 1.5%. Interestingly, the non-transport work sector has remained extremely low and less than 0.1%. So we haven't seen sort of gig work or electronically mediated work take off outside of the transportation sector. Still haven't really seen it. Selling and leasing activities on there as well. What are the median earnings? So a median is the 50th percentile. And we see that in recent months, both before and after the pandemic, the median earning for transportation gig workers actually under $500 a month. It's similar to gig workers in non-transport sectors under $500 per month. There is some data that disaggregates a little bit by geography, and we see higher earnings generally in California, the Bay Area, as much as $1,200 a month and $800 a month in LA. Those higher earning potential is part of what's attracted. I think Professor Moose referred to people, driving from Sacramento to be an Uber driver in the Bay Area because of the potential for higher earnings there than they can have here locally. So we see that has been very steady. Just an interesting aside, this would be the leasing activity where the incomes have really increased. That would be primarily driven by Airbnb since the pandemic. So interesting aside, not relevant to us today. And then for most households, the median household that receives gig economy income, it's about 10% of the household income. This is for the transportation sector, it's a little bit higher than that. So this is the annual income, and this is as measured by deposits into their bank accounts. Again, remember this is banking data. So it represents about 12 to 13% of income. It actually somewhat decreased during the pandemic as additional, not only was some gig work decrease for these households, but they received pandemic unemployment assistance and other sorts of income reduced the share a little bit. Non-transport work, they're earning a similar amount, the median per week, but the share of the income is a little bit lower because in the non-transport sector, we see somewhat higher wages. So this last slide from here shows the total income of gig worker households over here in the left and the right hand column. We see that the median for transportation workers is just under $50,000 annually. For non-transportation workers, they're a little bit higher. Comparing it to households in the sample that don't have any online platform income, we see transportation workers are median's about 10% lower than the non-platform workers, but there's actually a big difference at the 75th percentile. So we don't see transportation gig workers as a little bit more compressed and not as skewed to higher income workers. And then we see higher in the non-transport sector, and then it is reasonable that we would see higher incomes in like the leasing sector, where you're actually owning assets and leasing them out. One thing that we see there is a change. I just realized I forgot to set my timer, so someone's gonna have to, if I'm going on too long, just please interrupt me and cut me off.
No worries, Jeff.
All right, great. So jumping into the second part, let's take a closer look at the transportation services. In the previous slide, we saw that gig work has transformed transportation in ways that are quite dramatic, but not necessarily so in other areas. So they deserve a closer look. That's part of the reason that we're looking more at transportation services. And why do transportation services, why was it so impacted? One is that it was ripe for disruption. The taxi industry wasn't really providing good service to consumers. And, you know, I think I'm probably not the only one in the audience that probably took more transportation rides on Uber and Lyft during a single year in 2018 and 2019 than I had taken taxi rides in easily the previous 10 or 20 years. The taxi industry wasn't sort of providing good service for people, and people weren't even thinking about that mode of transformation too much. Another reason is that in this particular industry, they developed a sort of a higher level of electronically mediated employment. So some electronically mediated employment are just sort of fancy classified ads where people are posting their availability and you're connecting with them, and they may facilitate your payment. But in the transportation sector, it's working much faster, and the innovation was really a higher level of electronically mediated employment, where it went to algorithmic assignment, which really was necessary in order to really generate the incredible efficiency which created the value here. In algorithmic assignment, the buyer isn't taking the time to sort of look at all the possible suppliers out there. The buyer wants to get picked up as fast as possible and get to their destination fast as possible, sort of on demand activity. They want to get to their destination. They want to get their lunch immediately and quickly. And so in order for that to happen quickly, an algorithm is employed that connects to the most efficient provider and also involves the pricing mechanism to sort of speed up the transaction. And it fits a special need in transportation that the taxi industry wasn't serving. I'm still amazed that the average Uber wait time is 4.8 minutes. It seems to usually take a little longer than that for me personally, but it's incredibly efficient. But in order to have this algorithmic assignment, for it to work efficiently, right, you're taking some control away from the workers in order to make the quick transaction and the quick ability for things to be on demand. So the workers have less control over pricing, over who they're driving, than other sorts of electronically mediated employment that is acting more like sort of a more sophisticated type of classified ad type of situation. One thing I'm going to note here is that this algorithmic assignment is not just confined to the independent contractor setting. So one of the interesting things we're seeing in business is that this is spreading to traditional W-2 employment, particularly for large employers. So we're seeing large companies like Target putting more and more of their workplace scheduling into this type of system, to drive sort of efficiencies in the response. And so, this issue of on-demand work and algorithmic assignment really goes beyond this issue of worker classification, and why I think it's important to think about it a bit bigger. As an economist, if I'm going to quickly say, look at this market and the basic components, we're interested in supply and demand and third-party impacts. That would be sort of the basic framework we would look at. The first part of supply is most of the symposium discussions around that, and I'm not going to wade into that too much in the interest of time, because I do want to point out some of the important issues here is to look from the, don't forget the consumer perspective, where we actually measure the value that's been generated by these technologies. It's not just sort of a distributional fight between two entities here, is that we really have new value that's been created by this technology. Third-party impacts are a topic that I'll just briefly mention. I'm going to show, to illustrate it, data is sort of can be hard to find, but there's real interesting data in New York City, where we've got the Taxi and License Bureau has put data out there into the public domain, which allows you to look at the penetration of ride-hailing apps in a city that had, arguably the most developed existing taxi service before these sort of ride-hailing apps came. So what I'm going to do is just a couple of quick slides that show the big picture in New York City, but then break it down into submarkets in New York City to understand a little bit of why this has sort of taken off and grown. So after the ride-hailing apps come, they do expand the market. If you add these together, they expand the total taxi trips per day from about 500,000 to 1 million a day in New York City. Some of that, about a third of the app business, comes from displacing the traditional yellow taxis, which you see their trips declining. But about 2/3 of it came from sort of growing the market and the overall number of trips that are made. But really interesting dynamics when you look at it in terms of parts of New York City. So in Manhattan, it didn't change things nearly as much. You only see about a 25% growth, not a doubling of growth. And more of the growth is sort of at the expense of the existing taxi market. So the existing taxi market is heavily concentrated in Manhattan, and didn't immediately lose their share to the apps. But when you go out to the outer boroughs in New York City, you see that that's actually where the ride-hailing apps completely transformed the economy. They completely transformed this industry. Trips increased in the outer boroughs by a factor of 10. And interestingly, that the traditional taxi industry initially started making more trips in those areas as they were facing sort of greater competition in their core markets. So ride-hailing apps really brought taxi services and new transportation services to parts of New York that were less served in the past. Airport pickups, it didn't really displace taxis, but were complementary to airport pickups, and were displacing private rides or other sorts of means that one might take to the airport. So that's an interesting submarket as well. In California, we're going to look at what has happened in California. We're going to look at these non-employer statistics. So non-employer statistics only go through 2018, relying a little bit on the UCLA Anderson forecast that sort of parse this data out in some detail. We see similar growth in California. When we look at non-employer statistics, really the transportation industry is the only one where we can really see a clear growth that can be attributed to these new ride-hailing industry. But we see about an addition of about 200,000 jobs. But interestingly, that we see even growth in taxi services that are employed by others. So it also, there's some evidence that it grows transportation services in general. We also see a tremendous amount of earnings. So we're adding over $5 billion of earnings during this period, that in total earnings. Looking at another data source, which is the U.S. National Household Travel Survey, we see this is national data, and we see, where has taxi services taken off with the advent of ride hailing. See that it's been larger metro areas, not as much growth in smaller and rural areas. It's still a difficult industry in rural areas. We've seen substantial growth in users. So we have on any given day in large metro areas in the US, a little bit under 1% taking a taxi ride, to 1.75% on any given day taking a taxi ride in large cities. We see about a doubling of that activity in mid-sized metropolitan areas like Sacramento, seeing significant growth from about 0.25% to about 1%, certainly much more convenient to here. So I think we're going to get some demographic data about the drivers in more detail later. So that's why I just wanted to say a few things about the users. And we'll find that there's not too much difference between the use of the rideshare apps between white, black households. Highest percentage, 15% of Asian households at this US survey in 2017 are using ride-hailing apps within the past month. We do see higher usage amongst higher income households. So while relatively inexpensive for the service you're getting, it's still not necessarily cheap. And so we see higher usage among higher income households, but it's not exclusively a luxury good. We see significant usage still also in middle class and lower households. And of course, I guess technologically mediated activity, we see much higher usage among younger populations. 20 to 40-year-olds have really embraced it quite a bit. And a little bit more usage amongst males than females. So this illustrates this over time. Taxi services have seen the biggest growth for high earners, somewhat less for the lowest earners, but also significant growth in this $50,000 to $100,000 income range. And then demographically, again, really large growth. Before the ride-hailing apps, not nearly as much differences between the usage across age groups. Interestingly, ride-hailing apps have not really changed taxi usage amongst very young travelers. So a couple of important sort of take-home points is that we've really grown the market here. So there are large economic gains, large gains to the economy that have been created, mostly new growth. We've expanded services to underserved areas. While these sorts of transportation services are still hard to come by in rural areas, we've found suburban areas, smaller metro areas, places like the outer boroughs of New York City, seeing much greater access to this type of transportation services. And we've also seen impacts in related markets. So one of the big debates has been, what is this going to do to vehicle ownership? Is it going to be that it makes life easier to go without a car? I know I've got a daughter who recently moved to Washington, D.C., and has, for the first time in her life, gone without a car. But she actually credits the ride-hailing apps to making that a little bit easier. She makes 90% of her trips on the metro, but it doesn't serve all of her needs, and she uses ride-hailing apps, and that's allowed her to not have a car. However, the data shows that the introduction of the ride-hailing apps has actually expanded vehicle ownership in general. So the not needing a car impact has been outweighed quite a bit by people acquiring vehicles to use on the ride-hailing apps, either as a means of employment or perhaps the income that they could extra income they could get for a ride hailing app helps them cover a car payment and have a vehicle that they might not have had in the past. Fuel consumption, less parking expenditures. Parking's a really interesting area here that where there's some real potential benefits. Sort of entertainment and alcohol, I will spare some anecdotes in that area, but I think people are sort of aware of that. Externalities is another important area when we think about regulating the gig economy. It's not all been positive here. We've actually seen some increase in miles driven in traffic, which sort of makes sense. If I take a trip downtown to go to dinner and I drive my private vehicle from my driveway to my destination, if I'm using an Uber, there's some additional miles where that driver comes to get me and I wait 4.8 minutes for them to arrive. So that's extra miles driven. Extra miles driven can lead to increases in accidents. And then a interestingly studied area is the impact on public transit and to the extent to which it's complementary or a substitute for public transit. We found that it can be complementary in some ways, solving the last mile problem. A lot of trips go to rail and airports, but for sort of shorter local trips, it's been a substitute for buses. And then just very briefly, in the interest of time, I think this was alluded to in one question that sort of as economist, and I think about this types of gig employment and the changes we're seeing in the labor economy and what might be the appropriate policy responses to improve the welfare of workers. Employee classification is sort of not the first thing that comes to mind. And one of them is this issue of social insurance. So part of the reason the stakes of this is so high is that so much of our social insurance is based on employment rather than tax funded. And as we heard earlier, there's been a big push to actually increase the benefits of employment and tie more and more social insurance to employment relationships rather than being tax funded relationships. This particular issue, I think, somewhat exposes the problem with this approach. So we have social insurance that's based around traditional employment relationships, and we know that gig work often serves as a safety net. Now, one thing I will point out that this is not new to Uber and Lyft. 1099 work, if we go back and look before the sort of gig economy, every recession, every increase in unemployment, we see an increase in self-employment in independent contractors. It's quite clear in the data, and then it diminishes as the economy improves and we see lower levels of employment. But we do know that unemployment is one of the best predictors of people entering the gig economy, that they're using it as part of the safety net. And when the safety net is weak, that we have as a society, they're more likely to turn to this type of employment. So it exposes some of the weaknesses in our safety net. As we try to put social insurance on employers, there's some potential issues here. It increases conflict in this space, and there's some issues with competitiveness for our businesses. And so there's already been discussion of portable benefits and how this points out the need to sort of expand the tax-funded safety net. Maybe we need to decouple retirement security and health insurance and some of these other things from the employee relationships. I think this actually adds some urgency and argument towards policy movement in this direction. And one other direction that I think is worth sort of mentioning and exploring is the idea of, are these gig work platforms natural monopolies? Is it efficient to sort of have a single market and a single intermediary? And I think there can be some argument that it's true that there may be some natural monopoly here. And in that sense, this market, this connecting of consumers and producers directly sort of takes on an infrastructure type characteristic. And as we think about where this could evolve, and maybe not next year, but as we move into further out into the future, I suggest that people start to look at the potential for public utility models and try to think of this as social infrastructure, and even to consider a public ownership or public alternatives for these types of markets in the future. There's one interesting experiment called CalFlexi in California. So far, it's been pretty much limited to the service of in-home childcare services and a part of Southern California. It's going to be, I think, difficult to scale this towards some of the transportation sectors and the areas that need sort of a higher level of efficiency. But I encourage this as sort of a future thing for people to explore if they want to learn more. And so with that, hopefully I am generally on time here, Jay.
Yeah, that was great, Jeff. Thank you very much. And we do have a few minutes for questions. So let me ask Matt to pose some questions.
Absolutely. Would percent of income look different if it were by individual rather than household? This questioner said that it seems like using household does not tell us enough about individual drivers and what percentage of their income, as opposed to the entire households, is from Uber. They understand this is no doubt a data limitation, but still interested in
it's important to understand the data limitations there. And so the households here are, because we're looking at banking data here. So these are people sharing an account, not necessarily sharing a domicile. These are people that share an account. So maybe more characterized as sort of families that are there. And so, yeah, it does pool income that you might have somebody working in the gig sector sharing income with someone who isn't. So it does, that is a limitation to the data, but people that share accounts are sort of joint economic units. So I could also argue, it's a good way to look at that data.
And then there was a follow-up there just saying, wondering if data from unshared accounts would show interesting differences as well.
Yes, it might. And again, this is one of the limitations of this is what I think is sort of the most interesting real-time data out there. But you've got sort of financial institutions that I'm grateful that they're sharing the data and putting it out there with researchers, but they're doing it in this very, very sort of aggregated way. So I think for understandable reasons, and we aren't able to sort of to directly manipulate that data or to really drill down in the way that we like to and are accustomed to in other types of markets.
Speaking of aggregation, how would you disaggregate the economic gains to consumers derived from technology versus the very significant subsidies provided by venture capital backers?
That's a really good question, right? So, and I did not get into this issue, but some of these companies are only recently sort of profitable under significant measures, and tech industries have often used venture capital to try to penetrate a market at very low cost, serve consumers at low cost initially in order to sort of gain some level of dominance. And so it's true that expansive growth isn't just it's due to the low cost and convenience, but initial low cost has been subsidized by venture capital. I don't know exactly to what extent I could parse that out. They're trying to change our habits, and to some extent that's successful. Know that even employer-based transportation has actually seen some services has seen some growth. Anecdotally, I can speak to it myself. It's sort of changed my mindset about how I get to the airport, and I've actually been more inclined to locate and find a scheduled employment-based transportation service to get to the airport than in the past, when I was sort of conditioned to rent cars or call a friend.
Yeah, I'm in the same boat. I was living in New York during some of that period, and yeah, a lot of that data you showed matched my experience. In Manhattan, I could just step out and raise my hand, so it it makes sense why I wouldn't be as likely to call Uber or Lyft there. But I lived in the boroughs, and yeah, it was an easy call there. And we have another question here, kind of building on that last question, and I think you might have touched a little bit on this. Uber and Lyft have been consistently operating at about a $5 billion deficit for each year in business. This seems to be due to high insurance costs, as 50% of their revenue is dedicated to covering these costs. Will these ride-sharing companies ever become profitable?
Yeah, well, I'm not going to make a prediction on their ability to be profitable. I do believe they have started to turn some marginal profits. The market seems to believe that they have the potential to be profitable. Yeah, I'm not going to speak specifically to the businesses. Don't have a lot of knowledge there.
No one invests based on Jeff's advice, I think is.
Thanks for adding the disclaimer. Yeah, that's particularly in this sort of market.
I would note that I think James River Insurance originally was hired by Uber, or not hired. They provided the insurance to Uber, and they got crushed. They had to pull out of the market. I mean, the claims far exceeded what they anticipated. So that's one of these uncertainties. So it doesn't surprise me if insurance is a huge deal. Thank you very much, Jeff. Those data were really interesting. We're going to transition directly without a break to a presentation on complexity and variations in the gig economy. We're very lucky to have Peter Leroux Munoz, who serves as General Counsel and Senior Vice President of Technology and Innovation for the Silicon Valley Leadership Group, where he focuses on autonomous vehicles, artificial intelligence, data privacy, international trade, and immigration. Any one of those would be enough, Peter, so kudos to you. He began his legal career in intellectual property litigation and has also worked as in-house counsel for a financial advisory firm. Thank you very much, Peter, for joining us.
Jay, thank you so much. It's my pleasure to be here. I am going to start sharing my screen. I always hold my breath whenever I press this button. So let's see if this works. Here we go. Okay. Perfect. I think people can see that there. And I'll begin my slideshow now. So again, thank you all for having me. It is very much a pleasure to be here this morning. As mentioned, I do serve as SVP of Tech Policy for the Silicon Valley Leadership Group. And for those who may not be familiar, the Leadership Group is a business association representing nearly 400 member companies of all sizes working in the innovation economy. And one of the things I enjoy about my work is that it's exciting for me to help companies as they bring innovative solutions to market and help address consumer needs in new and interesting ways. Now, because we're among a group of lawyers and soon to be lawyers, I have to give my caveat that my remarks are solely those of the Silicon Valley Leadership Group. They are not meant to represent the position of any of our particular member companies or partners. So with that out of the way, let's just dive kind of right into to the presentation here. And really the presentation title, Complexity and Variations in the Gig Economy, is an apt title because the gig economy is unique and innovative, and this makes it a complex industry to regulate. I think the prior presentation touched on some of the complexities there. So thoughtful regulation really does require thinking about how best to provide for the needs of workers, and specifically one of those needs that is consistent throughout for workers is that of flexibility in the work arrangement. Now, let's talk a little bit about background of app-based work. And as we all know, the use of private vehicles to transport passengers or deliver food for compensation, this is not new. But the advent of app-based platforms that connect consumers, merchants, and deliverers has radically changed the delivery business and the nature of work more broadly. Across the nation, trips taken via app-based rideshare platforms far exceed taxi rides. And I think we saw that just before. Grocery and restaurant deliveries are also commonplace. In fact, they're so common that even my anti-tech parents now order fresh groceries from their favorite stores. But what is the nature of this gig work? Well, with the rise of innovations like app-based rideshare and deliveries, we've seen this rise of new innovative form of work. Passengers have access to affordable transportation and greater mobility options. Drivers benefit by earning on their own time with the freedom to set their own hours. And they are not bound by rigid work shifts or a boss telling them if, when, and where to work. Now, the more flexible work arrangements offered by sharing economy platforms provide an alternative to those excluded from traditional 9-to-5 employment relationships. And those people include workers like students, parents, and part-time workers, among others. The ability to set their own hours and work simultaneously for competing companies is not possible under normal work arrangements. So, for example, let's consider a situation. Imagine with me, if you will, that you're working for a coffee company like Pete's Coffee in the Bay Area, and it's a slow day, but you see across the street that there's a huge line of cars waiting to order fast food at a restaurant. Now, if you are in a traditional employment model, you can't say to your boss, hey, you know what? I'm going to work over there for a while, and then I'll come back and I'll finish my shift here. Your boss would look at you like you're crazy and then tell you that you couldn't do that. But the flexibility offered by the gig working model means that you can do exactly that. You can bounce back and forth between different app-based services. And so if you're working for a traditional rideshare platform, you aren't getting a lot of rides, you can easily check other ride-sharing platforms or delivery platforms to see what the demand is if it's higher somewhere else and freely switch. So add in the ability to set your own hours and work when, where, how, and how long you want to work. And it's easy to see why gig economy work is appealing to so many and allows for the inclusion of so many who traditionally would not be able to be part of the standard workforce. Another benefit that comes through with the gig economy and app-based working platforms is that it helps to speed up the process by which people get paid. In a typical employment job, workers have to wait to get paid usually every 2 weeks. With gig economy work, workers are able to cash out much more quickly after completing their work. And this helps people better manage their cash flow and use it for things like rent payments or adjust circumstances that may come up where they need money sooner than on a typical bi-monthly schedule. There's also the idea of consumers and the benefits that they accrue as a result of transport network company and DNC delivery network company services that are offered. One of the downsides of attempting to reduce worker flexibility is a reduction in reliability for consumers. TNCs and DNCs increase mobility and access for groups like the elderly and the infirm, as well as for those who don't possess a driver's license or otherwise opt out of driving. These services make transportation and delivery more viable for those who do not own a car, similar to the previous speaker's daughter living now in Washington, D.C. at whether that's not owning a car by choice or by necessity. And reclassifying drivers as employees who must adhere to a rigid work schedule decreases the number of potential drivers available to meet demand at any given time, increasing consumer costs and wait times. So who drives for app-based services? I think we got a sense of that before, but let's flesh that out a little bit more. Every year, more than 1 million Californians work with app-based ride-sharing programs and food and grocery delivery platforms. They're parents who work while their children are in school. They're family members who need the flexibility to care for aging parents or ill spouses. They're students who earn income around class schedules. They're retirees who need supplemental income. And I've seen this here personally in Silicon Valley. They're young entrepreneurs who sustain their startup dreams while putting money in their pockets as they pursue their larger financial goals. And there are any number of other additional types of people. The overwhelming majority of these drivers do not rely on this work as their main source of income. In fact, more than 80% of drivers work less than 20 hours a week. They have other jobs or responsibilities, and they simply can't work set shifts as traditional employees. So what do drivers want for themselves? I think that it always has to be a central question that we ask ourselves. Sometimes it can be tempting in politics for groups or politicians to claim to speak for other people, but I think it's best to let people speak for themselves. So what do drivers want from their work experience? Well, independent surveys have consistently shown that drivers overwhelmingly prefer to remain independent contractors. And it was the position of drivers that propelled Proposition 22. Now, Proposition 22, as we probably all know, was a ballot measure in 2020. And the non-traditional nature of work for app-based drivers and the desired flexibility that comes with it suggests that drivers should be classified as independent contractors and not as employees of the companies that connect them to passengers or consumers. However, some legislators in California disagreed, and legislation was passed that codified app-based workers as employees rather than independent contractors. But the people most directly impacted, drivers themselves, wanted to remain as independent contractors. Prior to the passage of Prop 22, surveys showed that these app-based drivers overwhelmingly preferred to work as independent contractors by a 4-to-1 margin. In 2020, the issue of how to classify drivers was brought to voters through Proposition 22. And Proposition 22 was trying to make a very important balance. On the one hand, it sought to protect app-based workers' desire to remain independent contractors. And on the other hand, Prop 22 sought to extend new economic benefits to drivers, including guaranteed hourly earnings and per mile compensation towards expenses, funding for new health benefits for drivers who work at least 15 hours a week, and medical and disability coverage for injuries and illnesses on the job. Additionally, Prop 22 also enhanced protections against discrimination and sexual harassment. So Prop 22 also had to balance all those factors while ensuring at the same time that services remained available and affordable to consumers, many of whom cannot access traditional transportation options. And California voters ultimately supported Prop 22 by nearly 60% of the vote. Now, looking at after Prop 22, what was the reaction among drivers? Well, after Prop 22, classified drivers and workers looked at this and they considered their circumstance. And according to UC Riverside School of Business Center for Economic Forecasting and Development, California drivers earned on average $34.46 per active hour, including tips. Now, this represents an income increase of 26% since 2019. And you can see on the screen here the different earnings in various places that drivers can earn. Now, to be clear, there are regional differences between average earnings. Where you drive impacts income. Drivers are earning as much as $40 per active hour plus tips in Napa, but even drivers in the lowest compensated regions are receiving on average $30 per hour plus tips. Furthermore, drivers continue to be satisfied with app-based work after Prop 22. 82.3% report satisfaction from app-based work, and 75% report that they prefer to be classified as independent contractors rather than as employees. And this last statistic reflects a similar study conducted by the Benenson Strategy Group, which found that 84% of drivers prefer to remain independent contractors versus becoming employees. And again, this goes back to one of the central features that makes app-based driving so innovative. It's the flexibility. It's the ease with which drivers can earn extra cash and the flexibility to do so on their own schedule. And these elements are central to app-based work. Now, tellingly, most app-based drivers do not seek full-time work on platforms. 2/3 of drivers drove an average of 5 hours maximum per week, utilizing these services as a way to supplement income from other jobs or work opportunities. And you can see again here the information about the levels of satisfaction and the importance of flexibility to those drivers. But now let's talk a little bit about where we're at presently with regard to Prop 22 and more broadly app-based drivers and app-based workers. Following the voter approval of Proposition 22 in the fall of 2020, SEIU and 4 drivers followed a lawsuit that sought to challenge the constitutionality of the measure. A judge in the Alameda County Superior Court held the measure to be unenforceable on the grounds that it denies the legislature the ability to regulate compensation for workers' injuries. The California Attorney General has appealed the decision, and so the issue of the constitutionality of the measure remains to be finally decided, as well as the issue of protecting the voters' rights of initiative and the integrity of our election system. At present, Prop 22 remains in effect and continues to reflect the will of California voters. Let's turn our attention for a moment to the impact of app-based drivers during the pandemic. Now, the low barriers of entry for gig work have been critical during the pandemic. And as we heard from the previous speaker, some more drivers will turn to this kind of work during an economic slowdown. This has been something that we've seen, and the evidence sort of bears that out. As much of the economy was shut down due to quarantine orders, app-based work helped hundreds of thousands of Californians earn income to continue to support themselves and their families. And interestingly, this has been especially true for working mothers. According to the US Census Bureau, 3.5 million mothers of school-age children have left active work since the start of the pandemic back in 2020, shifting into unpaid or paid leave, losing their job or exiting the labor market altogether. Now, Isabel Soto, who is the director of labor market policy at the American Action Forum, a policy institute, noted that, quote, women are still, in a lot of cases, predominantly responsible for much of the care in the home and in families with children. The gig economy allows mothers and women to make their own hours, set their own rates of pay, and own their work in a way that traditional work structures don't allow them to do. It makes sense that this flexible work is attractive to women, end quote. Here in California, we can also quantify the impact that app-based work has had on drivers and merchants since the onset of the pandemic. Data compiled by the Protect App-Based Drivers and Services Coalition showed that between March 2020 and February 2021, more than 1.2 million app-based drivers in California earned $4.2 billion in income through the first year of the pandemic. Now, the same study showed that over 800,000 drivers in California started driving with app-based rideshare and delivery companies during the pandemic, demonstrating that app-based platforms were critical to help workers who lost income or jobs, or who simply needed a new way to earn. Similarly, merchants were also hard hit during the pandemic. We know this, with many industries being forced to adapt to new and shifting realities and taking on new policies. One of the most impacted, of course, was the restaurant industry. Overnight, eateries pivoted from serving guests in restaurants to a delivery-only business model. According to research by the California Restaurant Association, as many as 30% of restaurants were threatened with permanent closure due to the pandemic and the attendant economic shutdown. Creating their own in-house delivery program was infeasible for most restaurants. And why is that? Because you have to pay for additional people to answer phones. You have to find deliverers. You have to provide vehicles in some cases. And you have to shuffle staff from their traditional roles within the restaurant. App-based services provided a much-needed lifeline. Rather than build those in-house delivery services from scratch, restaurants were able to utilize app-based platforms to pivot quickly and continue serving their customers. And similar to drivers, the Protect App-Based Drivers and Services Coalition has collated data from merchants who utilized app-based platforms during the pandemic, and the results were startling. 117,000 restaurants and merchants utilized app-based delivery services in 2020. And that 258 million individual customer orders were placed with restaurants and merchants through these services during that period. App-based platforms generated $9 billion in revenue for restaurants and merchants during this time. Now, these are big numbers, and they make a real difference. Technomic, a food service research firm, found that 79% of restaurants reported that they would have had to close their businesses without app-based delivery, and 81% would have to lay off staff in their absence. So we've talked about drivers, we've talked about merchants. What about the consumers? What do they think about these kind of services? Well, consumer attitudes towards app-based services have also been captured by studies and by research. In August 2021, Pew Research surveyed Americans about the attitudes they held towards app-based services. Nearly 1 in 4 Americans use the platforms to order groceries or other household goods. 22% utilized rideshare offerings, and almost 40% of Americans reported utilizing delivery services to connect with local restaurants. Now, let's be clear, and this is something that was shown in the previous speaker's presentation. Distribution of who is using these services is not always even. As you can imagine, the majority of users are younger, they live in urban areas, and they have college degrees. However, a stunning 94% of all respondents across the spectrum believe that app work is a good way to earn extra income and work a flexible schedule. So I presented a lot of information here. Let's try to land this plane. What's the takeaway here? Well, the takeaway, I think, is that app-based work is fundamentally different from traditional work arrangements because of the inherent flexibility granted to workers. It's the workers who benefit from this break from traditional work arrangements, and it's the workers who continuously have asked for new, innovative, and flexible work arrangements that grant a higher diversity of workers entry into the labor market, whether they're students, working mothers, people with passion projects, retirees, aspiring entrepreneurs, and others. Instead of using workers as political tools or assuming we can divine their intent, why don't we listen to them when they say that they want flexibility? They want the freedom that comes with app-based work. And I think we should also listen to California voters when they overwhelmingly agree with them. So yes, app-based work is different from traditional modes of employment, and it's more flexible. California's laws and its regulations should be equally flexible in setting rules that meet this new reality. So with that, I will take a pause here, and I'm happy to address questions that people might have.
All right, excellent. The first question we have here, regarding the hourly pay that you reported, can you explain what active work hours mean? Is that time clocked into the service, or is that time driving? Is it something else? If somebody's looking for a ride, is that part of active work hours? Where do those begin and end?
So the work hours begin when a driver is actively engaged in picking up or dropping off a consumer. So driving to pick up somebody, and then in the act of bringing them to their location. That's the work hour.
Great. Next question. You claim that an employee classification would force employees into fixed schedules, but California does not require predictive scheduling, nor is there anything in the labor code that would suggest that ride-sharing companies would be forced into set schedules. So why does employee classification impede flexibility?
Well, I think it impedes flexibility in exactly the way that I spoke to before. One is, when you have an opportunity to work in a job and it's in a traditional employment setting, I'll go back to the example of working for like Pete's Coffee. There are numerous limitations about where you have to work, the location. That's oftentimes a limiting factor in your independence. Two, there's a factor in terms of when you have to work. You can't just show up anytime you feel like it. Three, there are limitations in terms of for whom you can work. There are oftentimes restrictions about working for other kinds of companies at the same time, whether it's in the same industry or otherwise. So there are a whole host of reasons that this kind of work, gig work itself, provides for greater flexibility than traditional work arrangements.
Are you aware of any legal restrictions around those being offered in an employment relationship? And if not, do you anticipate that in response to this disruption that employers might start offering that sort of flexibility as a benefit of employment?
That's a really good question in terms of what might happen around this. I think that what we've seen with the app-based work is a reconsideration of work, not only within kind of delivery services or driver services or whatever, but it's just kind of a reconsideration more broadly. I could very well contemplate a situation where more traditional forms of work look at their constraints and try to determine if there are ways in which legally they can provide greater flexibility. I think it's something that has made app-based work so attractive, and the reason why we see a whole host of new people kind of coming into that area. So I certainly wouldn't be surprised, but it's it's hard for me to kind of speculate what one particular industry might do or not do in the future legally.
Mhm. With drivers being online with using multiple platforms at once, could these ride-sharing companies pay pro rata share of wages, especially since many of these companies use a third-party payroll system? Couldn't they use these third-party payroll systems to facilitate a pro rata wage system?
That's something I'm not aware if the companies themselves might be contemplating that. So I really can't speak to it. But again, I think what is interesting about the app-based service companies is that they're consistently looking at ways to be thoughtful and innovative. So while I can't speak to whether that in particular is something that they will ultimately decide to do, because again, I don't speak for any one of the companies. It is something that that companies may ultimately decide to consider, but it's ultimately their decision as to what works best for their own company.
Do drivers really have control over, quote, where they work? Isn't it true that they do not know the destination of a ride until they accept it? This can result in a driver who intended to take one more ride before going home, driving significantly far in the opposite direction of her house, thereby significantly delaying the time she arrives at home. And I guess, yeah, if you could just speak to the sort of the restrictions that come along with those sorts of relationships.
Yeah, I think ultimately this goes back to the freedom that drivers have. You know, the nice thing about the app-based template, I think that provides a lot of the flexibility, is that there is no set requirement in terms of hours that you have to be on at a certain time, that you have to fulfill a certain number of rides or anything like that. So I think that to say that there's no flexibility or that there's reduced flexibility because you don't know, I don't know that that's necessarily the case, actually, because at any point, a driver can simply log off. They need not complete a certain number of hours or a certain number of rides.
Makes sense. Returning to hourly pay, if this questioner understands the answer to the question correctly, it sounds like hourly pay is super high if the driver has no downtime between rides. But do we know how often this is the case? Do we have any data about hourly rates if we count all the time clocked into the app instead of just drive time? And I might expand on that. You know, obviously these drivers have to do a lot more than just drive, you know, people around. They need to maintain the car, things like that. How do the hourly rates compare when you're including all of those requirements?
Thank you, Matt. And that kind of reminds me of like billable hours. When I started off my legal career, I remember working on cases, and you know, there's a lot that goes in, you know, when you're not necessarily billing hours. That's a good question. I don't have that data, but I'm happy to work with the groups and that provide me a lot of this information and see if we can lay our hands on that information.
This questioner referring to how you were saying that the majority of gig workers work relatively few hours. This person's seen a lot of studies showing that the majority of work hours provided on these apps come from a minority of workers who work regular, full, and part-time hours. Should these workers receive the same benefits and compensation for waiting time that employees receive when they're working longer hours?
So that's another good question. I think that's something that the industry, you know, the industry partners will have to kind of take a look at, the players themselves. I think looking at the data here, I think those are the people who, the ones who are working more hours, I think are in the minority. So it's not as reflective of the typical driver experience. And so given that, there's a question for how individual companies might want to kind of consider addressing those unique circumstances. So again, I can't speak for any particular company, but recognizing that those are outliers, that might be something that industry players may decide to look at.
Do you know if obviously what you're saying, the majority work a few number of hours, do you know if it's one of those situations where, you know, they say, oh, 0.5% of users online create 75% of the activity online. Is it that
Yeah,
kind of situation?
I understand your question, and I do not have that information, but I'm happy to, again, work with some of the people who provided this information to see if we can get that.
Great. And is drone delivery or autonomous vehicles a realistic threat to replace drivers in the next 5 years?
Oh, man, that's a big question.
Yeah.
Drone delivery and autonomous vehicles, a threat to replace drivers. So let me take a step back about all of that. Let me just say, and this is again me speaking for the Silicon Valley Leadership Group, with regard to the deployment of autonomous vehicles in California. California as a state, it tends to move a little slower than other states. And so while I can't, speculate how fast the CPUC, the California Public Utilities Commission, or the DMV are going to work on something like that, I can say, just given their track record and how long it's taken to get some basic autonomous vehicle deployment models out, that seems overly accelerated. But it is hard to. It's hard to contemplate that in the near future. That's my own personal assessment, having worked in this space.
So perhaps not the next 5 years is what I hear you saying.
I think it's probably pretty fair to say.
Peter, I have a question. Given your role with the Silicon Valley Leadership Group, did your group take a position on Prop 22, which seemed to divide? It wasn't uniform for all the participants in this economy. Were you outside of the Prop 22 fight, or did your group play a role?
No, we looked at the issue, we talked about it collectively, and ultimately we decided to support Prop 22. Okay,
so it was supported. Was there any thought that other similarly situated companies should be included in Prop 22? In other words, one of the complaints is, well, Uber wrote their own personal law, and I'm just curious, your perspective where you're not aligned with one company, were there any discussions about how should we rationally draw these lines?
Yeah, well, first off, I don't accept that Uber was writing their own law, so I disagree with the premise there. But with regard to the way we operate as an association, I mentioned we have over 400 member companies in our collective body, and when we look at issues, we recognize that we always want to find consensus among our diverse members, and sometimes member companies may not be directly impacted by a particular piece of legislation in the immediate term, but nonetheless look at something and say, this is a regulatory or legislative trend that we want to support because this will be good for innovation more broadly, for consumers more broadly, for business more broadly. And I think that was the reason why overall the consensus among our 400 member companies was to support Prop 22. I'll be very clear. Internally, we do not say, hey, it's good for one member company or it's bad for one member company. What do you guys all think about that? We're always trying to see what is the consensus around the innovation economy companies that we represent. So I think that looking at Prop 22, the idea for our members is this is app-based services are new and innovative ways of making deliveries, of supporting consumers, providing these services in a unique way. And it's something that we wanted to support. I think giving people and giving workers more choice in their work arrangement was also something that we wanted to support as an organization.
Okay, and I want to make clear I wasn't poking you with the Uber comment.
No, that's quite all right, Jay. You can poke away.
A CEO of another company had indicated, wow, it's like Uber got their own law. Who's going to take care of us? And I don't know if they're one of your members, but
no, I disagree with that assessment, but yeah. But you're allowed to poke away. All good.
Matt, you have another question?
Yes, we have somebody asking, I understand that there are satisfied workers. However, when it came to the COVID-19 pandemic, everyone wanted benefits, even when the drivers and companies had not paid into the system. What is the view of these workers in regards to unemployment insurance or disability insurance benefits? Do you have any data regarding how the pandemic has altered these workers' views?
Yeah, so the surveys were taken, the surveys that some of the stats that I gave, and I'm happy to share all the stats afterwards so people can have access to it and make full use of it. The satisfaction surveys were done some were done just a couple of months ago. So it was well after the pandemic had started. Going through my notes here, I'm trying to parse out which numbers those were. I'm having difficulty finding it, but I'll make sure that you get the data. But surveys were done specifically after the pandemic to, one, allow for time for drivers and workers to consider post Prop 22, have your attitudes changed, and post pandemic, have your attitudes changed. So we'll provide all of that information, and all of your participants will be able to see that included there.
And that's great. And I think that actually answers the other question we have in the Q&A, although one just came in. If people can contact you, if there's a way that you could share what would be an appropriate way.
Yeah. Let me. I'm not sure if I can post my chat in here, but it's real easy. It's P. Lerone Munoz, LEROEMUNOZ at svlg.org. You can also visit us at svlg.com, and you can find me there under the tech policy. So welcome to, please feel free to reach out. Look, I know that there are a lot of different opinions on this stuff. I know that people have strong feelings. I am always willing to talk to people. So whether you agree with me, whether you don't agree with me, I think I want to be as transparent and open. So please, you have an open invite to reach out to me at any time. And I'll just finish by saying, again, really the focus for me at the end of the day is on the workers and their express preference for the flexibility of this kind of work.
That's great, Peter. Thank you so much for joining us. I know you're incredibly busy, and this has been a vital part of this conversation. And I'll let everyone know our great events team will get materials out to you, and this is all going to be reduced to writing in the law review. So we hope to make all this information fully available. So thank you again, Peter, very much. Appreciate it.
My pleasure. Thank you all.
All right. We will now have one more presentation before we move to the lunch break, and that's an empirical assessment of the lives of precarious workers. So I think we might have some differences from the previous presentation. Professor Vina Dubal teaches at UC Hastings College of Law. Her research focuses on the intersection of law, technology, and precarious work. She uses empirical methodologies and critical theory to understand the impact of digital technologies and emerging legal frameworks on the lives of workers. She has also written about the role of law and lawyers in solidarity movements, and her scholarship, which is extensive on the gig economy, extends from commentary in popular media to top-tier law reviews. And due to fault of all my own, she had to leave class early to make it here because I forgot in my scheduling. So she's fresh out of the classroom and ready to talk about the lives of precarious workers. Go ahead, Vina.
Thank you, Jay, so much for having me. I think that you're correct that my presentation actually flows well from the last conversation, in particular, the last comment about what workers want. Forgive me if some of this is a repeat of what you all have already heard because I had to miss this morning's conference. But before I talk about my research, I just want to say that, the number of freelance workers in the US is actually quite small. So contrary to the numbers put out there by Upwork and other tech companies who rely on a freelance workforce for their viability, the Bureau of Labor Statistics suggests that it is still under 5%, but it is growing. because of these companies and the vast amount of venture capital that goes into funding this type of work. And so concerns about worker liability and worker protection and corporate liability have focused almost exclusively on this distinction between independent contractors and employees. So as most of you know, workers who are employees have the theoretical right to be protected from work discrimination, from poverty wages, from unlawful termination, etc. Independent contractors do not. So over the past 40 years, business representatives have concentrated on growing the independent contractor category, lowering the liability and legal risks associated with doing business, often transferring those risks onto workers and onto taxpayers. While workers and worker advocates have focused on narrowing the independent contractor identity or category, ensuring that more US workers are protected by the web of employment and labor rights. And in the US, as all of you know, with the decline of the decimation, I should say, of the welfare state, employment laws are the only safety net that most people have. This issue has become, again, central to these gig economy debates. It is now central in regulatory, judicial, legislative battles across the US and across the world. Most judicial bodies have found internationally that workers for companies like DoorDash, Uber, Foodora, to the extent that they've been able to get a final decision that they've overcome, in the US arbitration agreements, but elsewhere have in Canada, South Africa, Italy, Spain, elsewhere have found that these workers are by and large in the UK considered employees or at least deserve minimum wage protections. And in California, of course, we now have Prop 22, which has been declared unconstitutional by the lower court. And we are seeing this appealed by the interveners, of course. Prop 22, in another article that I would recommend to you that is in the Harvard Law and Policy Review that I wrote after the law was passed, Prop 22 is what I call the new racial wage code. It is a way of calculating earnings quite distinct from a time-based minimum wage in which workers are really owed nothing despite the fancy language. They are only paid for engaged time, that is time after they are allocated a fare or a job. But this does not include time with the app on waiting for work. And importantly, that is not determined just by demand, but actually by algorithms. And so we have found post Prop 22 that workers say that they are punished in certain contexts for not doing what the company or the app wants them to do. As they get closer to the amount of engaged time necessary to trigger some of these other benefits, like the healthcare subsidies, they stop getting work. And so in fact, this is a new racial wage code for a subordinated racial minority workforce. This workforce, by the company's own estimation, is 70% nationally people of color and immigrants. And in the San Francisco Bay Area, according to a study out of UC Santa Cruz, the number is much higher at about 78%. So central to the question of Prop 22, central to the regulatory debate everywhere, and I'm going to argue that this should not be central to the regulatory debate, but I'm going to tell you why it was central. Central to this question is, well, what do workers actually want? Do they want to be employees or do they want to be independent contractors? And I just want to play for you a bit of how Dara Khosrowshahi framed this in his conversation during the Prop 22 campaign with Kara Swisher and Scott Galloway, and show for you actually a much problematized paid advertisement that Postmates, now Uber, put into the LA Times, in which they use the names of some of their workers to say that they wanted to be independent contractors with flexibility and not employees. Workers themselves said that they did not understand that this is what they were signing on to and did not want their names included. And therefore, it was actually very hard to find this image online because it had been taken out for legal reasons. Let me just play a bit of this. I don't know, can you? I don't know.
I don't think we can hear it coming through.
Okay, that's okay. I was trying to do something fancy with my audio, but I'll just move on. Essentially what he's saying is, oh, there was this survey. We want to do what good by our workers deserve some benefits. This was soon after he wrote the infamous New York Times op-ed, which went nowhere in terms of actually doing anything for workers. And he says, but surveys show 70% of drivers want to be employees. And this was stated over and over and over again. Surveys show that 70% of drivers want to be employees. So prior to the advent of these companies about a decade ago, I was studying and writing on the San Francisco taxi industry. And among other things, I was looking at how worker classification took on social and cultural meanings for many drivers. And I showed how these meanings had produced a divisive politics among driver groups. And after that, my work was sort of disrupted by Uber and Lyft, and I sort of started engaging in a theory-generating ethnography of Uber drivers in California who have been fighting for better working conditions. And this has included, hundreds of hours of participant observation and action and drivers' meetings and protests and meetings with regulators, on group phone calls and texts and government hearings and one-on-one conversations with some drivers with whom I developed relationships. My ethnography has continued into social spaces. All the workers that I studied are Uber or Lyft drivers, and many of them work for other companies as well, like DoorDash or Instacart. And this research, this deeply embedded research, gave me insight into the complex and unpredictable links between law, work, and everyday life. So rather than claim generalizability or static sociological ascription, my findings problematize broad claims to knowledge about workers. So I want to say that in addition to the study that Dara Khosrowshahi points to, I developed a survey back in 2016 that I did with over 200 drivers in San Francisco. They too said that most of them wanted to be independent contractors. It was about 2/3. And I wanted to sort of understand why it was that during the AB5 fight, despite the fact that all of the, that these workers said on the survey that I did and that Harry, the rideshare guy, did, that they wanted to be independent contractors, and yet we watched drivers and drivers groups fight passionately over claiming employment status. And so one of my questions in looking at my data is, well, how do we explain the preference for independent contractor status on surveys and advocacy for employee status? How do drivers make sense of employee status in relationship to their lives and visions for the future of work? And how might understanding these perspectives impact how regulators approach worker status in the tech-enabled gig economy? One of the most influential pieces of scholarship on Uber driver preference is an article written by Jonathan Hall and Alan Kruger, both eminent economists. And in a working paper made available in 2015 and later published in 2017, they concluded, also based on this survey research, that 79% of Uber drivers preferred independent contractor to employee status. And this data has been cited over and over again in regulatory contexts. The specific question that they asked on the issue was as follows, what I have up here. Which of the following would you prefer regarding your driving with Uber? Being classified as an employee of Uber so you can be eligible for a minimum wage, healthcare, and other benefits, but not have the flexibility to set your own schedule, or being classified as an independent contractor for Uber. So you would have the flexibility to set your own schedule, but you are not eligible for minimum wage, healthcare, and other benefits. But this question, you will note, for those of you who are trained in survey methods, is actually double-barreled. So essentially forces respondents to answer two questions at once when their opinions about the two might diverge. So drawing on the critique of two ILO economists, I argue in this article that this question obfuscates the law and actually does the cultural work of creating a legal misperception among survey respondents. So although many employees in the US have an inflexible schedule, employee status is not fundamentally incompatible with scheduling flexibility, as the question, as framed, appears to claim, and as the companies continually maintain. If you look at the test for employment status, this is not a test about scheduling flexibility. This is a test, if you look at the control test, if you look at the ABC test, this is a test about whether or not these workers need or should have basic floor protections. And the question of flexibility continues to obfuscate what employment status is. I asked a much more streamlined question, avoiding this double-barreled problem. I asked the workers in binary terms, do they prefer to be an employee or an independent contractor? And they weren't given any information on what those statuses meant, but findings from the binary question reveal something similar to what Hall and Kruger found, this preference for independent contractor. It was true whether the drivers were doing Uber as their primary work, or as their supplemental work, or as their only work. So if regulators take the position that driver preference matters, that the law should to some extent reflect the desires and perspectives of those it is intended to serve, then the survey data seems to back up the position of the companies. And yet drivers themselves and driver groups that I studied rallied around AB 5 against Proposition 22, which raised the question that drove this article: why? And after coding and analyzing years of field notes and interview transcriptions for perspectives on employee status, I realized that my ethnographic research did something really profound. It troubled both the survey numbers and the practice of determining complicated preferences through an efficient survey medium. So based on driver narratives drawn from interviews and ethnographic data, I argue here that the survey findings capture not attitudinal realities or desires, but in many cases, driver perceptions rooted in fear. So in the context of their relative powerlessness and economic reliance on Uber, employee status was subjectively constructed through a duality. It was both a desirable way for drivers to fight back against the company and a status that came with its own undesirable uncertainties, including most critically the potential loss of scheduling flexibility. Worker narratives overwhelmingly suggested that drivers had an ambivalent relationship to employee identities. And in making sense of these legal categories, which have been perplexing even for law professors and judges to parse, Uber drivers said that they unequivocally needed and wanted the protections and benefits that employment status offered, but many were afraid of what a notorious company like Uber would do if they embraced their role as employer. Drivers had a strong sense of the structural and instrumental power of Uber. Their ambivalence was fueled by what a terrible employer Uber could be, how Uber would never agree to an employment model, and anxieties that the company would take away their flexibility, not because employee status necessitates the shift schedule, which it does not, but just because they could. Drivers frequently alluded to the company's structural power, the amount of venture capital money behind these companies and the company's influential political connections. Many believed that the companies were actually involved in illegal bribes, but most were alluding to the instrumental power of the company and their deliberate and successful political engagement. The companies, the drivers believed, had so much power in the regulatory arena that no matter what, they could not be forced to recognize their drivers as employees. For example, Rusty, who was a Filipino-American immigrant driver, felt that there was no way Uber would give him basic employee benefits, no matter what the law and regulators said. And on our survey, he said that he wanted to therefore be an independent contractor. But when I interviewed him, I got a very, very different sense of what he meant by that. So like many migrant drivers in California, Rusty drove from his home in Orange County to San Francisco for work because the rates were higher than in Southern California. In the context of how much he could benefit from employee benefits, he described his migrant work life to me. For most of the day, I stay in my car, living in my car. I'll have a curtain that I'll use to sleep. And then there are days that I would be able to get to take a bath. But there are times when I'm not going to be able to take a bath for 2 or 3 days. Then you sleep in your car, and as soon as you get up, then you start driving. It's terrible. I'm far from my family. Rusty wanted the benefits associated with employment, but he chose independent contractor status on the survey. In one of my interviews with him, he clarified that his preference was based not on what he wanted, but what he thought was realistic. Over the phone, after returning home to the OC, he explained his thoughts on employment. It will be great if they make us employees. Oh, this is the wrong one, sorry. It will be great if they make us employees, but I don't think Uber will. They're very smart and they're very shrewd and they're very greedy. They're not going to go for it ever because they make money out of this kind of system that they have now, where I have to sleep in my car. Why would they change? The law bends for them. Rusty's assessment and reason for stating a preference for independent contractor status were well informed, but they did not reflect a rejection of employment benefits, only a realistic assessment of the company's power. Why fight for this, he said to me, we will never win. Rather than being clear-cut, his perspective, like others on employee status, was fueled by an ambivalence generated from fears that the company could act with impunity. Unlike judges or lawyers applying a legal test, drivers took into account the external influences that might impact their lives beyond the obvious benefits of the status. In addition to their feelings of powerlessness in relationship to Uber, the ambivalence that drivers harbored towards the status also stemmed from the necessity of scheduling flexibility in their lives. Whether they led transnational lives, endured disabilities that made a shift schedule impossible, or were responsible 2 and 4 young children, flexibility for work was not a desire, but a requirement. And contextualizing the need for scheduling flexibility and the ways in which it is conflated in driver narratives with the independent contractor classification also helps to explain and undermine the survey data. For example, Paul, a white 25-year-old internal migrant from Pikeville, Kentucky, close to where I'm from, a poor mining town in Kentucky, indicated in the survey that he didn't want to be an employee of Uber. But when over tea at a cafe in San Francisco, I asked him again why. He said to me, well, maybe not me personally, because eventually I'd like to move on to another job, but it would be nice to have paid time off though. But at the same rate, Uber's a horrible company. If they did have us as employees, they may be a lot stricter in terms of customer feedback. Maybe if a customer gave us really bad feedback, they'd fire us. His answer is much more complicated than was represented again in the survey. On the one hand, he wants the protections associated with employment status. Specifically, he wants paid time off. Our conversation troubled popular assumptions about what workers mean when they say they want to be independent contractors because of flexibility. Paul didn't mean that he wanted the privilege to work whenever he wanted to. He meant that he wanted to work whenever he could. Suffering from a mental illness that presents sporadically, Paul was on unpredictable days incapable of working. He wanted income protection during those times. That, he noted, would be a really positive benefit of being an employee. But like Rusty, he was afraid that if Uber was his employer, he would be even more at the whim and whimsy of the company, who might fire him based on a single customer's bad feedback. Historically, the test for employee status is focused on how much control a hiring entity exerts over a putative employee. But the 8 to 10 hour shift that we think of when we think about employment is a relic of factory work and the result not of employer control, but actually of massive labor-driven reform movements that sought to exert worker control over the rhythm of work. If courts conceptualize time discipline in the service economy, not by the non-existence of a shift schedule, but by how long one has to work to eke out a living, then even under the control test, the supposed flexibility of gig work weighs in favor of employee status. Because gig companies control how much workers earn per fare delivery, which fares and deliveries they receive, how many fares and deliveries they receive, and how they conduct themselves in the context of those fares and deliveries, gig workers have to work long, unpredictable hours. One astute driver told me, what flexibility? I sleep in my car, I eat in my car, I work in my car. That is not freedom. So what are the implications of these narratives for gig worker regulation? So while companies have tried to frame the debate about safety net protections for platform workers around whether or not workers want employee status, I've come to understand that this is actually the wrong question for regulators to consider, both because of the misconceptions that people have about what it entails and because of the ability of businesses to shape how workers think about these categories. For example, in the wake of AB5 and during the $223 million campaign for Prop 22, gig companies capitalized off the needs of drivers who cannot work a rigid shift schedule to both misinform drivers of the law's requirements and to mobilize fear against employee status. A better inquiry for regulators is what kinds of safety net protections do today's labor platform workers need? Extant research already suggests that Prop 22, unsurprisingly, does not match the basic economic needs of workers. Most are not getting the vast majority are not getting the health stipend. Some still labor below the minimum wage. And even others are still losing money when they work because there is no wage floor. Rather than limiting the regime of employee rights for gig workers through removal of hours-based wages, unemployment insurance, and workers' compensation. And I should note that this state, the taxpayers, were liable. Businesses that have been following the law for decades, these people bore the brunt of the UI claims that the Uber and Lyft drivers ended up filing during the coronavirus pandemic, not Uber and Lyft. And this was true all over the country. So, instead of removing these hours-based wages, unemployment insurance, and workers' comp, I argue that regulators should consider extending the scope of employment rights to include scheduling flexibility for platform workers. So something that the gig companies have proposed over and over again. They did so at first in an early September 2019 last-ditch effort to create a carve-out for themselves out of AB 5. They proposed this legislation that really had excellent language to help regulators think about how to legally inscribe scheduling flexibility for their workers. So as we think about the future of app-based platform work, my research underscores two important lessons. One, the nature of app-based work gives regulators the opportunity to grow instead of limit these benefits to account for the realities of post-industrial service work and the complicated lives of today's workers. I have no doubt that you've heard the management line that, oh, employment protections were for workers 100 years ago, and now we have these new advanced technologies, and so we need new protections. Great. Workers still need a minimum wage. They still need workers' compensation if they're injured on the job, and they still need unemployment insurance if they're laid off through no fault of their own. But now, because of these fancy new technologies, they can also have guaranteed scheduling flexibility. The other thing that I hope regulators will contend with is that despite what the survey research seems to indicate, workers need and want all of these employment benefits that offline workers enjoy. And I think that as we think about app-based service work and regulating the future of work more broadly, we have to take seriously that many workers need control over when they work, and that companies have the technological capacity to meet those needs. And it is the job of the state to ensure that they do so. Thank you. I'm happy to take questions.
Thank you very much. That was terrific. Matt, I will turn it over to you for questions.
Okay, and we just had one come in from one of our presenters, Professor Cherry. She thanks you for your insightful remarks. She's wondering how much of the uncertainty of drivers around which status to pick is partially attributable to confusion over the law. It's true that there are other areas that workers don't understand their rights. For example, most workers don't understand the at-will rule and think that they have more job security than they actually do.
Yes, that is absolutely nice. Thank you, Miriam, for your question, and nice to be in the same digital space as you. That is precisely the argument that I make in this paper, that in fact, the companies have done the cultural work of confusing workers about what employee status actually entails, particularly with regard to scheduling flexibility. And we know from broader political science work, particularly I saw a paper recently by Alex Lytle Hernandez give a paper maybe a year ago showing empirically that the vast majority of people in the United States forget about digital app deployed workers. The vast majority of the people in the United States actually do not understand what employment status actually is. It is 100% a huge portion of this is rooted in confusion over the law. And it is the confusion over the law that the companies do such a good job of exploiting when they instill fear in workers through the kind of propaganda that they use in emails and text messages and commercials, what have you. Many of us in California can tell you that the $223 million campaign that ultimately got the company's Prop 22 was replete with that kind of misinformation, the kind of conflation that you saw in the Hall and Kruger study survey, where people came to believe that, in fact, if you were an employee, that you couldn't have scheduling flexibility. I and others, including Ben Sachs at Harvard, have argued that, in fact, these companies rely on a workforce, a labor market that needs flexibility. And so taking flexibility away in its entirety would be a disaster for them. And so although it's a threat that they can certainly wield to powerful ends, it's not one that I'm sure that they would follow up on. What we saw, for example, in the New York City context, where workers are paid for all the time that they work, where there is a very simple formula to account for the fact that some drivers multi-app, very technical fixes to all these confusing ideas that people like to say make this impossible, to make it impossible to pay workers for all the time that they work. In that particular context, what Uber did was not actually limit scheduling flexibility, but limit when certain drivers and their locations could enter certain parts of the city based on their locations to start working, which is something that drivers did not like, understandably, but also things like that are responses like that can be dealt with very easily, either through regulation or preferably through a union contract.
And that actually leads well, I think, into our next question. Starts off with saying the information you provided is very illuminating. Given that New York and some other cities have been pushing some great ordinances, like you mentioned, to protect drivers, what role do you see cities in general having with your ideas?
Yeah, I think that there's so much potential for local regulation in this arena. There are two things to keep in mind. One is that what Uber and Lyft did early on is preempt local regulators in many places from being able to enact regulations. So, for example, in California, they got themselves regulated by the CPUC it's a bit ambiguous, and I have a different interpretation than some people, but the position that some of the city attorneys have taken historically in California is that because these companies are regulated by the CPUC, then that means San Francisco can't regulate, or it means LA can't regulate, because the CPUC can only be the state body that regulates them. So that for a long time prevented local regulators from doing anything with regard to the labor protections. We know, of course, that Seattle tried to extend both minimum wage protections and collective bargaining rights to these workers, which is collective bargaining rights was challenged, went all the way up to the Ninth Circuit, and now we're seeing a really terrible piece of compromise legislation at the Washington state level. And I think that piece of compromise legislation really reflects kind of what's happening here. So in New York, if you just view this from a political perspective, a political analysis, in New York, you had the New York Taxi Workers Alliance, which has been organizing drivers, rank and file drivers. This is not a worker center that just acts as a sort of a PR machine. This is a membership-based sort of undocumented union, if you will, of workers who have a lot of power, who have brought the city of New York to a standstill in their numerous strikes over the many years. They have a tremendous amount of political power, and they were able to use that political power to get drivers a wage floor, to win that wage floor, to win unemployment insurance through litigation, as workers in Philadelphia have also done. What's hard is that in other places, drivers are represented by sort of what I have called in a paper in Perspectives on Politics, weak surrogates. So Uber has done a really good job in particular of trying to divide the labor community on these issues and offering sort of carrots to certain more sort of business union type labor unions to say, look, we'll give you an active member, or we'll give you a membership. All you have to do is agree to a Prop 22 type third category, which I would argue is what's happening in Washington state. And so a lot of the potential for cities pushing these really great ordinances at this point in this regulatory fight have been deterred by either weak surrogates or by these preemptive or preemption situations that the companies themselves have created.
Thank you. Can non-gig employers advocate to protect the funds they advance for unemployment insurance from gig employee claims?
That's an interesting question. I mean, I think that one part of this whole saga that has really been underexplored is the way that this type of work creates anti-competitive markets. And, you know, in the Uber and Lyft story, they did such a good job of sort of painting taxis as cartels, as corrupt sort of mafia spaces that somehow had monopolies in cities. And certainly there are problems and were and continue to be problems with taxis, but these are small businesses, mostly owned and run by immigrant owners. And what these companies have done as a result of their incredible venture capital funding is similar to what Amazon have done, is that they create a captive market with really low anti-competitive pricing. Everyone moves from taxis and public transportation over to Uber and Lyft. And now we see they will actively, and already have in California, start raising the price in an effort to actually make a profit. In this process of being anti-competitive, and if we can understand that this is not just about Uber and Lyft, but you know, now there is a Prop 22 copycat bill for the healthcare proposition that's been submitted to the California Attorney General for nurses and healthcare workers. If we can understand that this is about the gigification of the entire service economy, as one of the venture capitalists, early Uber investor, said himself in an op-ed in The Information, then we can understand that maybe it's time for other small businesses who are worried about the fact that they are paying into UI, they are obeying employment law, basic employment laws. Why are these big fancy companies not? Maybe there is opportunity here for workers and businesses to find shared cause in fighting this monopoly or duopoly that really threatens much more than just this small sector of the economy.
And how do you think this anti-worker rights propaganda is similar or different from the 1930s anti-New Deal propaganda?
It's a really good question. I think it's remarkably similar. I think what is different is that with the new anti-worker New Deal propaganda, you heard a lot about freedom to contract. That was the language that workers had, and this was, this is the Lochner. We all have everyone individually has the freedom to contract, and to undermine that is to undermine freedom. And here, I think that we live, despite Supreme Court decisions with regard to arbitration and so forth, we sort of live, at least in a cultural context, and we understand that we all sign contracts that we don't read or understand, whether it's on our phones or whether it's in when we drop our kids off at our nursery school. We all sign contracts all the time, and maybe freedom to contract isn't all that. And instead, it's really a language about scheduling flexibility, about freedom to be where I want to be when I need to be there, freedom to meet my own needs, freedom to not have a boss. Dara Khosrowshahi, he continues to call these drivers be their own CEOs, despite the fact that these are people who are sleeping in their cars. I would say that it very much mirrors the anti-worker propaganda of the New Deal, but is enhanced to the extent that it includes this sort of idea that I present in this paper about, well, we're meeting what workers want, and we're giving people the opportunity to be entrepreneurs. It is uniquely neoliberal in that sense.
This next person starts off their question by saying your presentation was really helpful, particularly on the question of flexibility. And they wanted to know if you were familiar with the recent research by economist Juliet Schor, which found that an app-based delivery company in California, which converted its independent contractors to employee status in order to comply with AB 5, did not change its scheduling system. Is there anything in employment law which prevents companies from using flexible schedules?
This is a great question and central to this paper, that there is nothing in employment law that prevents companies from using flexible schedules. And as Professor Schor from Boston University has written in her own empirical research after AB 5 passed, a number of companies, companies that wanted to abide by the law, companies that wanted to do the socially responsible thing, they moved to treat their workers as W-2 workers, and the scheduling system did not change. And in addition to that, she notes, I'm not sure if she's noted this in the paper, but I've discovered this in my conversations with her and actually with other employers myself, that the employers are often happier because they have much less turnover. And so there are advantages. This isn't just like an employer being benevolent and abiding by the law and giving workers a minimum wage and workers' compensation and UI. There are affirmative benefits that come from having, both for workers, both for employers and for consumers, particularly in this service economy space, for having actual employee workers. There's much less turnover. There's also workers become professionalized, so they stay in the work for a really long time. They become really good at it. They're not driving you all over the place, but they are able to get you out of traffic without their GPS because their minds are better than the system. And they're not, suffering from the coronavirus when you're in the car because they have paid sick time off, and they haven't been driving for 3 days because they actually get a living wage. So I think that, in addition to Professor Schor's work that shows that the employers who switched over are able to continue to give flexible schedules to their workers, in addition to my own unpublished research findings that employers who've done so actually benefit from it and like it, I would say that there are also real advantages to consumers.
Is there a place for retaining independent contractors in this space? For example, considering the driver who uses their app-based driving gig merely to supplement their primary income, and then for companies, the costs of onboarding, payroll taxes, etc. For this type of driver may exceed the income generated by this type of driver who drives only a few times a month.
So I think that it is important to note that whether one works for many people in our economy have more than one job, right? Partly as a result of the way employment laws are structured, partly as a result of the fact that healthcare flows through employment for many people get less than 30 hours a week. And as a result, to supplement their first job, they have a second job. Often, if that second job is not in the app-based economy, that second job still continues to give them a wage floor, still continues to give them workers' compensation, might qualify for them for UI, etc. There's nothing about being a part-time worker that necessitates independent contractor status. That said, I want to point to some of the company's own figures. So they say that the vast majority of their workers are, as Tyler articulates, sort of part-time workers. What they don't say is that the vast majority of their work is conducted by full-time workers, that is, workers working more than 30 hours a week. They also, continue to say, oh, if we went to employment status, we would have to lay all of these people off, with all these people that Tyler is pointing to. The reality is that according to their own data, something like, I wish I could remember the exact number. I think it's 67 or 76, somewhere in a very high percentage, more than the vast majority of workers quit after a year. All of the workers who are doing this part-time, because it is such precarious work, and people figure out, it takes a while to figure it out, but they figure out over a period of time that, oh, actually the amount that I'm investing in this work the amount that I'm gonna end up paying in taxes, the amount the amount of time that I'm putting into it, if I calculate this at the end, it's clear that I'm earning less than the minimum wage, and actually have some shifts where I didn't earn any money. So the people who are left continuing to work in this way are people who are like essentially indentured, who bought these cars and have to pay them off. A lot of unhoused people who don't have other prospects for work, and are people who are fundamentally just don't have other options, the most vulnerable workers in our economy. And the point for those people, the most vulnerable workers in our economy, is that they are precisely the people for whom employment and labor laws were written.
That's fabulous. Thank you so much for joining this panel, which I think has been terrific. We've had 3 very different perspectives. I think it gives everyone a lot to think about while they have lunch. We're now moving to the virtual lunch session. So I hope everyone will take a minute, let all these thoughts gather in their heads, and be ready to come back at 12:15, and we will continue our program. Thank you very much, Vina. That was great.
Thank you. Take care.
So everyone can stay logged in. We're just going to turn our cameras off, and we'll see you at 12:15. So take care. Well, it is 12:15, so I think we should resume the symposium. I hope everyone had a good break and are ready for more great presentations. We're going to start now with session 3. The title is Looking to the Future, Management and Labor Perspectives. And our first speaker, talking from management perspectives, is Professor Michael Maslanka. He practiced employment law for more than 30 years before joining the faculty of the University of North Texas, Dallas, where he is now Associate Professor of Law. He's published extensive materials on the practice of employment law, and also casebooks and articles on employment law and anti-discrimination law, and in fact is a fellow co-editor on the employment law book that I have edited. So it is great to welcome my friend and colleague, Michael Maslanka.
Thank you, Jay. I appreciate that very much. How's everybody doing this afternoon? I hope you're all doing fine. Before I get started, I have problems with my vision. So if I appear to be peering into the camera or looking real closely at a piece of paper, it's simply because I'm having difficulty seeing, but it's no other reason. Oh, start my video. Do I have to say that again, Cassandra?
If you click on your video to open your camera.
I did.
Oh.
I'm here. Wait. Start my video. Okay, here we go.
Yeah, there we go.
All right, Cassandra, thank you. So I'll just start. I hope everybody's doing well today. Thank you, Jay. Thank you, Cassandra, for all your great technical help. I hope everyone's doing well. Let me just say from the beginning that, well, it keeps saying start my video. I have problems with my vision. So if I seem to be peering into the camera or looking at my outline real closely, there's no other reason other than that I have problems seeing. So thank you for your graciousness and bearing with me on this. So Jay asked me to talk about the future from a management perspective. And I wanted just to say that I practiced employment law from 1981 until I entered the academy in 2015. 2 of those years with the National Labor Relations Board, and the rest were defending companies. And so I speak from that perspective. So let me just start where I want to end up. And here's really where I want to end up. It's simply this, is I really think, and this may sound like heresy, but that companies should welcome and will welcome the ABC test. And that companies in the long run will understand that the ABC test is actually not contrary to their interests, but in their interests. Let me tell you this, from all the time I've represented companies from small companies to some of the largest multinational companies in the country. There are three things that a company really needs to prosper. 3 things.
Professor, Before you continue, Professor, I'm sorry, we still can't see you. Would it be possible to try to turn on your camera one more time or accept a request?
I'll do it again. Hold on. I see myself. The host has asked you to start your video. I'm clicking on start my video.
Unfortunately, maybe there's a technical problem we can't get past. All right, sorry to interrupt you.
Yeah, we can hear you fine, Mike, but just note that we can't see you.
All right, so all the stuff about peering into the camera and looking at my paper doesn't matter. So just know
helpful
that
color detail.
a little color detail. Just know that I'm doing this. I'm so sorry. I can see myself here, but anyways, I've hit the button. But anyways, so let me just say that my thought on this is that the ABC test is a good idea. Now, why? It's because there's one thing that companies really don't like, right? Well, one thing 3 times over: uncertainty, uncertainty, uncertainty. Companies cannot prosper in an environment of uncertainty. Companies prosper in an environment that is certain, that is definite. And for all the talk about how companies want to exploit the independent contractor status, I really think that the alleged benefits of that status are overdone. So let me just segue into the concept of what are the purported benefits of having independent contractors for a company, and what are the detriments of having independent contractors for a company? Well, supposedly the advantages are flexibility. You can plug in workers where you need workers, take workers out where you don't need workers. As a matter of fact, the use of staffing companies actually has increased 41% since the Great Recession of 2008, 2009. So companies want flexibility, and I understand that. The other supposed benefit is that you don't have to pay benefits to workers who are independent contractors, that you don't have to pay them overtime. You don't have to be subject to anti-discrimination laws. And those are all these purported benefits. But I think when companies really look at independent contractor status, and they look at the uncertainty at the determination of independent contractor status, the detriments, the downsides of something other than the ABC test actually, I think, come into light. I'll give you a few examples that I was thinking about on this. Is that the number of misclassification lawsuits have risen. Now, notice that I didn't say that litigation over whether somebody's an employee or an independent contractor is a downside. Litigation is a given in any kind of business. It's a cost of doing business. But I said misclassification lawsuits, and they have been on the rise for a long time because employers often, because of confusion, not because of any desire to exploit workers, but of confusion regarding what is an independent contractor, misclassify. I know this sounds like ancient history, but I took a look, and the Department of Labor back in 2000 and 2005 did several studies on misclassification. And they found that as a general principle here in the United States, 1 in 3 businesses misclassified employees, that they treated them as independent contractors rather than employees. I'm not talking about the exemptions. I'm talking about the concept of misclassifying someone as an independent contractor when they're really an employee. That's a downside. That's huge. 1 in 3 businesses misclassify workers with respect to these categories. And there was a 2012 audit, it was a state-by-state audit on the number of employees. And again, these are projections. Is that in 2012, the state of New York had 750,000 workers who were misclassified as independent contractors when they're really employees. So this issue of misclassification is huge. And as you know, misclassification lawsuits are class actions under the FLSA, opt-in provisions. And the damages are devastating. They're devastating. Lost minimum wage, lost overtime. They're automatically doubled because of when there's a finding of a violation. That can amount to millions and millions of dollars. And even if it's a small amount of money, even if the misclassification with liquidated damages results in a modest sum, one thing that you have to look at, of course, are attorney's fees. And there are cases here in the Fifth Circuit, I'm in Texas, where the attorney's fees are 2, 3, 4, sometimes 5 times as much as the lost wages that should have been paid. And I think that's a huge risk. That's a huge downside with uncertainty. And the other downside with uncertainty is simply this, I think, I think businesses and I think companies really do want to be good corporate citizens. And I think companies also understand a fundamental rule of business, which is this, and it's not a political statement. Somebody's got to pay for the roads, right? Someone's got to pay for the infrastructure. Money has to come from somewhere in order for there to be an environment where business can flourish. And when we have misclassification, or when we have willy-nilly designation of workers as independent contractors, what do we lose? We lose tax revenue, not by a little, but by a lot. And a lot of the infrastructure that is needed for a company to succeed doesn't get built or doesn't get repaired. And I think that is a true downside. And I also think, frankly, Professor Duval, if I mispronounced that, my apologies, made a really good point, which he talked about worker benefits. There's a reason we have workers' compensation. There's a reason we have that. It's to take care of the worker, but it's also to make companies more efficient, to patch somebody up and to get them back to work. And so I think when you look at the downsides of the uncertainty of the current status of how do you decide whether someone's an independent contractor or whether they're actually an employee, all those factors, I think, argue in favor of an ABC test, which actually is, and I've got some numbers here in a minute, which is actually growing across the country. Because if you don't have the certainty of an ABC test, what do you have? You have a right to control test. And we see again and again employers trying to get summary judgment, right, on a right to control issue, an independent contractor issue, and that summary judgment is denied. And that could take a lot. And there's a series of cases. I know in the Lawson case, Grubhub, they got summary judgment in 2018. But you look at the Cotter versus Lyft case. You look at the O'Connor versus Uber case. Summary judgment was denied in those cases, right? This is before the ABC test took effect. Because what was the right of control? The right of control has primary factors, but what gets you on summary judgment are all the secondary factors that go along with right of control. And so there's the uncertainty of, if I misclassify, if I find someone, if I make them an independent contractor, even in good faith, but they're really an employee and I seek resolution in the courts, what's going to happen? chances are it's going to get to a jury. Chances are I'm not going to get summary judgment. And I think employers are sensitive to that issue. And I think they should be. Not because, as I said, litigation is a cost of doing business, but because of the damages, the company killer damages that can exist with respect to a misclassification lawsuit. I know this might sound odd about the ABC test, but I did a quick look at it. 16 states use the ABC test, and then 38 states use some form of the ABC test. And the good thing about the ABC test, and I'm going to go, we all know what it is, but when you look at it, it really provides clear-cut, objective standards in addition to the presumption that goes along with it. Employers then know this is exactly what I need to do. This is exactly whether someone's going to be an employee or an independent contractor. And it is that certainty that I think employers need to embrace and will ultimately come to embrace. You know, when I was in practice, I would often get a question from an employer in multiple states, and it would be, do me an independent contractor agreement that I can use in all states. And it was essentially impossible to do. That sort of cohesion, that sort of unity is something I think employers really will embrace and will not come to reject. And really, when you think about it, what's the big deal? I want to talk a little bit about this thing about the gig economy, because the ABC test really takes us back to the way things were structured back in the 50s and the 60s and the 70s. Because what is a gig? Really, no, really. What is a gig job? A gig job started off with one person, with a person doing one task, one job, which is really no different than it was back in the 1980s. You have a company. The company wants to renovate part of its building, or wants to build a shed, and it hires someone to come in and to do that. This thing about the gig economy, putting aside drivers for a minute, which we spend a lot of time talking about, this thing about the gig economy is simply us going back to the future. And the concept of the gig worker has been hijacked by these transportation companies. But the essence of a gig worker is really the essence of what independent contractors have always been, which are workers in their own business. And the concept of the gig economy gets thrown around very loosely when it really is simply a return to the way things should be. It's a worker who comes and does a job and then moves on to a different job. You know, I originally been, a single project. I'm from Buffalo, New York originally, but I've lived in Texas now 40 years. And there's a story I learned when I came here to Texas about the Texas Rangers. And it's not an apocryphal story, although it's been added on to over the years. It's like in the early part of the 1900s, there was a town in South Texas. And apparently there was a riot, and it was being burned to the ground. And the sheriff went to the telegraph office, and the telegraphed the Rangers in Austin, Texas, and said, town burning, send Rangers, need assistance. And a telegraph came back and it said, be at the train station tomorrow at 9 a.m. So the sheriff was. And the sheriff went out there, he's waiting for the train, and he sees the train coming around the corner. The train's coming around the corner. He goes, oh, it's great. It's great. And, the train stops, and out stops this Texas Ranger. He's coming down from the car, and he's got his 6 guns. He's got a rifle, and the sheriff goes, oh, thank God the Texas Rangers are here. Thank God the Texas Rangers are here. And the sheriff looks around the Texas Ranger, looks behind him. He goes, where are the other Texas Rangers? The Ranger looked him right in the eye and said very quietly and very softly, one riot, one Ranger. That is the essence of what independent contractors really are. And that has really never changed, despite this concept of the gig economy, hijacking the concept of a gig economy, or the concept of the word. And I think in looking at this, there are issues that need to be addressed. One thing, and I think we can look at our Canadian friends to the north, is what happens when you get someone who truly is in their own business, right? And there's a case in the Fifth Circuit that deals with this after Katrina. There was a company, these two guys owned a company, and what they did was they repaired downed lines, right? So the transmission lines would go down, and then they'd have to go up again. They'd have to be repaired. So the workers actually, this company actually signed on with, I think it was Verizon, it might have been AT&T, to rebuild and to repair the damaged towers. But of course, the damage was so great that it turned out that this was the only work that those workers did. And they did it for 4 years. That's it. That was their sole client. And ultimately, they sued. And they sued, saying, you know what? We may have started as independent contractors, but we morphed into employees because you are our sole source of income. And therefore, you need to pay us all this overtime that we worked. Summary judgment was filed. Summary judgment was denied the company. And there were material issues of fact sending the case to the jury. Canada understands this, and Canada actually has a concept, the phrase dependent contractor. And in some parts of Canada, it's statutory. Other parts of Canada, it's case law. And I think we need something like dependent contractors here, because a dependent contractor, when your livelihood, right, depends on one entity, you are an employee. And so Canada, and there are numerous cases in the Canadian system, relying upon the dependent contractor idea. And that's something I think that needs to be, that can be fit into the ABC test as well. And I think it's something, talking about the future, that we need to look at. And I want to just sort of close my remarks by talking really also about employees. There's an article, interesting article in the Wall Street Journal, November 30, 2021, right? And it talked about the Great Resignation. All these workers, all these employees that are leaving to start their own businesses, to be true independent contractors. And some of the numbers cited in the journal article, I think, are very interesting. And it's a good article. And look, I'm going to just share a few of the numbers with you. 500,000 more self-employed workers in 2020 than in 2019, right? That's an amazing number. And the truly amazing number to me really is this. applications for new federal tax ID numbers has risen by 4.5 million year over year. It's up 56% from 2019 to 2020. And there's a company called Etsy, I never use them. I see their ads on TV all the time. They're up 2,600,000 affiliates or workers. I guess you sell things on Etsy or Etsy year over year. And so a lot of workers are leaving and they're becoming actually independent contractors, not drivers. They're becoming independent contractors in the classic sense, in the Texas Ranger sense of an independent contractor. Is that going to last? What's the future going to bring? I'll make another prediction. I think that being in business for yourself is much harder than people realize. And once you start having to pay quarterly income tax payments, once you have to file with a K-1, as opposed to the benefits of a W-2. When I was a partner in all these law firms, I was a partner, but I had to pay quarterly taxes. I was essentially self-employed. Now that I'm an employee of the great state of Texas, now I remember how great it is to have FICA, all those contributions paid 50% for by the employer, and to be a W-2 employee. I think the Great Resignation is going to recede into memory and is going to be a blip. And also because we just like to be around other people. We like to work with other people. And so the Great Resignation is not really going to be all that great. It's going to be something that's going to be historically interesting. And I think that it goes back to this concept of flexibility that was talked about earlier, is that employers were on their way to changing, right? Speaking as, I guess, looking at corporations, employers were becoming more flexible before the pandemic, not less flexible with their employees. Part of this was the ADA, and part of it was just retaining and keeping good people. And so that trend was maybe interrupted a bit by COVID, by the pandemic. But I think employers will go back to it. And I think workers, these certainly new independent contractors, will in fact be coming back to work. And so I just want to close by saying, what's going to be the future? I think the future are uniform laws. I think the future, and I don't know if it's going to be a federal law, it would be nice, but I don't think politically it's possible. The ABC test will be adopted, and Texas will be one of the last, by the way. Let me just say that I'm talking broadly, even though I'm speaking here from Dallas, Texas today. Texas will be one of the last to fall in line. But I think the financial and economic benefits to an employer of having a clear-cut test to follow greatly outweighs any of the mirage that appears to an employer. There may be a short-term benefit. You may have more short-term profits by trying to basically make your workforce all independent contractors. But that's not going to be the recipe for sustained growth, or for the growth of an economy, or the growth of a company. So I welcome the ABC test. I welcome modification along the lines of Canada with the dependent contractor concept. And I think that we're going through this phase now, but I think when we come through it, 15 years from now, 20 years from now, a conference like this won't exist. A conference like this, we won't need it, because there'll be these outliers, these hijackers like Lyft and Uber and whatnot, but that there'll be a unity in the idea of who is an independent contractor, who's an employer, and we'll move on from there. Thank you for your time and thank you for your attention today.
Well, thanks, Mike. I'm sorry that I couldn't see you, but I could hear you, and it's good to hear you. I have a question. First of all, I'm wondering if some of the platform companies might say your answer sounds like surrender rather than adaptation. And the reason I say that is, and I appreciate your point, we could argue no one may want to go to the employee status because of competitive disadvantage. But if everyone's subject to the ABC test, then wouldn't everyone be on the same footing? But the reality in California is that the companies fought AB5. They immediately sued to say it was unconstitutional, started Prop 22 in response. So I'm wondering if you could just comment on the dynamic that seems to be, although you might have the wisdom, it may not capture the strategic thinking of companies, even when there's no competitive disadvantage, as it seemed with AB5.
So that's a good question. And I think somebody else alluded to this earlier. I think Uber, well, I'll mention Uber, but I mentioned Uber and Lyft together. I think they waged an expensive propaganda campaign. And I think they convinced a lot of people, workers in particular, that, oh my God, you need flexibility. Oh my gosh, we offer you flexibility. And they sold them a bill of goods. And they did so because it's in their best interest to sell them a bill of goods. Not all car companies, there's a car company here, I don't know if you have it in California, it's called Alto. And their sales pitch is, our drivers are our employees, not somebody that we just sort of pick up off the street. I mean, they don't say it quite that way, of course. And that is our competitive advantage, because we have control over who's going to be behind the wheel of the vehicle that is driving you around. So I think this Uber and Lyft and all of this, I think it's transitory. And I realize Grubhub, I understand. I use Grubhub almost every day for lunch, I get it. But at some point, it's the tail wagging the dog. I guess I'm rambling on a bit here, but I think a bill of goods was sold to people in California regarding the great image of having this flexibility. And I think, as the earlier speaker, the professor spoke before lunch, pointed out, I don't think people really understood what they were voting for. I don't think workers really understand what they're buying into. It's not flexibility. That may be what they're sold, but it's essentially three-card Monte.
Yeah, it's funny. I had a friend who will go nameless who said, oh, I voted for the workers. I voted yes on Prop 22. And I thought, well, I'm not going to tell you how that actually lines up with labor and capital, but I think it was confusing. Matt, I'll turn it over to you if we've got some questions queued up. Everyone, we've got a management side lawyer who's saying the ABC test is not all that bad, which is an interesting angle. So fire away with your questions. Go ahead, Matt.
Well, this question comes from Professor Cherry, which is a comment and a question. She says, note that the dependent contractor in Canadian law was proposed by Professor Harry Arthurs in the 1960s to address protections for the weakest of self-employed workers. The category of dependent contractor today in Canada means that the workers in that category get nearly all of the rights of employees. It provides more benefits, like the ability to join a union and collectively bargain, than what is held out by Prop 22. What are the dangers of creating a separate category for gig workers?
I didn't hear the last part of that, Matt.
What are the dangers of creating a separate category for gig workers?
I think part of the danger is that, and I like the idea, by the way, of a dependent contractor concept, is it starts to, again, interject uncertainty. Well, what is dependence, right? What does dependence mean? How do we measure it? And so it can turn into a bit of a, you know, you're waist deep in the big muddy, so to speak. But even though there are downsides to it, I think it plugs a hole that needs to be plugged. And that's why I gave the example of those two workers who had their little company out in on the Gulf Coast repairing transmission lines. So there are dangers with their subjectivity and uncertainty. And I've been reading up on Canadian law on this. But I think despite some drawbacks, I think overall it's a really good idea, and it prevents exploitation. And frankly, you know, I think about this case, the Fifth Circuit case I was talking about. An employer can easily be proactive. A company can simply say, "You've been doing this now for 6 months. Let's renew our original agreement. You confirm that you're an independent contractor, that you can work for other people, that you've made an economic decision simply to work for us, AT&T, and that is your decision." So there are ways to deal with it other than dependent contractor status. But I like the idea of a dependent contractor. I think it's a good idea.
And one thing that I've been sort of thinking about through a lot of the presentations today, and you and Professor Moots kind of touched on it, sort of goes a little maybe outside the management perspective, but one thing I wonder is the question of Prop 22 appropriate for a ballot initiative placed before the voters? You said, I think that you weren't really sure that people understood what they were voting for. And so then my question is, I mean, I know Texas has ballot initiatives as well. Is this really even appropriate for to be placed in front of the voters?
Yeah, so Texas really doesn't have the ballot initiatives quite the way that California does. Our legislature meets every other year, and then only for like 180 days, if that, and it was designed that way. I think, I'm not sure, I don't think it's a good question. I really don't think these sorts of issues should be decided by popular vote, really, because there's a lot that goes into deciding what's right, what makes the most sense for society as a whole, as to whether we're going to have something like the ABC test, right? And it just this whole notion about the tax revenues are lost, right? Fine, everybody's got flexibility, but nobody's going to be able to drive on a road without hitting a pothole. So all these Uber drivers and Lyft drivers can be driving all over the place, but you know what? There's not going to be enough tax revenue to make it a smooth ride and not a bumpy ride. It's not going to happen. So I think there's certain things that maybe you want to have a ballot initiative on, but not something that essentially goes to the heart of how an economy runs.
Mm-hmm.
And it's interesting. Yeah, I just don't see it. I just don't see it. That's why we have ideally a legislative process that can consider various factors and try to make a reasoned decision.
And I also think it was really interesting. You brought up, the intersection between the Great Resignation and independent contractors. And I think Professor Moots brought that up too. And I think you were saying, well, I think flexibility is going to come back. How do you see that? Do you see employers, one question I asked earlier, if somebody, will employers start offering what these service-based apps are offering, or how do you see that flexibility coming back and changing in the future?
I think this. I think, and don't get me wrong, I think, I wish we didn't go through the pandemic. I think it's a terrible thing. But I think I'm going to analogize it a bit to a near-death experience. Okay, I've never had one, don't want to have one. But I think corporate America has gone through a little bit of a near-death experience with the Great Resignation, because it is hard to get people to work for you now. That is the memory that is going to be imprinted on corporate America. It's tough. And you know what? Maybe we should rethink how we treat employees. Maybe there's a reason they left, that we weren't flexible enough when COVID hit. So I think this sort of near-death experience of trying to, and I don't know how it is in California, but in Texas, it's very hard. Places are closing down here, or limiting hours because they can't get the workers. And I think that near-death experience actually will teach a lesson. And I think we'll see better workplaces and more humane workplaces, Matt.
Yeah, I hope you're right. And I also think it accelerated a lot of trends that were already happening. I worked a lot as an independent contractor, not so much in a gig economy sort of way, but in terms of like remote working, a lot of things that I was working in tech, a lot of things that were happening there really started to filter through because they were such an obvious quick win in the pandemic.
Well, thank you, Matt and Mike. I appreciate your presentation. We're going to shift gears to the worker union perspective. So you didn't set up too much of a straw man, Mike, because you were willing to concede the ABC test in the long run is beneficial. But we may have some additional considerations from the worker union perspective. Proud to introduce, or pleased to introduce Caitlin Vega, who co-founded the union side lobbying and campaign firm Union Made after serving as legislative director of the California Labor Federation. As a labor lawyer, Caitlin specializes in legislative efforts to combat misclassification and to address the fissured workplace. In particular, she worked for the enactment of AB 5 by the California legislature. Go ahead, Caitlin, the floor is yours.
Thank you so much for including me in such a wonderful day. I have learned a lot and really enjoyed all of the discussions. I have to say, I think the professor's presentation that we just listened to may have been one of my favorites, because I have yet to hear an employer representative speak about what I truly believe and agree are the benefits to employers of the ABC test. So that was really refreshing. And I was glad that you talked long enough that I found a couple things to disagree with, because so much of what you said I thought was very profound and really rang true. I have found, as a labor lobbyist for the past almost 20 years, that oftentimes the employers, I think, take positions more rooted in ideology than in practical, than in what is practical and workable, and in many cases in their actual best interest. And so I absolutely agree that having a simple objective test like the ABC test has many benefits for employers, especially in terms of addressing unfair competition. One of the problems we have in this area, and one reason that you often don't see, a little bit of misclassification, you see industries go from a predominant employee model to a predominant model of misclassification is that when your competitors are cheating and when they're misclassifying, they save so much money that it becomes impossible to compete using the employment model. And so I would agree that having the ABC test in place helps everybody figure out how to follow the rules. And it also ensures that there's a lot less game playing because it is a simple, straightforward, objective test as opposed to the right of control test, which is a lot more complicated. But because we agreed on so much, I will step back a little to talk about just this idea about what is the future of the gig economy. I always like to start when I'm on presentations about the gig economy by saying, I don't think there is a gig economy. I think that calling people gig workers or calling companies gig companies was part of a campaign by those companies to pretend that they have invented something new and to act as though gig work or gig workers are somehow unique and different from all other work and all other workers. And in fact, I don't think that is the case. I believe former Assemblymember Lorena Gonzalez spoke in her presentation about the historic roots of employers seeking to avoid responsibilities for their workforce, whether that's in early sweatshops or many other forms of labor contracting that were intended to insulate the company that makes the money from the people actually doing the work. And we have seen in the last few decades, as union density has declined, and as as our economy has shifted into more of a service sector and less of an industrial-based economy, we've seen that these trends really accelerate, where companies have looked to build kind of a contingent workforce, to use contracting out, to use third parties who serve as the employer of record, to further distance themselves from what happens to their workers. We saw, to use one example, in the trucking industry, with trucking deregulation, a move almost industry-wide from an employment-based model to an independent contractor model. And we saw incredible levels of exploitation and abuse under that new model. And so misclassification, of course, is nothing new. It's something that the labor movement, I would say, was founded around challenging this idea that companies are not responsible for the laborers who do the work. And certainly over the last several decades has been a very high priority for the labor movement. And so I personally started working around issues of misclassification in trucking, in janitorial, and in construction, to name a few, and searching for ways that we could better enforce the laws. The ABC test is great because it is simple and objective, but we often like to remind people that in most cases, it doesn't matter what test you use. In the vast majority of cases, it's very clear who the worker is performing work for. The worker's not setting their rates. They're not in charge of the way they do their work. They can't cut their own deal with the customer. And so in most cases, it's very clear. And another advantage to the ABC test is that it's easier to enforce. So it's like we might win in the end, but if we have to go through the drawn out litigation of proving 11 factors, it's much easier for the employer to be able to change one thing and get away with misclassification or continue misclassification than when you have a shorter, simpler test. But these were all of the fights that have been going on over the past few decades. And then, of course, the tech companies came along with this idea that there was a new kind of economy called the gig economy. Again, not very different from the rest of the economy, the same kinds of labor practices, but this was unique because it involved an app. And I think that's one of the most important ideas for us to challenge and reject, that the rights of workers should be afforded have any connection to the type of technology that is involved in their dispatch. We look at a lot of industries within the labor movement, whether it's Teamsters going from horses to trucks, whether it's, the telecommunications industry and all of the different forms of technology that workers have had to master and use, whether it's jobs that involved hiring halls or telephones, or workers to show up and line up in the morning to get work, or the use of an app. None of that has any bearing on whether that worker deserves rights, whether that worker deserves to be paid for all hours worked, whether they should have access to the safety net benefits that are attached to employment, like unemployment and workers' comp, and whether they should have the right to join a union. So I think just as a starting point, it's really important to think about why the companies have pushed so hard to persuade us that there is a gig economy, that there is a type of gig work that needs to be regulated differently than all other work. And that was really a central premise in the work we did on AB5, was to reject that distinction and to say that all workers should be subject to basically the same protections. Now, another interesting piece of what the gig economy, in quotes, has done is that they have suggested that they are the solution to the problems in the rest of the economy. So as union densities declined and as our economy has become more dependent on low-wage jobs, you have workers working in jobs that are part-time, that have no hours guarantee, that have just-in-time scheduling. And all of those have created a situation where it's really hard for workers to know what they're going to make, what they're going to earn in a week, whether they'll have enough money to pay bills, what kinds of, it has required a level of flexibility because workers are, working at Walmart waiting to see each week how many hours they're going to get. So the gig economy or the big gig companies come along and say, we have a perfect solution for you. It's not making more money in your hourly rate. It's not having a guarantee of hours. It's not having scheduling predictability. It's not doing anything to improve job quality. It's giving you the opportunity to work a second, even lower paid job where you only get paid during certain times that we deem appropriate. But we are now the answer to providing economic stability. And so I think that's another reason that it doesn't make sense to separate the gig economy. I think this work model is very much, and it could only prosper in an economy where workers have been devalued, where workers have lost unionization, and have very little bargaining power, to where this is what we're made to feel like we have to accept as a viable option. This whole notion of flexibility being workers' lives are going to be so hard and terrible, they have to be willing to work at night or on the weekend in order, a second job in order to make ends meet. And the companies did a whole kind of campaign around this idea, around the idea of, every job is just a side gig. It's not your real job. It's a side hustle. It's not what is actually supposed to pay the bills. And I always think, well, what if every job wants to be your side hustle? How is anyone supposed to make a living if that's the kind of economy that we're moving toward? So what does that mean for the future? AB5 was our attempt to say, we need to, and I think as former Assemblymember Gonzalez pointed out this morning, it began with the California Supreme Court unanimously saying, we need to rethink the way that we're organizing work. That case actually involved delivery workers delivering from their cars. It was very close to a gig economy case, although it was not one of the major companies that we talk about. But what they said in that case was really, we all know what's happening here. We have a worker delivering packages out of their own car that the company, gives to them and tells them how to deliver, sets their rates, gets to choose who gets work. They're clearly employees. And so with AB5, we codified that decision and we said, yeah, the ABC test, very clear. You're working under the direction of the company. You're doing the regular work of the company. Excuse me, and you're not your own business. Very clear, you're an employee and you deserve to be protected. And there's no reason that should be any different because you were dispatched by an app rather than any other form of technology. As everyone knows, the gig companies refused to comply with that. They had spent many years up to AB5 ignoring and violating the law, using forced arbitration to prevent drivers from being able to take them to court in a meaningful way to address misclassification. And they were very clear with us around AB5 that if they didn't get their exemption, they would go to the ballot. And as I think was mentioned earlier, it was the most expensive campaign in American history, based entirely on the amount of money that the companies spent to buy their way out of labor laws. So now the labor laws that apply to virtually every small business, medium business, every other company in California no longer apply to them. So what do we do now? First of all, that proposition may very well be held unconstitutional, and we would return to the status of AB5, ABC test applying across the board. That would be an incredible victory for rideshare drivers and delivery drivers who have been essential in this organizing all throughout. We're very important to the passage of AB5, have fought very hard to assert their rights under AB5, to file wage claims, to demand that they be reclassified, and who continue to fight. But I want to raise the other kind of the other alternative. If that doesn't happen, if we aren't able to show that we can have one set of laws that applies across the board to all workers, the other alternative we see looming out there is this idea of a third way. As soon as Prop 22 passed, the companies they had created this, coalition for independent work kind of organization. And they immediately said, this is the future of work. We won. This is going to be the future of work. And we're going to launch campaigns across the country. And what we're going to do is we are going to create a type of worker hired through an app, statutory contractor, regardless of the amount of control that is exerted by the employer, some sort of portable benefits, which are of course much cheaper and less protective than the kinds of benefits that employees have. And this is going to be the model for the future. Right now, we see that being proposed in a number of states, but it's being proposed explicitly for rideshare drivers and food delivery drivers. So that there's so much that's harmful about that model. I think people focus a lot on the lack of access to unemployment and workers' comp, or to sick leave, or to other kinds of employee benefits. I think there's something even more basic, which is that these companies have come up with this scheme around, what counts as productive time and when workers deserve to be paid. And of course, this was not invented by the tech companies that do rideshare or food delivery. We see this happening. This is very widespread in trucking and in courier services, where workers are only paid under certain circumstances. No one is responsible, as an independent contractor, no one is responsible to pay you for every hour worked. And the implications of that are really profound. I think somebody asked in the Q&A about downtime. So for Uber and Lyft drivers, it's generally thought of as about 40% of your day. You don't have a passenger in the car and you're looking for rides. For port truck drivers, you're only paid once you have the load. You're paid by the load. And so port truck drivers are often required to sit for, hours and hours with their engines idling at the ports, waiting to get a load. There's no incentive to make it any more efficient because no one's paying them for their time. And so the end result is that oftentimes they owe the employer more than they get paid in a week. Because they have to pay the costs and maintenance of the vehicle, and they're not paid for all hours worked. So that's a really insidious piece of this so-called third way, which I think has very scary implications for other kinds of workers. I think back to the years I spent doing restaurant work and I kind of imagine, what if you weren't getting paid when there wasn't a customer? Like the whole premise is, this is your work time. You're available to work as needed by the employer. If you were only paid when there was enough customer demand, it would significantly reduce what workers earn. And it would be a real departure from the idea that when you are making yourself available to the benefit of your employer and able to do work, that's time that you should be getting paid for. So it would really, destroy some of the most basic tenets of employment law and worker protections that we have. So as I said, we see these laws being proposed specific to drivers, rideshare and food delivery, but we know that no one really wants to stop there. We know these companies want to expand into public transit, for example. They want to expand into medical transportation. They have already expanded into healthcare, into construction. Virtually any industry, there's an app that dispatches workers. And so I think it's going back to this idea about whether there's a gig economy, this is really about what is the model of work going to look like? And is this really something that we as a labor movement or, as people who are policymakers and work on these issues, is this something that we are willing to settle for? I look at, what so many of us saw over this pandemic. And, from a labor perspective, I think we very much saw workers in so many industries, frontline workers, people who were never able to work from home, who were treated as though they were disposable, who were not warned about coworkers that had COVID, who were not provided PPE, who were not allowed to use time off to isolate when they were sick. We saw so many of those kinds of abuses, and there have been a series of bills intended to address some of those issues. We worked on a bill to require notification of workers that they've been exposed to COVID, or to require COVID-specific sick leave. So we saw that even employment status and the existing protections were insufficient to protect workers during the pandemic, and we needed to add on additional protections. And yet we are continuing to allow there to be a category of workers that has no access to any of that. And so in a way, the gulf grows even bigger between, employees and so-called gig workers who aren't entitled to any of those kinds of protections. So when we talk about what the future will be, I think we're at a crossroads. And I think that, I found the comments from the professor who spoke previously about the Great Resignation very interesting. I think, another way of looking at it is that workers were not willing to accept those fundamental threats to their safety, the safety of their families, that they were confronted with during COVID, particularly for the low wages and the, low job quality at far too many jobs. And so I think the challenge we now face as a labor movement is, are we going to fight to rebuild the economy that once provided more long-term employment, high quality jobs, jobs with healthcare, jobs with pensions, jobs with unions? Or are we going to accept a new second tier category of worker who doesn't get any of that? And I think that, as we grapple with that question, it's very important to go back to the point that there's no walling off one kind of worker or one kind of job or one kind of economy. The conditions that we accept within one sector will inevitably bleed into other sectors. The idea that technology should dictate the kinds of rights workers have, once we accept that premise, there is nothing to stop the growth of app-based companies in every sector, dispatching a cheaper workforce with fewer rights. And I think that, the challenge we face and the mandate we face is to figure out a better future of work, where we're raising standards for everyone rather than accepting that second-class status.
Thank you very much, Caitlin. I appreciate your presentation. I'll take the speaker's prerogative and ask a quick question. You may not want to give away any secrets, but what does Union Made have on its agenda looking forward on this issue? Or does everyone need to wait and figure out what's going to happen with the constitutional challenges to AB 5 and Prop 22?
That's a great question. Without giving away any secrets, I would say, we do a lot of work around misclassification and abuse of temp workers and contract workers. So I think that will continue to be part of our work. But I think a really big missing piece is that I think, someone raised earlier the idea of like whether AB 5 worked when it was in effect. And, so the speaker reminded them, actually, AB 5 is still in effect for the vast majority of workers, even app-based workers. And so I think one really important thing for us to do is to show that it works, to use it, to enforce it, to hold employers accountable. Because when we were working on AB 5 and close to enacting AB 5, we started hearing from companies that they were starting to look to transition. In fact, big companies were looking for small companies that used employees that they could contract with rather than companies that misclassify. There was a little bit of a shift that was noticeable. And then the tech companies, qualified Prop 22, and all of a sudden things started to shift back. And I think corporate America started to say, oh, well, maybe we, buy our way out of it this way, either through the proposition or we try to come up with other ways to get out of the law. And I think if we do some smart strategic enforcement, we can show that that law works, that the outcomes are fair and reasonable and prevent unfair competition. And so, I'm very hopeful that we can, now that we're hopefully emerging a little bit from the pandemic and can be thinking about how we fight for better job quality in this state and challenge the, epic levels of inequality that we see today, AB 5 remains a really important tool that we can use to try to improve people's lives. So I hope that as we look up for ways to strengthen laws, which is a lot of what I do, we're also making sure that we think about ways to enforce some of the good laws we have on the books, including AB 5.
That is great. And real quickly, I know Matt has some questions to ask from the crowd. I loved your analogy to the hiring hall and the idea the gig economy is nothing new, but nobody ever argued that the hiring hall itself was an employer. And doesn't Uber just say, we're a hiring hall, but whoever thought the hiring hall was an employer?
That's a very interesting question. I'll just throw out that I do some work with some of the entertainment unions that also have that similar model. I think both in the entertainment sector and in the construction sector, you can see ways that unions have made gig jobs good union jobs. And some of that does involve things like within the entertainment sector, like a payroll company serving as an employer of record so that they can aggregate wages and benefits from different employers. Sometimes it's a question of how you structure it like that. Obviously, a union-run hiring hall has negotiated agreements with the employers that they're dispatching workers to. So they are a dispatcher rather than an employer. Certainly that would be, we have seen before EB5, we saw the attempt to do bills that said basically, they called it a marketplace and a marketplace participant. They said any worker that uses a marketplace to find a job is a contractor and the marketplace has no role. We tried in AB5 to really hone in on these ideas. There's a section on referral agencies. We believe there are entities that simply act as a referral, that are matchmakers, allow two entities to find each other. I think, again, the professor made a really important point around true independent contractor status is really simple. It's basically being your own business. An entity that wants to be their own business should be their own business, and they should find ways to provide services and others should find ways to contract with them. That's all kind of implicit in what we think independent contracting means. Where that falls apart is where you have individuals who are not their own businesses working for a company that not only determines what they will charge, half the time doesn't tell the worker what they're even going to be paid for the work they're doing. And so really, I think Uber and Lyft are not even a close case. They are so far to the extreme of dictating, whether the worker gets to know the destination. The rates constantly change. Sometimes the worker can find out ahead of time. Sometimes they can't. They, remove workers from the app when they determine that they deactivate them, as like an employer fires somebody or denies them work. In every traditional test or indicator of employment status, they are absolutely 100% running the show, controlling the work. And so I think, you raise the question of the hiring hall. Our perspective was always that you could come up with interesting ways to help connect people who want to do a job to people who want to pay them to do a job. There's certainly a role for, an entity to play in being a matchmaker or a way for them to find each other, but it's not through controlling the transaction and setting the rates.
Right. It reminds me of Uber giving the ability to drivers to negotiate the rates until Prop 22 passed, and then they took that.
It was amazing. Yes, they got significantly better on a couple key things for about 2 months, and then it all vanished.
Okay, I'm going to turn it over to Matt, who's got some questions queued up for you. Thank you again.
This questioner says, great presentation. The points you are making about misclassification are very compelling, but given the deep pockets of the gig companies, what's the best way for worker advocates, unions, and others to fight back against these carve-out campaigns? And what did we learn from the Prop 22 experience?
I think that's a really important question, because we definitely hear from unions that they're concerned about how much the companies are willing to pay to buy their way out of labor laws. And I think, I don't know if it's a cliche to say you can't negotiate with terrorists. Like, how can you negotiate with people because they say we will outspend you and take away all your rights? Like, how can you think that that is an entity that you can trust to negotiate the terms of workers' lives with? I just think we have to, as a movement, reject that. We have to find ways to build power and to fight back, and not to allow ourselves to be so fearful of those campaigns we cave, because ultimately, you know, we're in this moment where you have Starbucks workers, you know, organizing across the country. We just had a wave of strikes. We're seeing both union and non-union workers really feeling inspired to fight for better. There's this moment where the labor movement is so popular, where people want to be part of unions and believe in what we stand for. We have to stand for it. We have to say what we represent. We have to stand for the vision of worker power that the labor movement was created to fight for and defend. And if we settle for less than that, why would any worker want to be part of our movement? So I think, I know the money's scary. It's scary. It's a lot of money, but we have beat big money many times in many ways before. Labor's power has always been through our ability to organize and knock on doors and run great campaigns and tell good stories and put workers front and center, talking about the real impact on their lives. And we lost Prop 22 in California. It was the worst thing that could have happened in this whole fight. It was terrible. But we can't allow what, like, before we lost, we won. We won AB 5, which everyone said we couldn't do. We were told, you have to cut out the app companies. You'll never beat them. You'll never be able to, you know, win against them. We won, and then we lost, and we're going to win again. And we have to be willing to be in the fight. We have to be willing to lose sometimes, and then we have to get smarter, learn our lessons, and come back and win the next time around. But if we give in, then what is our purpose and what do we stand for?
Oh, yeah, thank you for that. This is not exactly the same issue, but how do you feel about platforms like Fiverr that require individuals to begin selling their professional services for $5? This talent is exploited by other small businesses.
I learned so much on AB 5 about so many different kinds of platforms that do all different kinds of things. And I think I don't know enough about that one to speak very specifically, except to say that, you know, what I have learned in the world of misclassification is like, so misclassification is almost always like a scam or a fake out. So before it was about apps, you know, we had workers who were getting told they had to, they would be reclassified as vice presidents of the company. And then that was a way that they were not employees and didn't have any rights, or they had to sign LLC agreements. I mean, we would have instances. There was a famous one where a group of garbage delivery driver or garbage pickup drivers, you know, they were all called into a meeting and they were all required to sign independent contractor documents and say that they were each their own garbage delivery service. There's always this element of kind of this fake out, this way of like, we're going to pretend you're actually a separate business. There's always a scam. We saw in the JamPro case, which involved janitorial franchising, the use of the franchise model to disguise misclassification. And when we were working on AB 5, the franchisors came around and said, you need to exempt franchises from AB 5. And what we really tried to say was, there is no one business model that's exempt from misclassification or that somehow, you know, better than others, just like there's no real business model that is inherently abusive. They are all just different ways to structure, and all can be used in a way to exploit workers. And so I would say there's a lot of those kinds of scams we tried to sort through. There's, you know, all the pyramid schemes of different ways of selling things. And, you know, it's complicated how much of that. There are some that are more like an abuse of a little business than they are an abuse of a worker. And we tried our best in AB 5 to figure out, you know, where to draw those lines and who we are most charged with protecting. But, you know, it's the variation on the ways to do this and the ways to maximize profits off somebody getting underpaid are varied and complicated, and we're constantly seeing new kinds of examples that probably need specific types of regulation.
And I think besides agreeing on the ABC test, I heard you sort of agreeing with Professor Maslanka on the idea that these tech companies, at least named a problem and then, told people we have the solution, perhaps maybe even created or framed a problem and told them, hey, we're the solution. And it sounds like you think, the economy is kind of, heading in this direction. Are we concerned? I mean, you were saying, you sort of, said, oh, I'm afraid to say negotiating with terrorists, but hey, look at all this money that they're spending. When we're up against, or this movement or whatever is up against such spending, and it does seem to be kind of like a us versus them, it's a fake out, they're selling us something. Are you worried about the tone, or how do you think that tone affects the discourse when, for instance, there's people who, hey, my cousin drives for Uber and he's not sleeping in his car and life's moving well for him. How do we, reconcile that for people who don't, aren't predisposed to see it?
Yeah, I mean, I think my sense is that there is a huge feeling of discontent with the state of the types of jobs that are available, the lack of job quality. I think a lot of the, again, this idea that Uber's meeting people's needs, I think is a lot based on the fact that there's so much more we need to do to make all jobs better. Because it's true that if retailers are not required to provide you with a weekly schedule ahead of time and can make you come in anytime, then you're having to find ways to pick up extra hours on the side. And so there's nothing inherently wrong with the idea that a worker would say, well, given I have this situation here with my principal job, this is what I have to figure out with the side job. Those are, no-win situations that workers have been put in because of the lack of bargaining power in the economy. And certainly there are people who like doing those jobs and who do them as side jobs, just as there are people who, the majority of the rides in rideshare are done by a small group of drivers who work 40, 50, 60 hours a week. I think our job as policymakers is, and people who think about policy, is like, it's our job to make sure that work exists that allows people to provide for their families, that allows them to have access to healthcare, that has employers paying into the UI system rather than taxpayers having to subsidize that. It's our job to ensure a basic level of job quality and that those kinds of jobs are available to workers who want and need them. If people want to choose to do side gigs or work as contractors, whatever else, everyone's free to make their own decisions about the jobs that work best for them. It's our job to ensure there is basic job quality, there are good jobs available. And my belief is that the vast majority of workers want those jobs. I know that a lot of work we've done around polling, particularly of young workers, is that what workers really most want is stability, economic security, stability, these things that young people have been told they no longer have the right to expect. And so I think it's our job to deliver those kinds of jobs and to fight off a predatory business model that undercuts those kinds of jobs. I think that's the challenge. You can't say, well, Uber and Lyft get to break all the misclass rules, but yet we're going to make sure that UPS has to keep providing these great union jobs where it's full family health care and the ability to retire. Those are not compatible concepts. As long as we're saying some companies get to, not even pay workers for all hours worked, let alone any of those other kinds of benefits, we are in a race to the bottom. And ultimately those are going to be the only jobs we end up with unless we figure it out.
And I hear you saying, the labor movement has to stay in the fight, and hey, the legislature did something, but that got sort of undermined or what have you. And there are still some, challenges in the courts. Obviously, the labor movement has to keep fighting, but do you think, and I'm asking you to predict, and obviously that's unfair, but do you think you can rely on the courts to end on the labor side?
No. I don't. I think we have to, I think, depending on the topic, I think Prop 22 is unconstitutional, and we may be able to rely on the courts for that determination, because that's a determination based on our state constitution, and that will be state courts. And I have a fairly high level of trust that that decision will be upheld by our state courts. Certainly we have, the Supreme Court that has gone, the US Supreme Court that's gone out of its way to interpret issues contrary to the interests of workers quite frequently, especially in issues, things like forced arbitration, where they have extended the reach of forced arbitration far beyond what it was ever intended to be. And that's been a huge limitation on the ability of workers to exercise their rights. So I definitely would not place our faith in the courts. I think we have to place our faith in ourselves and in the workers, and in this, resurgence of labor activism, as I think people have, reevaluated their lives and their jobs and the way they spend their time, and workers want to have more power on the job. And I think if we place our faith in that, we'll end up somewhere good.
Okay, well, thank you very much, Caitlin, for a great presentation. We're going to take a short break until 1:45, and we've had consistently over 120 people logged in. Don't go away. We have a great final panel on comparative perspectives that will look at other states and the federal government, EU approaches, and international outsourcing. So we will be back to resume at 1:45. Coming back for the fourth and final session today. Thanks for hanging in there with us. I think the speakers have been fabulous. We now have 3 more presentations, which are interlocking. They're comparative approaches. And I will give a plug. They're not our formal sponsor, but we have a great international group here at Mcgeorge. And so this comparative international angle, I think, is very important. The first paper is Comparative Perspective State and National. Miriam Cheery is Professor of Law and Co-Director, William C. Weffel Center for Employment Law at St. Louis University School of Law. Her interdisciplinary scholarship focuses on the intersection of technology and globalization with business, contract, and employment law topics. In her recent work, Cherry has focused on the role of virtual work in the economy. Miriam, it's great to see you again, formerly on the faculty at Mcgeorge. I give you the floor. We can't hear you.
How about now?
There we go. Thank you.
All right, there was a setting that needed to be adjusted. Well, thank you so much, Jay. I really appreciate the invitation, and I've been lurking here throughout all the speakers today and have really enjoyed them. I will also say, Jay mentioned that I was formerly on the faculty at Mcgeorge School of Law, and so actually the last place I went to a conference was at Mcgeorge, and I got to enjoy seeing some of my former colleagues and speaking. We were in the Gordon Shaber Library, and so I think very fondly of my time at Mcgeorge. I'll also just say a quick thank you also to Dean Michael Schwartz, who introduced the symposium, and thank you also to Matt Urban for all of his work, and to the other editors at the Pacific Law Review. Thank you so much for organizing today. So it's interesting to think about how this panel is set up. I think in some ways we've been focusing really on California. We've been focusing really on California law. That's because California law has had so many interesting ups and downs and twists and turns during the past couple of years when we think about the regulation of gig work. But I think in this panel, we're really scoping outwards. And so I'm going to talk about some of the other states and some of what is happening on a national level. And then we're going to scope out even more to look at the EU and international perspectives. And so I'm super excited about that. So I am going to keep my remarks a little bit shorter just because I know we're getting towards the end of the day. And some of the things that I was planning to talk about, we've already covered. So I'll share my screen. And here we go. So this is my contact information in case anyone wants to get in touch with me after the symposium. So I've been writing about this topic, about the on-demand economy, as part of a larger focus on technology and work and how technology is shaping and transforming the way that we think about work, the way we perform work. And so I've been writing about the gig economy since 2008, 2009, and that was before Uber and Lyft really, before they existed. And so we were talking a lot more at that time about forms of crowd work that existed in the ether in terms of people doing computer crowd work, and the idea that work would be coming to you on your phone. And so these were some of the things that I would talk about, and at the time, until those platforms really took off, it all seemed very futuristic. And I think today it's just becoming more and more common and part of an understood acknowledgement about how work is going to be performed. So as other speakers have talked about, and I teach in St. Louis now, so I had to include a picture of the Gateway Arch here, but I do think that classification is a gateway issue for all of those rights that we've been talking about throughout the course of the day, whether that's minimum wages, union membership, disability accommodations, and we could go on. And the confusion, I think, had originally arose back in the early part of the 2010s, and that's part of the use of independent contractor in the labels on websites and apps, the boilerplate that, as previous panelists have talked about, that people rarely read. And then the confusion became the fact that gig work had some aspects of independent contracting type work, but they also many of these forms of work had a connection to the employment relationship. And so this led to confusion, and we've already talked at length about the gig battles of California and certainly what's been going on with Proposition 22. So I'm going to shift to the comparative view between other states and then what's going on nationally, and then I'm going to talk more about how, and I think we had a foreshadowing of this in the last panel, but how the pandemic might actually, this is a bit provocative, but how the pandemic might actually help us to fix the problems of the gig economy. All right, so I think we've talked, there's a panel on which this was talked about, but the ABC test is actually a pretty widespread test throughout the United States and often used for determining unemployment compensation, unemployment insurance. I think the other piece that's interesting, though, is that there's been attempts at change around legislation that would change the definitions. So in some instances, the definition or what test we use, there could be questions about if a test is more leaning towards finding employee status, as the ABC test is, then in a sense, it's pushing towards a particular outcome. Whereas in some other states, there was legislation that was introduced that I'm going to talk about that was part of transportation network codes. So there was legislation that was put together in many instances. The template was put together by many of the platform companies as a way of making sure that their companies were authorized to do business in particular states. And so within these transportation network codes, it talks about how the drivers actually should be classified as independent contractors. Now, what effect that has on the state law really is up in the air, right? And in many of the states where this legislation was pushed through. The idea, I think, behind this was to authorize the ability of the companies to do business, because there were originally some problems with licensure and insurance and so forth. But then this definition kind of crept in, and the question remains, I think, is this is this a back door? Well, I'm going to talk about some other jurisdictions that have attempted to regulate the gig economy in a way different than the initiative process that has unfolded in California. So for example, we could turn to the New York City Council, and this just happened, right? This is the end of 2021 in November. The New York City Council passed 6 bills that were focusing on delivering basic rights to gig workers. And we had some reference to this by Professor Vina Dubal as well. But these bills were not actually concerned with the question of gig worker status. Instead, we were trying to get at other issues, I think, that have been important or have been of concern to gig workers. And so those include things like minimum wage standards, and including the time that the worker is logged into the app, not just the time that was spent, not just the time that's spent actually doing the particular task. I think Caitlin Vega referred to that. The interesting piece about tip baiting, this is a practice in which customers are allowed to leave a tip, and they can put a large amount, but then they can edit the tip down. And there are some instances where this has really been deceptive and problematic. And then finally, this seems like a very basic thing, but access to bathrooms, which during the pandemic, gig workers have been excluded from using restaurant bathrooms. And so this was an attempt to really get at some of the basic rights, but it didn't address this question of status. Well, meanwhile, we have questions also. So looking out at other parts of the country, we could also talk about Austin, Texas. So this was an interesting back and forth that did involve a ballot initiative. And in fact, there, Austin was requiring particular safety measures, such as increased insurance and background checks for drivers. And Uber didn't like that, and they threatened to withdraw if those were to come into place. But the voters overwhelmingly said that they wanted those kind of requirements. And as such, Uber ended up leaving the market in protest. But now they've adopted these requirements actually around the country. And so they've snuck back into Austin. The last jurisdiction I'm going to talk about is the city of Seattle. So in 2015, the city of Seattle wanted to establish safe days and sick days for rideshare drivers. And their solution was to try to allow rideshare drivers to join a union, to become part of a union, and to be able to bargain collectively. And that's what they saw as being maybe the ultimate or being a check on the power of platforms. But this sounds interesting, right? Maybe that's the way to even out the power differential, but this has ended up in court. It's never been established. And part of this, I think, is just this question of preemption under the National Labor Relations Act. And so the Chamber of Commerce got involved, and this has been tied up in court for many years at this point. So this hasn't come into fruition. But I will say there are some developments on the national level. And again, previous speakers referred to this, but under President Trump, there was an NLRB advice memo that said gig workers are independent contractors, but the Biden Department of Labor has walked that back, and Marty Walsh has made it clear that this policy was going to be reconsidered. And in fact, it is open for consideration right now. It is open for briefing and comment at the NLRB. So, and there's predicted to be some changes on the national level, which might in fact impact what goes on in cities like Seattle, or would empower cities to be able to take action. Finally, I'm going to mention the Third Circuit decision in Razak versus Uber. And this is a case that involved Philadelphia rideshare drivers for Uber Black and violation of the Fair Labor Standards Act. And, this is an important jurisdiction in part just because of the states that are covered, Pennsylvania, New Jersey, and Delaware, very populous and an influential ruling. And so this is interesting because this group of rideshare drivers was in a unique position in some ways because they had actually opted out of the mandatory arbitration provision that is now a part of the boilerplate of signing up to be an Uber driver, but they had opted out. And the district court had actually found in favor and awarded summary judgment to Uber on the question of employee status. But on appeal, the Third Circuit said that's not the case. A trial will be necessary. There's important issues of fact here to be resolved. And they looked at the factors from an older case, Donovan versus Dial America Marketing, which talked about the aspects of control, the ability to have a profit or loss, and special skill, how permanent the working relationship was, and whether this was part of the employer's business. So all aspects that we've been talking about and going over today. And the Third Circuit looking at this said that because of algorithmic management, because of the idea that the algorithm certainly can monitor things like how fast the driver is going, where exactly they are, and so forth, that this is actually a particularly powerful form of control. And so again, I think when we're faced with a situation where we have a great deal of unevenness and confusion, I think there are particular questions. I think this is a favorable precedent for those that have been arguing that platform and gig workers are entitled to the rights and benefits of employees. So that's my overview of what's going on within the US on a state and national level, but I'm going to talk just a little bit very quickly about some changes, I think, about how we think about gig work because of the pandemic. And I think some of the remarks of the previous speakers are foreshadowing a bit of what I'm going to say. But for those of you who are interested, this is part of an article that is currently in progress, which is called Essential Workers, the Case for Gig Worker Parity, that is going to appear in the Loyola Los Angeles Law Review later this year. And so just to set the stage for this, I think as we've talked about, what's interesting is that there's an enormous shift to remote work. And in the process, frontline workers were acknowledged for their contributions, but there was a great deal of reliance on gig workers, particularly precarious in their employment status, for delivery of meals, groceries, medications, and other goods. And so this really gives rise to what I call the essential worker paradox. And so I think Caitlin Vega referred to this idea of disposable workers, or workers not workers who are gig workers not getting the respect they deserve. But I do think while gig workers have continued to work on the front lines, this question of employee status, this legal issue, has really held them back. And so I think there's this idea, this acknowledgement that their work, the work they're doing in delivery, and the work that they're continuing to do with grocery shopping and other types of services, while the work is essential, the workers have not been treated as essential. And so this is particularly a problem and an issue for gig workers because with no sick days, they're much more likely to work sick. And so if they're only being paid by the task of the job, I should say, not all employees in the US get paid sick leave. And in fact, only 16 states mandated, and this only applies to employees. So there really is quite a gap here. So in the paper, I really talk about this overlap between essential workers and gig workers, and that it leads to some very confusing outcomes. And again, I think Caitlin Vega's statement that there should be parity for workers of all types and protections for workers of all types comes into play here. So for example, you have the category here on top of essential worker versus non-essential worker during the pandemic. And you could have someone who works for one restaurant and is a delivery driver just for one restaurant, and you could say they have employee status. But you look in quadrant 2, and if they're working for a delivery platform, like let's say Grubhub, then they're kicked into this category of gig work and independent contracting, even though or potentially independent contracting, and they're really doing the same exact type of work. And then we look at quadrant 3, which is non-essential work, and you can see someone who's working for an accounting firm, let's say on a 9-to-5 basis, is given employee status, but someone in quadrant 4 who's working for the platform Upwork would be, again, stuck in this gig work, potentially independent contracting status. So I would point out that 3 and 4 also have a problem because they're doing the same kind of work. But the real injustice here is when we compare quadrant 2, and we look at the Grubhub delivery driver here who's essential and yet not receiving the employee benefits, with quadrant 3, where we see the accountant who's doing non-essential work and at home, who's working at home, and they have employee status. So there's just types of inequality that I think exist. And I'm going to talk a little bit about where this term essential work came from, by the way. So we've mentioned it quite a few times, I think, during this symposium today, and yet I don't know that there's a lot of discussion about where this term actually originated. And I was curious about this in the process of writing about gig workers as essential workers and where did this term come from, because I had not seen it used in any employment law treatise, in any employment law textbook that I've used to teach employment law. I had not seen it in any employment law articles. So where did this really come from? The last real mention of essential workers really came up around the Second World War, and the fact that there was a so-called, ironically called the Manpower Commission, even though it was actually Rosie the Riveter and other women who were being encouraged to enter the labor force. And so there was an idea that we needed to expand the number of workers who would be able to help with important wartime tasks and important tasks to make sure that the economy kept running. And so the adaptation now came up in 2020 when Homeland Security took this kind of idea of what industries are absolutely essential in order to keep them running, in order to keep the country running, in order to keep people safe. And so that's how we get to the definition that we do. And so they use, this is the cybersecurity and infrastructure bill from 2020, and state definitions have picked up on this to include transportation network providers, to include restaurants that are engaging in takeout and delivery services, and some of them actually explicitly talk about gig work and platform companies as being essential workers. So here's my comment about how the pandemic might help to fix the gig economy. I think for the first time, there really was a recognition that gig work was actually very important and not frivolous work, not something that's just being done for convenience. So I think there really was perpetuated in the beginning of the gig economy, in the early 2010s, this idea that, so the founder of TaskRabbit, for example, gives the origin story of the company to say, I wanted to meet my friends at a bar, but I also needed to buy dog food and stores were closing soon. So I just wanted something convenient to be able to help me out here. But I think nowadays there's a recognition that this is not just frivolous work. This is not just something silly. This is very important. And I also think that this idea that it's only a side hustle, I think has been countered. I think that there's been a backstop and a substitution effect, especially during the summer of 2020 when we had, and parts of 2021, where we had over 10% unemployment rates. And finally, I think this idea, we recognize now that the groceries don't pack themselves. And this is not just because we don't necessarily see what goes on. I think people understand now that there are people who are performing these tasks, and it's not just something that the platform is able to do and you get a result. I think people understand that there are real workers behind this. And so, the current crisis, I think, becomes a moment when some employee rights temporarily became available for gig workers. So we've already referred to this: unemployment insurance, paid sick leave being provided. And so the question just is, how far will that go? There's still been some problems with accessing those programs and so forth. But I think that there's a glimmer of hope about these programs, not just being temporary fixes, but extending far longer than the pandemic. So I'll just end here again. This is my most recent book, Work in the Digital Age, and it covers a number of different technologies, as I say, the gig economy, questions of automation and technological unemployment, big data, virtual reality, and how many of these trends are affecting the workplace. So with that said, I'm going to stop sharing and I'm going to stop there. Thank you so much.
Thank you, Miriam. That was great. I'm wondering, I like the essential worker angle and thinking through that. And as you were saying that, it occurred to me, all the great employment law cases, the cases where the court's really going to do something important, they all say there's three interests: the employer, the employee, and society. And it seems like that's one thing we haven't heard as much about today is the social interest. Now, collecting taxes, we've heard it, but I think it sort of thematizes because those workers are essential, not for their own purposes or the employer's purposes, but for all of us, you know. So I really thought that was a great insight.
Well, thank you. And I think third-party interests and the interests of society come up a few places in the employment law course and the curriculum. You know, if you think about the exceptions for public policy for whistleblowers, for violations of the law, the reason why I think that's seen as a carve out or a distinction in US law really has to do with the interests that are protected beyond the private contract of employee and employer, but instead thinking about the larger social context. And so I do think that's definitely an interest here in thinking about some of the really heroic actions that have been taken, and yet you're called an essential worker, and yet what does that get you? It should get you basic employee status, one would think.
Right.
And yet that has not been the case.
Right. Great. Matt, are we set up with some questions?
Well, I have a question. I was thinking, you know, we here in California, we like to imagine the rest of the nation and perhaps the world looking west to see, you know, what we pioneer in these areas. Do you know, but watching your presentation, it was interesting to watch, you know, these other kind of experiments, you know, going on. Do you think states and other nations even possibly are modeling themselves after California or responding to California as much as we like to think? Or is this, you know, is this sometimes a local problem that should have different solutions in different areas?
So I think in part, the start of the gig economy was in California, right? These apps and platforms were pioneered and tested in the Bay Area and in Silicon Valley. And so really, in some sense, everyone really is following because these apps have become nationwide and worldwide and across the world, right? You can find apps of these kinds. And so in that sense, I think that's following from California. The regulatory angle, I think we referred to this before as that part of the gig battles of California where we were talking about O'Connor versus Uber and the Lyft case, Cotter versus Lyft. When we looked at those cases, I think if there'd been a resolution back in 2015 that wasn't a settlement, that actually decided the status, then maybe we could have said, and I was very excited when those cases were coming out and they were set for a trial date, and I actually had a ticket ready to come listen to the arguments, and I was really intrigued to see what the arguments would be there, and then it settled, and that's, I think, the incentives of litigation in some ways really derailed what could have been a definitive answer to this employee status question. Of course, there's many questions beyond status that we could get into. I think that we were foreshadowing, people were talking about how you calculate wages, what some of the other benefits look like. And there's a lot of complicated questions, but until we resolve the status issue, it's hard to get to any of those.
And we also had somebody ask, you know, we've had a lot of presenters kind of highlight some of the, you know, the less obvious issues that workers face when they become independent contractors. But these are very nuanced problems, and we were even asking in other presentations, well, this is something that, you know, voters should be discussing. How do you think that we can, or that people can show or express or highlight the sort of non-intuitive costs that come along with being statused as an independent contractor?
So I think this is getting back to Professor Mootz's comment, Jay's comment about what is the social interest. And so, you know, if you think about some of the costs, when you have, you know, I think we saw that during the pandemic where and we talked about this, there were earlier panelists who talked about this, but the large volume of unemployment filings that were coming about when there hadn't really been payment into the system, and someone has to pick that up, right? And so the taxpayer ends up picking that up. And so I think there are these costs that if there's a subsidy and benefits aren't provided, or there's none of the safety nets that we think of as going along with employee status provided, someone eventually has to come along and take care of that. And then that ends up with a spillover effect. And I think that's been the case with many employers that have been very sparse or bare on benefits. I mean, there's been litigation, you know, over Walmart for years, right, about whether in certain states they actually really need to provide health benefits, because otherwise the taxpayers were having to pick up the tab for that. There was legislation in Massachusetts about that some years ago. So I think it's those same kind of questions.
Thank you.
Yeah, I think the comparative aspect is important. I think the Skidmore case, the Skidmore Respect for Agency Decisions, was an FLSA case where they tried to figure out what to do with on-call time. I mean, on-call time is a tough issue you have to wrangle out. And I think this notion of when is an Uber driver working, we just gotta work through it, so to speak, and maybe we will get some light shed if these cities experiment. Thank you very much, Miriam. That was a great presentation. We've got 3 speakers packaged together here. So we have Miriam just introduced comparative within the US, and we're going to turn outside of our country to Valerio De Stefano, who's going to talk about different approaches in the EU to these problems. He has recently joined Osgoode Hall School of Law as Associate Professor. He previously was BOF Zapp Research Professor of Labor Law. That sounds very cool. At the Institute for Labor Law and on the Faculty of Law at the University of Leuven. He's published extensively on the platform economy, and I mean it very extensively. We're very pleased to have you here with your international expertise, and I turn the floor over to you, Valerio.
Thank you very much, Jay. Professor Moots, it's a pleasure to be here with you and with other many distinguished colleagues that have published extensively on this topic. So of course, Europe, it's big enough and it has many jurisdictions. I am going to concentrate in particular on a recent initiative that was adopted by the European Commission, so basically by the executive body of the European Union, to try and better protect platform workers in the European Union. But before speaking about that more in detail, I want to give you a little bit of a more general framework. So platforms are extremely popular in Europe and have been so for a number of years, and also have prompted, as elsewhere in the world, extensive litigation about the employment status of platform workers. We had litigation in basically almost every member state of the EU, or at least the most developed member states of the EU. And basically this litigation had various forms of outcomes, but recently at least we see that the Supreme Courts of many of the countries of European countries. So I'm speaking about the French Supreme Court, the Spanish Supreme Court, the German, the British, and the Italian, have all recognized that there is something problematic in classifying platform workers as independent contractors. Now, in countries such as France, Spain, Germany, these workers have been reclassified outright as employees. In countries like Italy or the United Kingdom, where an intermediate category of workers between employees and the self-employed, so something similar as a concept to the dependent contractor status in Canada, exists. The Supreme Court have classified these workers as dependent contractors, like as falling into this intermediate category now, which is something that should give us something to reflect about. You still need to extensively litigate even when you have an intermediate category. So one of the arguments of the proponents of intermediate categories is that if you have an intermediate category, it's going to be easy to classify workers in the intermediate category, and then it's basically easier for them to access to employment rights. This has not been the case where the employment category, the intermediate category exists. Platform workers still have to litigate up to the Supreme Court, and the judgments are, of course, subject to revision. You must remember that most European countries are civil law countries, so there is no stare decisis. The courts, even the lower courts, sometimes can reverse the decision of upper courts. So the situation is, of course, I mean, we had this series of judgments that favored platform workers, but of course, this is not enough. And this is where the European Commission has decided to step in and propose a directive of the European Union concerning platform workers. Now, this directive does a number of things. The two most important things are addressing misclassification and addressing algorithmic management. I'm going to speak briefly about both of these two limbs of the directive. But before that, I, of course, don't expect to people in California to be hyped to how the EU works. It can be very Byzantine and very unclear to many of us in Europe as well. So a EU directive is a piece of legislation that is binding, and it's not directly applicable to states. Basically, what happens is that once a directive is approved, member states have a limited period of time, normally it's 2 years, to bring their legislation in line with the directive. So compared to a regulation, which is the most invasive form of regulating from the EU, that has a direct application from day one, the directive has a more gradual and flexible application. That doesn't mean that member states can ignore what the directive says. If they do so, they incur in significant penalties, but it is more flexible. And having said that, this proposal from the Commission that still needs to be negotiated at the legislative level, but with the European Parliament and with the member states, so there is still room for improving or changing this proposal. But basically the gist when it comes to employment status is that first of all, the directive reestablishes a principle that in Europe we call the principle of the primacy of facts. Basically, it restates that the classification and employment status, the classification of workers and employment status needs to be based on substance over form. So the parties are not allowed to change the name of a contract from employment to self-employment if there is no genuine autonomy on the side of the worker. So you basically are not able to name an employee as a self-employed, classify them as a self-employed if they don't have autonomy. The other thing that the directive aims to do is to basically provide for a presumption of employment, so for a presumption of employment status, when a digital labor platform controls work. And in order to determine whether a digital labor platform controls work, basically at least 2 of 5 elements need to be met. So basically to trigger this presumption, 2 of these elements out of 5 needs to be met. And these elements are whether the platform effectively determines the price of the service. So basically, we can imagine a fare for an Uber drive or a fee for a DoorDash delivery. whether the platform requires to perform platform work in compliance with specific binding rules that could, for instance, be you need to wear certain outfits, you need to have certain cars and things like that. Whether the platform supervises work in any way by means of electronic devices and algorithmic management. Whether the platform effectively restricts the freedom of workers to work by, for instance, not allowing them to subcontract their work to other people, or by imposing shifts or working time schedules in any way, and whether the platform effectively restricts the possibility to build a worker on clientele. So we know that some platforms don't allow to have contacts with clients of the platform outside the platform. That would be the case. So basically, if 2 of these 5 elements are met, then a rebuttable presumption of employment is triggered. Now, many of the commentators in Europe have appreciated the idea that the Commission is trying to address misclassification. At the same time, there is some concern that these elements and the way the presumption is supposed to operate is too narrow, and many of these conditions may be easily reverse engineered by the platforms. So the platform could try and go around these 5 elements. Some proposals for amending this for the better for platform workers will be to reduce the number of elements that should be met to trigger the presumption, or to eliminate the presumption that the elements anyway, and to just leave the presumption that every digital labor platform employs people rather than engages them as independent contractor, and then the platform can prove otherwise. There is particular concern, particularly over some of these elements, and maybe we can discuss about that in the discussion later on, that this definition and the way the presumption would operate would be too narrow, and at the end of the day, would be a double-edged sword that would, in some cases, make it even more difficult for platform workers to be reclassified. I think that might be the case, and I have to say that platforms have been particularly silent when it comes to this proposal. Yes, many of them have said that the usual thing about flexibility and they want their business to operate, etc., but we haven't seen the kind of fire that many of us were expecting against this proposal. And in my opinion, because the way the presumption is devised at the moment is a blessing in disguise for the platforms. The other part that is very important in the directive is addressing algorithmic management. So any form of control and supervision that platforms operate over workers through digital means, artificial intelligence, people analytics, and things that respond to the definition of algorithmic management. This is certainly a positive development. One of the idea of the Commission is that there needs to be, first of all, transparency about algorithmic management and how it operates. And transparency means providing information to individual workers, but also to their workers' representatives, so labor unions, which are still particularly strong, particularly in some European countries compared to what happens in the United States. There are also some specific prohibition to collect and process data that regard emotional and psychological states of workers, or their health and safety data, or data connected to their private conversation. So there are also some restriction. Not all algorithmic management will be allowed if this directive passes as it is. There will be some room for imposing a human in command approach. So basically the directive gives the right to workers to context the decision of automated decision making, and to have a human in the loop to review the decision of automated decision making system. So this is also another thing that was particularly appreciated. I have to specify at the moment that the Commission is also proposing a general and broader regulation to govern artificial intelligence in Europe, this regulation also addresses algorithmic management at work, and it's striking how much this directive will be more protective than the general regulation. So if this directive passes as it is and the regulation passes as it is, we will have the paradox that platform workers will be much more protected than the rest of the labor market against algorithmic management. So this is something that also will probably be addressed. One of the problems with this chapter on algorithmic management, and I'm going fast because I am self-conscious of the fact that it's late, is the fact that the directive anyway assumes that algorithmic management and forms of digital monitoring should be legitimate insofar as they are regulated. And here we see a sort of departure from some of the approaches of national member states that traditionally have required more protection in case of technological monitoring. In Italy, in Spain, in France, in Germany, if you want to install a video camera, and not a video camera that points at workers, but just a video camera in a warehouse, you need to have the agreement of the unions or of the labor inspectorate. So it's a much higher kind of protection rather than what is proposed here in the directive for algorithmic management. It might be that some member states will try to raise the level of protection against some forms of algorithmic management at the very least. The final thing that I want to address today, and it's part of the package that was presented by the Commission when they presented the EU directive on platform work, but it's not in the directive, is a separate legislative or regulatory, more precisely, initiative, is an initiative about competition law. This may or may be not known in the United States, but in Europe, there is a very big problem when it comes to the self-employed joining unions and trying to bargain collectively. The Court of Justice of the EU has declared that self-employed people have no right to bargain collectively, and if they do so, they are in breach of antitrust law and competition law. This presents a number of problems. First of all, in many European countries, collective bargaining is a constitutional right that applies to everyone without distinction of employment status. And it's also hardly compatible with ILO conventions on freedom of association and collective bargaining, which all of the member states of the EU have ratified and are binding, that also mandate for collective bargaining to be accessible to every worker, regardless of employment status. So this precedent from the Court of Justice created many problems for people that wanted to organize and bargain collectively, and I can give you just one example out of many. In Denmark, a platform had concluded a collective agreement with with a union that represented domestic workers. So basically workers working in private households. This collective agreement had set minimum protection for people employed by the platforms. And then the platform decided to extend a minimum fee even for the self-employed that were still basically being engaged by the platform. The Danish competition authority stepped in and said the platform cannot fix a minimum fee for platform workers when they are self-employed because they breach competition law. So you'd see how paradoxical that is, that somebody that works in a household with basically and do basic cleaning in household is considered to be an enterprise, an undertaking under European competition law. So the Commission sees the problem. Also, the Commission has exclusive competence about competition law. So competition law is one of the areas in the EU, one of the few areas in the EU that is entirely up to the EU to regulate, that competence is not shared with member states. And the Commission therefore adopted or plans to adopt some guidelines that would allow some self-employed workers to bargain collectively just by saying that these workers, and those are platform workers, workers that work side by side with employees, and dependent self-employed workers, dependent solo self-employed workers that earn at least 50% of their income out of a single principal. They will not be covered by competition law. They will be allowed to bargain collectively. Other self-employed workers that have a form of dependence vis-a-vis their principal are covered by competition law, but the Commission will not go after them, will not intervene to basically find them in breach of competition law. Now, this is of course an improvement from the previous situation, but at the same time, there are some criticism about how this immunity from competition law and this exclusion from competition law is carved out. Devil is in the detail. And again, the fear is that for as much as the Commission is well-intentioned, many of the workers will be still falling through the cracks of these protective standards. And with this, I close my presentation, but I am of course very happy to answer your questions if any.
Thank you very much. That was fascinating. And our situation is similar, where workers cannot organize if they are independent contractors, and that's one of the real sticking points. I have a very general question, and it's an unfair question, but that's okay. The rhetoric in the United States is all about freedom and individuality, and Europe has a very different conception with its much stronger unions, and I'll be romantic, more of a solidarity sort of tradition. Do you see that in this area, or is it pretty much the same arguments that we see in the US?
Well, of course, it's very difficult to give a general answer to that. It is true that the level to which the US worship freedom, and it's something that people in the world understand and admire, it's not the same in Europe, or let me reformulate that. In Europe, we will not see a system where you don't have health insurance if you don't pay for it as a form of freedom. Nobody will think that that will be a good thing. It would be a good thing to pay lower taxes. I mean, nobody, somebody would think about it, but I mean, if a politician were to say, you know what, let's go with the American way of providing health coverage, they would not survive the end of the week. So we see some of the rhetoric of freedom driven by platforms, and platforms say that workers value the freedom that flexibility provides, and employment will strip out of them. At the same time, this argument was stronger some years ago. It is much less sticking at the moment, and I agree with Miriam that the pandemic also changed something in the attitude. Europeans in general think that you can still have protection and not be deprived of all autonomy at work. So employment doesn't always mean that you need to be micromanaged. This is more or less the kind of rhetoric that platforms are trying to drive. It was successful for some time. It is much less successful at the moment. This idea that flexibility of working time should basically be the trade-off against which you lose all your employment and labor rights doesn't fly as well in Europe as it did only a few years ago, I would say.
Yeah, I know some people have proposed in the US not the right to unionize, maybe because of anti-competition, but the right to bargain for things like healthcare, but that's not necessary in Europe. That's just not part of the problem that these workers face, as you point out, because everyone has healthcare as a general rule.
Yeah, and so healthcare in general, I mean, additional healthcare, supplementary healthcare is something that you can have a collective bargaining on. But in most of the countries of Europe, you don't get healthcare from your employer, and it will be unthinkable to advance the idea that it should be your employer to provide you with access to healthcare.
Right. Matt, why don't you go ahead? I think we've got a question, or at least one question up there.
Well, and I wanted to, take advantage of my position and ask, we were just sort of talking about the cultural perspectives that, I think influence the difference between California and U.S. law compared to EU law. Do you think there are other conditions, the system of government, civil versus common law, that help, help explain the differences? I mean, in the end, it seems a lot of what you were focusing on was still control. But what do you think beyond cultural differences drives those changes, those differences?
Well, again, it's difficult to give an answer that is valid for all of Europe. I mean, Europe, sure. If you only look at the EU, it's 27 countries, okay? And that's not all of Europe. And every country has their own legal tradition. In many of the European countries, particularly in the continental Europe, we have rigid constitutions or semi-rigid constitutions that were approved after the Second World War and provide people with social rights, with what we call social rights, including collective bargaining, freedom of association in unions, the right to strike, healthcare, social security. These are all rights that are included in the constitution of many continental European countries. And since these rights exist, it is much easier for lawmakers to pass mandatory protection that you cannot waive out or buy out, that protect workers' rights. I mean, it has implication for all of our societies, but if we only look at employment, there are a number of constitutional rights, and even in the European treaties, there are a number of social rights that cannot be waived by the parties and cannot be even overcome by the lawmakers. So, for instance, something like Proposition 22 would be completely unconstitutional in most of the countries I can think about, and definitely not possible under EU law. So I think that's also a different driver. It's not just about society. Our constitutions tend to be more protective of social rights than the US Constitution, but mainly because they were born in a completely different era.
Makes sense. So yeah, we do have a question from the audience here. What is the estimated timeline for review by the Parliament of the proposed directive? I was impressed that throughout the process that the Commission promised a proposal by the end of 2021 and delivered. So it would be interesting to know if there is an announced timeline for the higher review.
There is an announced timeline, and I think we are still going to see negotiation before the Parliament and Council go for the best part of this year. It might be that these things go a bit longer, but I wouldn't expect so. I think that we are going to see something more definite by the end of the year. Even if it's not final, it's going to be something that is going to be super difficult to then change again.
Thank you.
Well, I don't see any questions. And Valerio, you have been very kind. You are on the East Coast. It is late Friday evening your time, and I know you have some commitments. So if there's no other questions, I will cut you loose a little early, my friend, so that you can attend to those commitments. it's very important for us. We tend to be all have our blinders on, and to have someone represent what's going on in the EU wakes everyone up that there's a whole world out there, and it's not just about California. So it's very important to have had you here, and thank you for your contribution.
It's me that I thank you all very much for having me. If you're interested in all these European developments, of course, there's the scholarship that we have produced in the last few years. And I and my colleague Antonio Aloisi will have a book out in July. The title is going to be Your Boss is an Algorithm. And yes, of course, that's going to be in English. It's a translation of a book we wrote in Italian, but it's completely adapted and updated. So if you're interested in this kind of approaches or topics, yes, and always feel free to reach out to me here in Canada. Thank you so much.
I have called my boss many things, but not an algorithm. So,
Yeah. So did
take
I.
care.
Bye.
All right. We are rolling a little ahead of schedule, but there's nothing wrong with that. This is a tighter woven session. So we've talked about state and national comparative issues. Valerio just brought up, I think, some fascinating points on the EU approaches. We're going to conclude this wonderful symposium by hearing from Winifred Poster, who teaches at Washington University in St. Louis. Her scholarship explores topics in feminist labor theory, digital globalization, and Indian outsourcing. Her focus is on the intersection of post-colonial computing with the political economy of service labor. Sounds like a fabulous way to wrap up. And Winifred, I give you the floor.
Thanks so much. Can you hear me okay?
Yes, perfect.
Yes. Okay, so now I'm going to share my screen. I'm hoping this works okay.
Looking good.
And let's see if I can start this. Okay, how's that?
Looks great.
Okay. Thank you so much to the organizers for an amazing event. What I'd like to do is to talk about transnational dynamics that are underpinning the gig economy. And I'd like to point out how gig work is not only being done like within countries, but actually across them. And that has very important implications for how we think about regulating this work. And I was so glad this morning when Assemblywoman Gonzalez mentioned the issue of fraud arising from different practices of gig work, because actually that is the whole thing I would like to talk about today. I would like to talk about the underside of what happens transnationally on these platforms in the form of very pervasive kinds of deception. So I want to start by illustrating this with an example from my own personal experience about a phone scam. And normally if we were all in person, I would ask everyone to raise their hand if they had ever been received a scam call on the phone. So I'm just going to trust that it's probably pretty common. For me in particular, there was one call that I received in 2010 that was a turning point for what I've been studying. So I was at home and someone called and said that he was from the Federal Communications Commission, the FCC. He asked if I was getting a lot of telemarketing calls and if I was on a federal do not call list. So both of which I said yes. And then he said he could solve the problem for me, that I should wait for a call from some other person who would then give me an automated security code. And then he was going to call me back, get it from me and put it into a system. So, you know, I've received odd calls before, but this one was unique to me for many reasons, and not even for the obvious reasons, which include how complicated this process was that was supposed to help me, and why the FCC would be making personal calls to customers, and why their scam was actually based on preventing scams. But rather for me, what was curious is that my career has actually been doing ethnographic research inside Indian call centers. And I knew for a fact that this call was, coming from such a place. But most importantly, that this did not fit the profile of the call centers that I had been studying. It indicated to me that something was changing about global outsourcing. What used to be an industry mostly based on telemarketing and debt collections for legitimate companies was now shifting to impersonators working for fake organizations with the purpose of scams. So what I want to argue is that this is not an isolated event, but instead quite widespread and indicative of several historical changes in the in global labor. And if it's okay with you, I'm going to take you into a little trip into my ethnographic research. I'm a sociologist, to show that there are many parallels in the outsourcing industry and the gig economy. And in fact, the latter has emerged from the former, that both are highly predicated on transnational labor dynamics, especially when it comes to digital labor or labor that happens through information and communication technologies, that both are facing existential problems having to do with fakes, frauds, and scams, which is a topic of a special issue that I'm editing right now and should be out later this year. And then also why regulation of the gig economy should pay attention to these dynamics. So let me start with outsourcing. What we call outsourcing involves moving work over national borders, largely through ICTs. So instead of having a multinational firm that has to actually travel itself and set up its own subsidiaries, you can now pass work off to a third-party local firm and send it over the internet. And India started doing this around the year 2000, which was ushered in by actors in the US, both state and private sector organizations, which invested in huge infrastructures for fast communication between India and the US in form of fiber optic cables and satellites and such. India became quickly a popular destination for outsourcing, in part because it had a massive labor force of young, educated, English-speaking and cheap workers. The Indian state also obliged in this process with successive stages of legal exemptions for this industry, some about women working at night, and later on other exemptions for data privacy rules, which is now not letting me advance my slide. Let's see if this will work. There we go. And so soon, most of the Fortune 500 companies in the US had outsourced some work to industry. To this industry, it hired over 2 million workers, and this lasted for about a decade. So what changed? Well, other countries got in the game, and by 2011, the Philippines overtook India in number of call centers and employees. And now if you look at the list, India is so way down the list of new jobs, and so many Latin American countries are at the top. And this was also complemented with rising unemployment in India, which hit a 20-year high just a few years ago. So it left a lot of people out of work. So why did the industry turn to scams? Now, there's, of course, a lot of reasons for this that criminologists probably would have to give their input on. But I want to talk about one factor that's really hard to ignore, which is that the US business sector actually showed them how to do it. So the Indian outsourcing industry had been recipients of a decade's worth of training in how to carry out overseas digital communication, including supplying the technologies for carrying out overseas voice work, and then sending their own personnel and business consultants to give personal instruction on the minutia of outsourcing voice work, which I witnessed firsthand. When I was in the call centers, I would see these people coming. And crucially, they provided training in how to produce fakeness on the phone. So what they had been doing is teaching managers on how to teach workers to act American. And this was so that they could appease, angry American customers about communication and about outsourcing in general. And I have called this process national identity management. And so if we go back to that experience I had with my own scammer, what I was experiencing in that moment is that he was using all of these same tactics on me in that call. He said his name was Clive. He used conversational skills to show familiarity with my environment. He said he knew about where I lived in the cities around me because he said, we've been getting unusual amounts of telemarketing in your area. And so he started listing off the counties next to me. He had a script for how to respond when that cover fails, because I knew this wasn't real. So I started asking him questions like, where are you calling from? Where do you work at the FCC? What's your job? All this kind of stuff. And he had answers for everything, whether they were improvised or scripted. What was new in this situation that I was so surprised about is that now he had, as part of this act, he had an affiliation with the US government. So here, this is a list of all kinds of scams that have been reported by, Indian call centers. Not only are they saying they're from the FCC, but they're saying that they're from FBI, the IRS, the Social Security Administration, Customs, you name it. So the irony here is that the US outsourcing industry has indirectly set up the conditions for its own replication and even undermining. So you could get this scam call center sector. And the icing on the cake is that these new workers are actually posing as US state officials, and sometimes even like Microsoft, private sector officials. So what was the result? I mean, they were good at it, right? So this scam industry prospered. Fake call centers started to appear in many regions of India, clustered in the big cities. In New Delhi alone, there were estimates of 10,000 fake call centers by 2013. And in one case, the scammers were making more than 2.7 million calls, at least to 600,000 different calls, phone numbers nationwide, and they collected more than $5.2 million from consumers in 2 years. They're also good at hiding in plain sight. So they were often located in large-scale facilities, sometimes with 700 workers. And they looked just like regular call centers. Like these were not like back alley operations or something. And in fact, some of these call centers operated within legitimate call centers. So the day workers would come and they would work in the legitimate call center, and then at night, the scammers would come and do the scam work. And critically, what happened is that the scam was even hidden to workers themselves. Some of them didn't realize when they applied for the job that they were going to be doing illegal work, even after they joined and were doing it for some time. This is an important point because this kind of deception in hiring is something that arises also in platform economies. So now let me turn to platforms and show you how this happens. So in my view, platforms are the next stage of global labor after outsourcing. So instead of sending a whole set of tasks to an outsourcing location in a specific country, now firms and even individuals are turning to platforms for employment and gig work. These are the new middlemen, intermediaries for global, information production and services. And what you see is that as the outsourcing industry was starting to have trouble around the 2010s, the platform industry was really taking off. So now what I want to show you now is that these gig economy platforms have taken many of the features of outsourcing and even amplified them. They've spread them, and sometimes they've made them harder to see. So just to talk about, to see the reach of platforms, I'd like to recommend an excellent report by scholars at the ILO that was published in 2018. And they studied the spread of web-based work, which is opposed to location-based work, which might be more like delivery or ride hailing and things like that. And when they focused on just 5 platforms, they found 3,500 workers in 75 countries. So this dark blue countries there are the ones that were part of their study. A good deal of these workers that they found were not making minimum wage for the countries they were in. And, as expected, there were even differences in earnings if you were in the global South versus the global North. But what really struck me in reading this report is the endemic subcurrents of fakes, frauds, and scams in this work and how they mirror what happens in outsourcing. So let me give you 3 examples of things that I was seeing. One is the production of the basic work of manufacturing fake content online. And nearly half the jobs that were studied in this report were from micro work companies. So like little tiny tasks on the computer, a single task that might take a few minutes. Click work, it's often called. Now, a good portion of that work involves creating false promotions for goods, services, and even individuals. So a typical task would be searching for a product and typing it into Google, or visiting a company website, things that would generate fake traffic for someone who wanted that. Alternatively, some of the tasks would involve liking a product, or downloading and installing an app, or retweeting something on Twitter, which is the image here, things that would improve the ratings of companies or people online. And workers in the study, they talk about how they were evaluating destinations that they had never traveled to and writing positive reviews about apps that they actually don't like. So, this fundamental job of creating fakeness. And I want to talk about a little more disturbing example of this, which is in, creating false social media content on political terms. So an example here are troll farms and factories. And these are organizations that produce fake content on social media for political purposes. Now, one might think that this is, maybe a small scale thing, but a report by the Computational Propaganda Project at Oxford showed how international this industry is. Their report about these troll farms spanned 81 countries. Again, it's the darker colored countries on this map. And since 2009, it has accrued $60 million that's being paid for this work. Not only that, but it often operates across countries as well, within regions. So neighboring countries will be doing troll work for another country. Some of these, work sites are set up directly by state governments, but most of the time they are organized by private sector firms and individuals who want to support particular candidates or officials. Either way, the work ends up being remarkably similar to click work above, with activities in creating a fake account, posting material that is false, etc. What's also similar are the labor conditions, where workers are sometimes compensated in small change for each post, which is how China's 50-cent army got its name. That workforce is estimated at close to 500 million workers. So The second thing that I like to talk about as a problem with platform are fake ads and fraudulent jobs. Platforms are, if you talk to anyone who's applied for a job on a platform, fake ads are a really big problem, very pervasive. Sometimes there will literally be no job behind an ad. And so scammers will post an ad just for short-term financial gain, like, to get, to pocket money for fake things like applications or background checks. Other ads do have real jobs behind them, but not the ones that are stated. So workers are duped into a secondary job that wasn't originally part of the bargain. And quite often that second job is, overtly illegal. So I just want to show one kind of example of this back with the troll farms. This was an ad for a troll farm in Russia, and it was, posted on an employment website. And, what they say in Russian on some of these ads is, what a great working environment it is, and what a great experience you're going to have. Nothing about the content of what you actually be doing and who you're doing it for. Other times, the industries behind the posts are explicitly scams. So, and one of those scams that's kind of common is shipping fraud. So in this case, workers are asked to send packages for which they have no idea what's inside and why they're doing it. And one of the reasons that this happens is with a scam called brushing. And brushing starts with policies on e-commerce sites like Amazon and Alibaba in China. They have policies which invite scams by sellers. So one of these policies is that to get your item on the top of the viewing list for customers, you have to have a lot of positive customer reviews. And the second thing is that those customers have to be verified by receiving a package from the platform to their address. Evidently, it's not hard at all to fake your way into both of those things. So how do you do that? First, you go to the dark web and you access, sometimes for free, sometimes you can buy it, leaked databases of addresses. And then you create an account for those people. And then the second thing you do is you hire gig workers to send the packages full of fake and often random things so that they can be verified. And then you can, log in and create the positive reviews. So what we're getting is cases of fake packages that are being sent from places like Kazakhstan and China to people in the US and UK, partly because that's where the biggest breaches of personal data have occurred. What happens then is that gig workers become unwitting go-betweens for these globally orchestrated and platform-based fraudulent industries. And so this underscores both the transnational dynamics of these industries and how commerce platforms incentivize this behavior. One final point, which is about reselling gig work. So this helps us come full circle in showing how platforms are replacing outsourcing and their troubling practices for workers. So with reselling gig work, it's also called sometimes service arbitrage or drop servicing. And it involves a case where an individual can become their own outsourcer through the use of gig platforms. And so there's one story came out in The Verge about a woman who has a big presence on TikTok. And she spends a lot of her time getting contracts for video editing and branding, which she used to do herself. And she's in Singapore, but then she goes on Fiverr, which is an employment platform run out of Israel. And on that platform, she hires workers from India, Pakistan, the Philippines, and Croatia at a fraction of the cost to do the work herself. And so in this way, she is reselling gig work to make a profit as that middle person. And ads for this whole process on TikTok say things like how you can make money doing virtually nothing, basically. Platforms in this way are then facilitating, exploitation of the lowest paid global workforces. And they're enabling individuals to do practices that outsourcing firms have been doing for a while, but in a much simpler way. So my point overall is that the gig economy has inherited many of the same problems of outsourcing, especially in targeting vulnerable workforces internationally and enabling deceptive practices. When we talk about scams, often in the legal system, those are considered crimes against consumers. But I argue that scams need to be treated as crimes against labor as well. We obviously need regulation that protects workers better from jobs that are, masking illegal practices, for people to know what jobs they're signing up for in the beginning, to know whose interests they're serving. In addition, the regulation of the gig economy should take into account, in general, the transnational patterns by which labor is being recruited and how the work itself crosses borders and may escape attention of nationally based policy regimes. And finally, that regulation of the gig economy should incorporate data protections as well, given the amount of data that's collected about workers on platforms and how it governs their experiences. Thank you very much. I will stop sharing now.
Thank you very much. That was informative. And I have to ask a personal favor. I may have another story for your
yeah.
And that is wage theft through this device. My son agreed to edit translation or edit documents written by non-English speaking people, not primarily English speaking people. And he was promised all this money and he called me for help because they delayed. He got about $600. They owe him 1,000 more. And of course they never pay. They string along as they can. And wage theft, when this was outsourced or a platform coming out of India, I mean, what do you do? Suddenly he was just sort of left high and dry. And is wage theft a big part of this, in addition to the fraudulent schemes, but just actually securing work of value and then just saying, well, we're a platform based out of India, so there's not much you can do about it for $1,000.
Yeah, true. That has been raised in so many dimensions, not getting paid, and then also that there's no grievance procedure where you can even try to, redress this. It's on the list in the back of that report from ILO that I showed. They have a long list of, rights that really should be protected for gig workers, especially on those micro work platforms and platforms where you actually do the work on the platform itself. So yes, absolutely. That's definitely number one issue.
This was a great contribution because I didn't even connect that in my mind. I'm putting together this symposium and I'm counseling my son, and I just missed the whole point that this is part of a larger structural issue. So thank you very much. Anyone want to pose any questions or any comments?
Well, I think, listening, I was sort of wondering, is this sort of platform, economy more exploitable, than others? Is it, inherently exploitable? Are these just kinks that need to be worked out over time that, as we use it more and more, we'll be able to regulate? Or are these problems, inherently brought up by this format?
Yeah, well, I think that the whole premise of this workshop today is partially about that. Like we really are in this in-between stage of, these platforms blew up and everyone's, jumping on, and now we're seeing how weak they are. in protecting workers. And a big thing from my perspective is a lot of these platforms are based in the U.S. and that has come out in Valerio's talk. I missed the previous ones, but I'm sure they addressed this too, that US regulations over platforms are so weak. Like there's just like almost no attention to them. And certainly rights of workers are not being addressed. So when our same platforms operate in Europe, then they have to behave differently. But I think that since their home base is here, this is where the attention has to be focused. So I mean, I'm an optimist. I do believe that all these things are addressable. It's just, we got to get on board.
That's great. A last call for questions. We're at the end of a day. That was a great way to finish. Any questions in general that people might have about the symposium or anything else? I think we really had quite a rounded conversation, covered a lot of ground. Well, let me thank you. Yeah, I think you go by Winnie, correct?
Yeah.
Thank you, Winnie, for really turning everyone's heads around. I think you certainly did for me. That was great. I want to thank all the people who presented today. Very interesting angles taken by everyone. And I also want to say that the stellar panelists and their expertise will be in our law review publication, which we hope will be coming out relatively soon, though print takes longer. In the meantime, I think Cassandra might reach out to folks and try to distribute maybe some bibliographies for some of the panelists, for people who want to do more reading or dig into some of these specific topics, which I think would be of great advantage. So I will, now we have spared no expense for this symposium. We have the best virtual wine that California has to offer. Unfortunately, I think this worked great, but the one thing I do miss is the informal gathering after the event and chatting with speakers. But I hope all of you raise a glass and relax and congratulate yourself for the great job as presenters. And thank you very much to all the people who stuck with us. We never went below 100 people in attendance. Thanks for your participation. And I will sign off. Any final words, Matt?
Nope, just to answer somebody's question who I accidentally said I would answer live. We will be posting this on YouTube at a later date.
Okay, so you can watch it over and over again. There's no limit to the amount of times you can watch it. Thanks again to the great team who put this together, Chris, Cassandra, Ashley, Matt, and all the law review people. I really appreciate it. And we'll see you, we'll see you in an Uber soon, I guess, is the only way to close this. So everyone take care and thank you for participating.